Madam, mentioning list under preliminary hearings. Random. Sir.
Red sitting, sir. Madam, red side. Esther, ಎಲ್ಲರೂ ಏನು ಬಂದು ಮೂವ್ ಮಾಡ್ಬೋದಾ ಟೈಮ್ಗೆ?
ನಮಸ್ಕಾರ ಸರ್. CGIT WP ಡಿವಿಷನ್ ಬೆಂಚ್ ಅದು ಏನಾದ್ರು ಒಂದೇ ಯಾವ ಥರ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದೀರೋ WP CGIT ತಮ್ಮ ಮುಂದೆನೇ ಬರುತ್ತೆ
ಮೇಡಮ್
CGIT ಸೆಂಟ್ರಲ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರೈಬ್ಯುನಲ್. CIT ಅಲ್ಲ CGIT. ನೆಕ್ಸ್ಟ್ ವೀಕಾ ಡೇಟ್ ಕೊಟ್ಬಿಡ್ಲ, ಸುಮ್ಮನೆ ಕೊಟ್ಬಿಡ್ಲ, ನೀವು ಹಾಕೊತೀರ ಯಾವ್ದಾದ್ರು. ಆಮೇಲೆ ನೋಡಿ ನಿಮ್ಮಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಹೋಗುತ್ತೆ. ಹೊಸದಲ್ಲ ಸರ್, ಹಳೇದು, ಹಳೆ ಮ್ಯಾಟ್ರ್, ಓಲ್ಡ್ ಮ್ಯಾಟ್ರ್. ಹೌದು, ಪೆಂಡಿಂಗ್ ಸರ್ 100%. ಪೆಂಡಿಂಗ್ ಮೇಲೆ ಹಾಕ್ಬೇಕು. ಸಾರಿ ಸರ್, ಇದು ನೋಡಿ ಸುಮ್ಮನೆ ನೀವೇನೋ ನೀವೇನೋ ದಯಪಾಲಿಸಿದಿರಿ ಅವತ್ತು ನಮಗೆ. ಹೇಳಿ ಸರ್. ಹಾ, ನಾನು ಹೋಗಿ ಕೊಡ್ತೇನೆ, ಅಲ್ಲಿಗೂ ಕೊಡ್ತೀನಿ. ನಾವು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದೀನಿ, ನಾನು ನಿಮ್ಗೆ ಸುಮ್ಮನೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಏನೋ ನಮ್ಮ ಒಂದು ಆಗ್ಬಿಟ್ರೆ ಸಾಕು. ಹಾಂ, ಎಸ್ ಸರ್, ಎಸ್ ಸರ್, ಎಸ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಅದು IFR earlier ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಸೀನಿಯರ್ ನಾಳೆ ನಾಡಿದ್ದು ಅಟ್ಲೀಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಆಯ್ತು. ಮಂಡೇ ಬರುತ್ತಲ್ವಾ?
ಸೊ ಪ್ರಸಾದ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ಮಾತಾಡ್ತೇನೆ ಈಗ ಹೋಗ್ಬಿಟ್ಟು. ಥ್ಯಾಂಕ್ ಯು. ಈ ಸಾಹೇಬರು ಮತ್ತು ಹುದ್ದಾರ್ ಸಾಹೇಬರು RDH ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. RDH ಇರಬೇಕು. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಫಾರ್ ಪೋಸ್ಟ್.
End of the list, sir, please. Amicable solution ಆಯ್ತು ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್. ಮೆನ್ಷನಿಂಗ್ ಇಲ್ಲ. ಡೇಟ್ ಸರ್. ಥ್ಯಾಂಕ್ ಯು.
$11:13.
ಮೇಡಮ್ ಮೆಮ್ಮತ್ತಾಳೆ
ಒಂದು ಡೇಟ್ ಕೊಟ್ಟು
ಏನು ಡಿಲೇ ಇದೆ? ಓ 11:30ಗೆ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಮೆನ್ಷನ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ? ಅಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ನಿಮ್ಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಲ್ಲ? ನಾಳೆ ಅಲ್ಲ, ನಂಗೆ ನಾಳೆ ಈ ವೀಕಲ್ಲಿ ಬೇಕಾಗಿದ್ದು. ಹೌದಾ? ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ? ಹೌದಾ? ಇಲ್ಲ, ಡೆಫಿನೆಟಿವ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 30 minute ಹಿಯರಿಂಗ್ ಬೇಕು. ಸೊ ಆಫ್ಟರ್ನೂನ್ ಸೆಷನ್ ಅಲ್ಲಿ ಆಗ್ಬೇಕು. ಇಲ್ಲ ಬೆಳಿಗ್ಗೆ ಮಾರ್ನಿಂಗ್. ಓಕೆ ಸರಿ ಬಿಡಿ, 11:30ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿಬಿಟ್ಟು ದೆನ್ ಐ ಡಿಸೈಡ್. ನೀವು 4:11 ಕನ್ಫರ್ಮ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅಂದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದೆ ನಾನು. 4:11ಗೆ ಕನ್ಫರ್ಮ್ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಕೊಡ್ತಿದ್ದೆ ನಾನು. ನೀವು ಬರ್ದು ಕಳಿಸ್ತೀರಾ? ಬಟ್ ಅದು ಅಲ್ಲ ಅಂದ್ರೆ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಆದ್ರಿಂದ ಓ, ನೀವು ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ಗೆ ಹೇಳಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? 4:11 ಬೇಕಿದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ.
Video off ಆಗೈತಾ?
ಕೋರ್ಟಲ್ಲೇ ಇದಿಲ್ಲ. ಯಾವ ಕೋರ್ಟಲ್ಲಂತ?
Court officer? Court officer? Court officer ಕೇಳಿಸ್ತಾ ಇದೆನಾ?
Lordship's kind. One matter relates to suspension. Tribunal has not considered the interim prayer. May I request for tomorrow?
Just decide.
Lord, the order of suspension is passed on 18th of October, Lord.
Yeah.
Please, I'm grateful.
Lordship's kind permission, my lord.
Ah.
One matter, I'm challenging the NCLT order, my lord, for post facto of approval of the liquidator. The matter is listed today. I have actually moved this matter twice last week, my lord. Date was given for today. It is not posted, my lord. Before the trial court, the matter is today. I'll request at least tomorrow it may be taken. I'll request the trial court to give me time, my lord.
That's a matter for.
Date fix ಆದ್ಮೇಲೆ ಬರ್ಬೇಕು. Otherwise the lawyer, it becomes difficult for the lawyers to face their clients.
Already they're
Date
imposing
ಹೇಳಿರ್ತಾರೆ.
cost, my lord.
ನಾವು ಕೊಟ್ಟಿವಿ ಅಂತ.
They're imposing cost actually for adjournment.
Okay.
I'm sorry, my lord. I'm sorry.
That's my request for a matter for day after tomorrow, it's an arbitration where it's the lease in question and the lessee running the school. It's termination, lease is terminated. The Leonard arbitrator has passed an order stating that I need to put up a board saying that the property is under dispute with respect to the lease. And I should make the parents sign a register that it is under litigation. It's beyond the
Next
scope
week.
of the.
Next week.
My request for day after tomorrow because they're trying to execute the order.
Next.
I'm grateful.
My form 53 is pending, my lord, initiated the criminal proceeding and discussing.
RFA.
Direct petition,
ಏನ್ ಯಾವ year?
2020.
Huh?
2024.
24th. Bharat, here, after 2 weeks.
Your Lordship, assigning the order of NCLT, Your Lordship.
Huh.
This matter permission, can I make a mention?
Yes.
But an appeal was filed before the NCLAT against the order of the NCLT admitting the petition against the operational creditor. The appeal was filed by the suspended director, the sole suspended director. He resigned. Now we filed an application to impeach the promoter who has 49% share. Now the NCLT, number one, does not consider the application. Second one comes to the very strange conclusion that the company has become non-existent. The appeal is dismissed only on the ground that the suspended director has resigned. Therefore, the company has become non-existent. The application per se.
Next week ಹಾಕೋಬೋದಾ?
End of the list, Your
Madam,
Lordship. End of the
problem is
list.
there are certain interim orders granted, now automatically they become vacant, at least tomorrow, madam.
Tomorrow. Day after, Bharat. Basuraj. Day after tomorrow.
Kind permission.
Proceedings under the Land Grabbing Act, my lord. There are two reports by the Tahsildar that there is no encroachment. Yet the special court is proceeding against me. The matter is coming up on 30th, my lord. My
30th.
request- 30th, day after tomorrow. My request for tomorrow.
Connected matter.
ಇಲ್ಲ, ಒಂದೇ ಇರೋದು.
30th ಯಾವ್ದು ಬರ್ತಾ ಇದೆ?
It's coming up before the special court.
ಅಲ್ಲಿ.
ಅಲ್ಲಿ.
ಏನಿದೆ ಇಂತ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ಬ್ರದರ್? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ. ಎಂತ
At least
urgency
on-
ಇಲ್ಲ.
at-
ಅಲ್ಲೆಲ್ಲ ಏನಾಗ್ತದೆ?
30th.
ಒಂದು ಪ್ರೋಸೆಸ್ ಆಗ್ತದೆ, ಎಲ್ಲ ಬರ್ತದೆ. ನೆಕ್ಸ್ಟ್.
May I make one submission, my lord?
I appear for the
Ah.
serial number 38, my lord. I appear for the appellant. Request for a short term.
ಪೇಜ್ ವರ್ಕ್.
Page number 6.
Page number 5, number 19 to 24. 25 to 38.
See, my lord, serial number 26, my lord.
26.
Please, my lord, I am
Yeah,
for the
here.
respondent. It's of 21, my lord.
21.
I am for respondent, my lord. Inform the petitioner counsel, my lord. Senior is not feeling well, my lord. Can leave weeks accommodate.
We post after 2 weeks on request of. Okay.
31 to 35.
32, my lords.
32.
Serial, I'm for the respondent 2 to 4, my lords.
Huh.
I request for 2 weeks' time, my lords. We want to file objections in this matter. I've informed the counsel for the petitioners.
From the other side,
Please, my lords, so they're here before the court.
2 weeks.
Grateful, my
At the
lords.
request of.
Serial number
Shetty.
35, Your Lordship.
Jaikar Shetty na? Jaikar Shetty.
No,
You are for?
I'm for respondent 2 to 4, my lords.
At the
2 to 4.
request of counsel for or 2 to or 4.
Serial number 35, my lords.
35.
Please, my lords. I
Ah.
am for respondent number 4, my lords.
Ah.
Praise for 2 weeks' time, my lords.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ವಾ?
My lords, we need to file some of the documents.
All right, 2 weeks at the request of Madam.
Great.
My lord, serial number 36
36.
is a partition matter. My
Ah.
client is here. We are offering 50 lakhs to the respondent.
Ah.
Parents.
Ah.
So kindly grant some time because my learned friend is also there.
I am for the response in this matter, my lord. I get instruction.
2014 matter ನಾವು ಓದ್ಕೊಂಬಂದ್ಬಿಟ್ಟಿವಿ.
ಒಂದ್ಸರಿ ಹೋಗಿತ್ತು ಆಗ್ಲಿಲ್ಲ ಈಗ 50 lakhs ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನಿಜನಾ?
Get instruction, my lord. ಗೊತ್ತಿಲ್ಲ. Get instruction. Kindly have it on next week, any date.
Next week ಆಗಲ್ಲ matter. 2 weeks ಹಾಕೊಳ್ಳಿ. Week after next.
Date,
At the request of counsel for
date may be fixed.
ಒಂದು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 2014 ಮ್ಯಾಟರ್. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ನಡೆಸಬೇಕು. ಹಂಗೆ ಉಳ್ಕೋತ ಇಲ್ಲ ಅಂದ್ರೆ.
Much.
Yes. 38.
I appear for the appellant.
Yes, brother, in.
I request for a 1 week time. I have informed to the other side also.
All right. 2 weeks at the request of Venkatramana.
Sorry, my lord.
Hey.
I make mention in serial number 27, my lord.
22nd.
I have received objection now.
27.
27. I have received objection now.
ಹಾ.
May I request weeks accommodation?
ಹಾಲ್.
My lord, one more writ petition they have filed on this,
ಇದರ ಮೇಲೆ
91, 92 of 22.
call this matter week after next along with WP number. So ಬರ್ಕೊಡಿ.
Yes, ಬರ್ಕೊಡಿ.
Okay. ಅವ್ರಿಗೆ ಇವರಿಗೆ ಯಾರು ನಿಮ್ಮ ಅಪೋನೆಂಟ್ಗೆ ನಾಗೇಂದ್ರ ನಾಯ್ಕ ಹೇಳ್ಬೇಕು.
Yes, yes, my lord, I am appearing.
God for-
I am appearing for Nagendra Naik.
ಹಾ. ಕೂಡಮ್ಮ ಕೂತ್ಕೋ.
For 1 week time.
ನಾನ್ ಕಂಪ್ಲೈಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆನ್ IA ಏನದು?
IML objection.
ಡಿಸೀಸ್ಡ್ ಅಪಲೆಂಟ್
Appellant death ಆಗಿದ್ದಾರೆ.
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದೀವಿ ಸರ್.
ಹಾ, ಏನ್ ಮಿಸ್ಟೇಕ್ ಇದೆ? ಎಂತದ್ರಿ ಏನ್?
ಅಲ್ಲ IA ಫೈಲ್ ಮಾಡಿದೀವಿ ಸರ್.
ಅದು ವಕಾಲತ್ ಬೇಕಂತಲ್ಲ, ವಕಾಲತ್ ಹಾಕಿ.
ಅಲ್ಲ.
ಡಿಸೀಸ್ಡ್ ಅಪಲೆಂಟ್ ವಕಾಲತ್ ಬೇಕಾಗತ್ತೆ.
Yes.
My lord, the application also might be allowed, my lord. We are ready for the final arguments also, if it can be had next week. I am the plaintiff decree holder. My suit, execution proceedings of 2015 have been stayed.
ಸೋಲ್ ಅಪಲೆಂಟ್ ಅನು ರೂಪಾ?
Yes, sole appellate.
ಸೋಲ್ ಅಪಲೆಂಟ್. ಒಬ್ಬನೇ.
One of 24 has been filed by the appellant to bring the LRs of the sole appellant, who are shown as appellant number 1A to 1C. Having heard we are talking for the respondent, come at the application is allowed. And LRs of the appellant are according to the protocol of the law. Counsel for the appellant is permitted to file wakalat for the proposed appellants within a week.
Yes.
It can be had next week, my lord. A date may be. Next week and one dates.
Week after next, but week after next. Yes. Yes, Prakash. ಏನಿದೆ?
There is some letter is not,
Letter.
I don't know who has written this.
ಸೇಮ್ RS ಏನು ಇದೆಯೇನೋ ಇದಕ್ಕೆ ಸಂಬಂಧ?
No, that was withdrawn.
ಬಿಟ್ರಾಗಿದೆ. ನಿಮ್ದ? ಅಡ್ವೊಕೇಟ್ ಏನೋ ಲೆಟರ್ ಬರ್ದಾರೆ. ಅವ್ರು ಓನ್ಲಿ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕಲ್ ಪರ್ಪಸ್ ಹಾಕಿದಾರೆ ಇದನ್ನ ಅಪೀಲು ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಾವು ಅದಕ್ಕೆ ಬೇಕಾದ್ರೆ ಹೆಂಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಒಂದ್ಸರಿ ನೋಡ್ರಿ ನೀವು ಲೆಟರ್ ನೋಡ್ತೀರಾ?
ಏನ್
ನಾಟ್ನೆಸ್ ಅಲ್ಲ ಬೇರೆ ಏನು ಯಾರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇಲ್ಲ. ಅವ್ರು ಓನ್ಲಿ ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ ನೀವು ಅಪೋನೆಂಟ್ ಕಲ್ಟಿವೇಶನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ ಅಂತ ಅಪೀಲ್ ಡಿಸೈಡ್ ಮಾಡಿಬಿಟ್ರೆ ಆಯ್ತು.
I have no objection. Matter lies on narrow compass. My lord, all the issues are held in my favor. But I have denied share on the ground.
Yeah.
But second appeal is pending.
ನಿಮ್ಮ ಅಪೋನೆಂಟ್ ಯಾರು? ಅವರೇ ಲೆಟರ್ ಕಳಿಸ್ಯಾರ ಏನಿದು?
No, Judge,
ಅವರೇ ವಿಶ್ವೇಶ್ವರ.
respondent number one is the only contesting respondent. Others are sailing with the appellant.
ಬಟ್ ಸಾಮಾನ್ಯವಾಗಿ ಲಾಯರ್ಸ್ ಹಿಂಗೆಲ್ಲ ಲೆಟರ್ ಬರೀಬಾರ್ದು. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಇದು. ಬೇಕು ಅಂದ್ರೆ ಅಪಿಯರ್ ಆಗ್ಬೋದು, ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು. ಹಿಂಗ ಲೆಟರ್ ಬರೆದು ರಿಜಿಸ್ಟ್ರಾರಿಗೆ ಬರೆದು ಅದನ್ನ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರ ರಿಜಿಸ್ಟ್ರಾರ್ ಏನ್ ಮಾಡ್ಬೇಕು?
It can be.
ಏನ ಅಬ್ಜೆಕ್ಷನಬಲ್ ಏನ್ ಬರ್ದಿಲ್ಲ ಅವರು.
May I make one submission? A paper book may be dispensed with.
ಅವಶ್ಯಕತೆ ಇಲ್ವಾ?
In only question of law. There no facts are not in dispute.
ಪೇಪರ್ ಬುಕ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ
Yes.
ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಆ
ಆಗ್ಬೋದು.
ಲೆಟರ್ ನ ಪಾರ್ಟಿ ಕಳಿಸ್ಕೊಂಡು ಇವ್ರು ಲಾಯರ್ಗೆ ಮತ್ತು ಪಾರ್ಟಿಗೆ ಸೊ ದಟ್ ದೇ ವಿಲ್ ನೋ ಇಫ್ ದೇ ವಾಂಟ್ ಟು ಎಂಗೇಜ್ ಸಮ್ ಲಾಯರ್ ಲೆಟ್ ದೆಮ್ ಬರ್ಬೇಕು.
RB Deshpande is in filed power. No advocate is.
ಇಬ್ರು ಇದ್ದಾರೆ.
Yeah.
Since the matter lies in a narrow compass as argued by counsel appearing for the appellant and there being no denial of the same, comma, we are of the considered view that the filing of paper books be dispensed with and accordingly it is. First off, in terms of letter dated 13/3/2024 addressed by Shri H.P. Vishweshwara, an advocate from Bhadravati, appearing for the, your respondent? Appearing for the respondent, comma. This matter be called on, ಯಾವ date ಹೇಳಿ?
Not any, second week of November, any date.
Another one date ಹೇಳಿ?
14th, my lord, 14th.
14/11/2024. First off, registry to send a copy of this order to the respondent
First respondent.
number one for information.
Right.
Next,
Appearing for the complainant.
by speed post immediately. No.
In this matter, Lord's
Yes,
contempt
sir.
was disposed of seeking reserving liberty because a revision petition was pending when the contempt was filed.
Ah.
Revision petition is disposed of confirming the order of the writ petitioner, Lords. That is against the respondent BDA.
Ah.
Lords, second set of the copies required to be furnished.
ಕೊಡ್ಬೇಕು.
Lordships, I have a copy.
ಇದೆಯೇನು?
I have a copy.
ಇದೆಯಾ?
Lordships, but permit me
Ah.
along with order copies.
ಏನಾಗಿದೆ ಇದ್ರಲ್ಲಿ?
Lords, this is a matter where complainant is an auction purchaser of site number one.
My lords, one submission. Lords, the review petition is dismissed. As on today, the order of.
Review no revision?
Review.
Review petition.
I filed a writ appeal. Liberty was granted to
Baba.
file a review. Review was dismissed. Now it appears that my lords, BD has sent the papers to the Supreme Court to prepare an appeal. Grants me 3 weeks' time.
2 weeks ಕೊಡೋಣಂತ ಅಷ್ಟ್ರಲ್ಲಿ ಹೇಳ್ಬೇಕು, ಹಿಂಗೆ ಇಟ್ಕೊಳಿಕ್ಕಾಗಲ್ಲ. Call after 2 weeks at the request of learned panel counsel appearing for
BD. BD.
PDA.
Office objection may be taken as complied with,
Office objection is complied with by filing the second set.
along with order copy.
Next.
Please, Griff.
Now we have fully complied.
Lords, they have served me a copy just now in the morning. I'll go through my client is not in town, my lords. This talks
Next
about.
week ಹಾಕೋಣ.
See,
There were two
gentleman-
directions, one to promote the petitioner as principal commissioner income tax, which we had done last year itself.
You are promoted.
Yes, no, we had to promote her as subsequently as chief commissioner, Last year, your lordship had given us 2 months.
Yes.
There was some delay, but now we have done it. 1st October, we have already promoted as chief commissioner as well. And I have filed the order. Either.
Please, after I file
May
my
I pass on
IAP
the copy of the
record. Contempt is between the court and the alleged contempt.
Lord, this is the copy of the order by which the petitioner
Next
is.
date, Nilkund held. Call next week. Just, learned, we call that. Learned ASG appearing for the alleged contempt or submits that the order in question have been complied with, although with the complainant
obliged.
ಏನಿದು ಜಯಣ್ಣ ಅವ್ರು ಇಲ್ವಲ್ಲ
ಇಲ್ಲಿ ಇದಾರೆ ಸ್ವಾಮಿ, ಇದಾರೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದಾರೆ.
Your lordship, I represent respondent, your lordship. I will file second set. The office has raised the office objection. I will file the second set, your lordship. Kindly have it next week, your lordship.
Second set. Statement of objections. 10 days for compliance.
Kindly, 4th, my lord. 4th of
ಇಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಇದೆ.
5th, my lord.
4th, 5th, 6th ಎಲ್ಲ ನಾವು ಪೋಸ್ಟ್ ಮಾಡಿದ್ದೀವಿ.
7th.
ಬರುತ್ತೆ
ಅಲ್ಲ, any date, my lord. Please, lordship, kindly.
after 23, call after 2 weeks. Yes, next.
Date to date.
Compliance within 10 days, call after 2 weeks. Next.
Much obliged, your lordship.
Okay. At the request of respondent.
Petition, smack.
Yes, Mr. Rasa.
Petition, my lord, filed before the tribunal seeking writ of mandamus. Lord, is rejected. Tribunal goes into merits of, my lord, the representation or the application given by me. Lord, what ought to have been considered by the state, tribunal considers it. That look at, my lord, limited prayer at page 63 before the tribunal to consider the application filed by the applicant seeking appointment on compassionate grounds on 6/7/2015.
Correct.
Lord, this is, my lord,
We are not confined. See, tribunal after L. Chandra Kumar exercises the writ jurisdiction, SP Sampath Kumar, L. Chandra Kumar. It exercises writ jurisdiction of the High Court.
Please.
So we are not bound by the prayers. Whatever grievance you had put forth in your representation, it is considered by the tribunal. Now you have to show tribunal's order on merits is bad. You show that, we will interpret.
please.
What was your grievance before the?
My lord, my lord,
Married
Sita,
claimed.
Sita Ram Rao, my lord, was my father.
On compassionate ground for married sister, your lords.
You know?
Brother has,
appointment
please lords,
for married sister.
married sister after 5 years.
Married sister after 5 years.
5 years.
ಅಂದ್ರೆ
after-
time barred ಆಗ್ತದೆ.
ಹೌದು.
6, no,
Married
On that
sister
ground
is not
only it is
covered.
rejected.
no, my lord, 6/4/2015, my brother died. My lord, he was unmarried.
Brother died.
Please,
Unmarried brother died.
unmarried brother died.
Okay.
6/7/2015. My lord, application as prescribed under the format, my lord, was.
Are you,
submitted.
whether the applicant falls within the definition of family?
Yes, yes,
Will not
ಇಲ್ಲ
read the definition of family?
please.
ಪ್ರಯರ್ ಟು ಅಮೆಂಡ್ಮೆಂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ. 2021 ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೂ ಬರೋದಿಲ್ಲ.
ಯಾವಾಗಿದು? ಡೆತ್ ಇನ್ ಹಾರ್ನೆಸ್ ಯಾವಾಗ?
My lord, soon after the death, 2015.
6/4/2015.
2007, 12/1/2007.
But,
ಅವಾಗಿನ definition of
my lord, in the case of, my lord, section 2B which stood amended.
amended.
Please, my lord.
Amendment with effect from?
My lord, that was, my lord, 9/4/2021.
That we have held the law as obtained as on the date of death in harness.
In fact, my lord, your lordship's, my lord, judgment in Pallavi GM. My lord,
Not Pallavi, Dharwadದಲ್ಲಿ Pallavi is on a different.
my lord, my lord, that case, my lord, dealt with, my lord, daughter.
Son was already given compassionate appointment.
Son was given.
He died.
He died.
ಅದಕ್ಕೂ compassionate appointment apply ಆಗ್ತದ?
My lord, because, my lord, it becomes a permanent employment. But even though it is, my lord, under compassionate grounds, it becomes permanent employment. Therefore, my lord, But the mother, my lord, is in the harness. My lord, she is unable to, my lord, work. But I am the daughter, my lord, and taking care of the mother. I have no avocation. I am a diploma holder, my lord. I have no.
How you are related to the deceased?
The deceased is my brother.
Your brother?
Please.
Read the definition of family.
Yeah, yes, my lord. Family, my lord, as described in the 2(1)(b, is, my lord, in the case of, my lord, deceased male unmarried government servant, his brother or sister who were dependent upon him and were living with him is, my lord, is what is covered.
Terminal benefits alla ಎಷ್ಟು ಬಂತು?
My lord, terminal benefits are not given. My lord, 2015, my lord, application is submitted. They made us to
ಎಷ್ಟು
run.
ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿತ್ತು?
My lord, he was, my lord,
7 years ಅಷ್ಟೇ, 8 years ಆಗ್ತದೆ. 7 date of.
Yes, my lord. My lord, father died on 12/1/2007. My lord, my brother was given an appointment on 6/11/2007. My lord, he had covered about, my lord, 8 years, my lord, has on that.
Little less than 8 years.
Please.
8 years qualifying service ಆಗೋದಿಲ್ಲ. 15 years ಇದೆ. 15 years. Sister is dependent. ಅಲ್ಲ, sister definition ಆಗಿದೆ ಅಂತ
Unmarried, or married sister, she does not come within that meaning.
Definition of sister.
The rule, your lordship.
In the
Dependent sister.
Yes. Dependent upon him and were living with him is, my lord,
Living with
what
him.
is said. That when we construe that, my lord, a married daughter could be
No,
given.
we have construed it otherwise in Dharwad. Covered by judgment.
That was, my lord, that lordships dealt with, my lord, in the case of a daughter-in-law. Daughter-in-law was held to be, my lord, not entitled. This is a case of daughter. In fact, Pallavi's case, my lord, your lordships held that, my lord, probably, my lord, this definition was not brought to your lordship's notice. The court held that, my lord, daughter.
This definition is.
Sister is not. Yes.
Post amendment.
Post amendment.
So earlier, what was the definition?
My lord, earlier it covered, my lord, only the unmarried. Yes.
ಮತ್ತೆ ಅದಕ್ಕೆ ಬರ್ತದೆ ಅಷ್ಟೇ.
No,
Your right to compassionate appointment arises on the death in harness. Is it not?
Please.
That's the law. Your substantive right to have your case considered for compassionate appointment accrues on the death of breadwinner of the family in harness. That's the law, right from 63 Supreme Court. Unless the amending law says it is with retrospective effect, the presumption is all substantive rights-oriented amendment are prospective.
Please, my lord, in fact, Pallavi's case, my lord, the Honorable Apex Court, while notifying respondents, my lord, considered two aspects of the matter. My lord, one with regard to prospective or retrospective nature of the amendment. Another one, my lord, the definition being not brought to the notice of this Honorable Court.
ನಿಮ್ಮ earlier definition ಓದಿ.
What happened, my lord? Please.
You need not spend, we are in the High Court now.
No, I understand.
We should take very little time in deciding small matters. Yes.
No,
What was the definition?
The earlier, my lord, family for the purpose of these rules, in the case of deceased male married government servant, his widow, son and daughter.
Widow, son and daughter. Then
Who were dependent upon him and were living with him.
Not covered.
Not covered.
The subsequent amendment covers.
Subsequent amendment covers.
Is it by way of substitution? What is the nature of amendment?
Amendment below the inclusive definition.
Inclusive is with respect to scope ಆಗ್ತದೆ ಅಷ್ಟೇ. That the efficacy of the amendment ಹೇಳ್ಬೇಕು. It's a substantive law. ಹಂಗಾಗಿ it is always.
But this being, my lord, a beneficial.
Unless indicated otherwise.
But beneficial piece of legislation.
That makes no sense. That's irrelevant. GP Singh says that an amendment is socio-welfare legislation is irrelevant ಅಂತ ಹೇಳ್ತಾನೆ ನಾವು. GP Singh has said that. Radhe Saab has updated that.
This amendment, my lord, is, my lord, given effect to based on a judgment of this Honorable Court, my lord, which covered also covered.
Judgment.
Please.
That is, we have held it prospective.
So therefore, my lord, this definition also ought to have been, my lord, read into, my lord, is my.
The grievance.
One concession I could, my lord, plead before the court is that tribunal, my lord, could not have gone into this.
That makes no sense.
What should have been considered by, my lord,
consider.
state?
Petitioner was before the service tribunal ventilating his grievance as to non-consideration of the subject representation dated so and so, wherein he had sought for compassionate, she had sought for compassionate appointment on the ground that she happens to be dependent married sister of the deceased. First up, the tribunal, having considered the matter on merits, has denied relief to the petitioner. First up, that is how the petition is now filed. First up, next paragraph. Kuthwadi, please be seated. Learned counsel appearing for the petitioner seeks to falter the order of the tribunal contending that on the colon. Firstly, the tribunal should have considered only the representation and not the merits of the case on which the said representation was structured. First off. Secondly, the tribunal grossly erred in not noticing the 2021 amendment, another 2021 amendment to the extent rules of act of the rules.
1990 rules.
Rules, extant rules, which govern the cases for compassionate appointment. First, according to him, the said amendment came in the light of a learned single judge's order of this court, which later came to be affirmed by the apex court. Vide, so and so, so and so. A judgment idea?
I did not.
All right, namatigide bidi. We have in our notes. The amendment has a socio-welfare orientation, and therefore such amendment should be read as being retrospective in operation. First, all these aspects having not been duly considered, the tribunal fell in error, warranting interference of writ court. First, learned HCGP, AGA, na? HCGP, AGA, appearing for the official respondents on our request, opposes the petition, negativing the contentions urged by learned counsel for the petitioner. First up. And he makes submission in justification of the reasoning of the tribunal. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence on the following grounds. Number one, right to have the case considered for compassionate appointment is indisputably a substantive right. Semicolon. Where laws are amended in relation to substantive rights, ordinarily they are prospective in operation, wide, so and so, unless a contra intent is demonstrated, which is not done in this case. First up, therefore, learned AGA is right in telling us that the 2021 amendment does not govern the case of petitioner, in view of death in harness being much earlier thereto. First up. Next paragraph. The vehement submission of learned counsel for the petitioner that the subject amendment of 2021 being socio-welfare in nature, as of necessity, it should be construed as being retrospective in operation, runs counter to at least half a century jurisprudence. First up, referred to G.P. Singh. First up, No ruling nor rule is brought to our notice to change, to have a view in variance. Full stop. Next paragraph. The contention that the definition of family, although did not include sister of an employee dying in harness, comma, having undergone statutory change because of subject amendment, comma, the claim of the petitioner to have her case considered for compassionate appointment needs to be favored, comma, is bit difficult to in view of our reasoning supra. First, next part. In the above circumstances, the petition being devoid of merits is liable to be and accordingly dismissed. Courts having been made easy. Dates ಎಲ್ಲ ಹಾಕೋಬೇಕು. ಎಲ್ಲೆಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಎಲ್ಲ ಕಡೆ dates ಹಾಕೋಬೇಕು. Restructure it. Yes.
My lords, I appear for the petitioner in this matter. My lords.
Yes, sir.
Lords, I appear
Await
for.
notice.
Yes, my lord. My lord, may I make one request, my lord?
Ah.
Respondent number 3, my lord, is the DRAT, against which DRAT, my lord, notice may kindly be dispensed with. We've only sought a direction for expeditious
Notice
disposal.
to DRAT is dispensed it in view of latest decision of the apex court. Yavdadu?
I'm sorry, my lord.
Latest 12 days back bantala. The quasi judicial bodies need not be impleted anta.
Please, my lord.
Live law dalli bandide nodi. Tan kodi court officer ಗೆ.
Yes, my lord.
Science.
My lords, in respect of the second respondent, may I please serve one of their panel or regular counsel, my lord, for Bank of Baroda, Mr. Vignesh Shetty, my lord.
In addition to taking fresh steps, comma, petitioner is permitted to serve a copy of the petition along with documents on the panel counsel, Mr. Vignesh Shetty, and file acknowledgement in the registry.
Yes, my lord.
Full stop. If that is done, post this matter.
My lords, and R1, may I serve hand summons, my lord? My lord, I'm only seeking this, my lord.
In addition to taking hand summons. Okay.
On R1 also, my lord.
On respond number 1.
Please, I'm so great.
Yes.
Lords, this is a case of regularization. 1990, this is the case of regularization, my lords.
Regularization.
1994, I was appointed as a daily wage employee.
What is this?
As a
94?
94, my lords, as a typist. And my lords, against the sanction post, and I was possessing the requisite qualification, and I have been continued against that sanction post for more than 10 years, my lords, without any interim order. And thereafter, my lords, I filed a representation to regularize my services.
What the tribunal said?
My lords, the tribunal stated that I have been entitled for benefit under 2013
Act. 2012 Act.
2012 Welfare Act, my lords. Therefore, I cannot be extended the benefit of regularization.
Correct.
However, my lords, in the Revanna's case, my lords, the Supreme Court has categorically held that that is no way connected with the regularization, my lords. That is that I have produced it, my lords, in annexure
But
page
in
73, page 73, my lords.
73. But in one matter we said, the statute 2012 Act is a complete repository of law of regularization.
So this is a finding given by the
Consider Madidara Act anna.
consider Madila Swami.
But ಅದು ಮಾಡ್ದಂಗೆ ಅದಂಗೆ, but
No, no,
how it
they-
becomes
they-
precedent.
No, they have told that the above act does not contemplate regularization of daily wagers. And my lords, the same person, Revanna, my lords, is junior to me. He was appointed in the year 1995. He has been extended the regularization benefit as well as the benefit under 2012 Act, my lords. So similarly situated person.
How tribunal treated that contention?
That was a sanction post, my lord.
Huh?
That was a sanction post.
Even this is,
Sanction post.
Please, my lord. And they-
That Uma Devi
against the
requirement
san-
was complied with.
Please, my lord.
even this is a sanction post, my lords.
No, no.
Page 58, page number 58.
Page 58.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ. And ಸಂಚಿಕದ ಒಂದು statement of objection.
Please, I'll file.
Issue emergent notice Learned AGA is requested to accept notice for respondents.
Well, that's a translated copy I produced.
Translation dispensed with. That's all. For the time being. If new judges come, you have to.
I'll do.
Okay. Next.
The office objection, Lord,
Another.
regarding non-filing of English translation.
English
That may
translation
be.
dispensed.
Lord,
Merits
this is a matter, Lord. Their senior geologist, my Lord, has been transferred prematurely beyond the
Retention period ಎಷ್ಟಿದೆ?
transfer period. 2 years, my Lord.
2
Is the
years.
minimum tenure.
ಏನಂತ ಟ್ರೈಬ್ನಲ್ ಏನಂತ
Under the,
ಹೇಳಿದ್ರು?
my Lord, tribunal, in fact, what happened was, my Lord, I was transferred from Haveri to vacant post in Bagalkot. The person who was transferred to my place had also challenged it, my Lord, before the tribunal. Tribunal clubbed both the matters.
You were party too. You were
Not-
also party.
I was also a part. I filed a separate application. The person who was transferred to my place also filed a separate application. Tribunal clubbed both matters. Insofar as my case, my Lord, tribunal did not give any finding on the merit. In fact, my Lord, tribunal, one important portion, my Lord, is where the tribunal says that since the order is already implemented,
No, that makes no sense.
that is,
Yeah, merely because it is implemented. Suppose decree is already executed.
All of CM.
Approval of CM ಇದೆಯಾ?
illa no, my Lord.
Prayer of CM notification in the name.
No, it was not-
8 officers are transferred, Your Honor.
8 officer.
Not one, 8 officers are transferred on that notification. And moreover, Lordship, against the petitioner, there is a DE proceedings pending.
No, that is against petitioner in the other case.
Saying, let us see. ನೀವು ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ವಾ ಅದು? ಇಲ್ಲ.
Public interest is done
ಇವ್ರ ಮೇಲೆ ಇಲ್ಲ ಅಂತಾರಲ್ಲ ಅವ್ರು.
there.
Serial number 11, that is, after the order of approval,
You are 2 of the 8.
yes, that I was posted to his place and he is transferred out. My transfer as well as his transfer, both are questioned. Let's, government does not take a stand, there is any inquiry. The private respondent, my lord, produces the note sheet. CM approval is there, but not a single sentence of reason. The finding recorded by the tribunal that there are cogent reasons from the record.
ಇಲ್ಲ ಇಲ್ಲ.
Not one sentence.
What Justice H.G. Ramesh said?
Let-
H.G. Ramesh's judgment.
M. Rajshekhar.
M. Rajshekhar was,
Produced that also.
what he says?
That the reasons have to be assigned and the reasons will have to fall within the bracket mentioned in the transfer guideline. And in so far as departmental inquiry, after the approval of the Honorable Chief Minister, there's a show cause notice sent to me. I have produced that show cause notice also. Show cause notice is treated as departmental inquiry itself is initiated against these persons.
ಅದಾಗಲ್ಲ. 214 ಕಡೆಗಡೆ enquiry is
Articles of-
initiated when?
Articles of charge is issued.
When articles of charges.
Till today, there is no articles of charge.
What do you say, brother?
That I will do.
ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
That I will do.
Learned EGA is requested to accept notice for respondents 1 and 2. You appear, Prithvi appears for respondent 3?
No,
Yes.
no.
Yes.
This, yes.
I mean,
Yes.
Yes.
Mr. Prithvi voluntarily appears for respondent number 3. ಅವ್ರಿಗೆ copies ಕೊಡಿ.
Please,
ನಿಮ್ಮ ಮ್ಯಾಟ್ರ್ ಅದು.
I'll take.
your matter.
Well,
11.
serial number 11.
11 ನೀವು ತೊಳ್ತೀರಾ?
Please.
Same
Illa,
order?
I'm not party in
ಇಲ್ಲ
this.
ನೋಡಮ್ಮ. ಅಲ್ಲಿ ಅಫಿಷಿಯಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ AGA issue emergent notice to private respondent. Call these matters together. ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು? ರಾಜಶೇಖರ
M. Rajshekhar.
ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Yes. that's
Copies.
Lord,
Even if chief minister wants to, he has to, even should be consistent with the paragraph.
Lord, in nine, petitioner has triplets. They are all studying in 7th standard. Could there be a stay of the order?
No, next week. ಈಗ ಆಲ್ರೆಡಿ ರಿಲೀವ್ ಆಗಿಲ್ಲನೋ? ಮತ್ತೆ ರಿಲೀವ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಇದೆ ಅಲ್ಲ, ಫೈಂಡಿಂಗ್ ಇದೆ.
I had to go to his place. I had also challenged.
ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿ ಇಬ್ರಿಗೂ
Very well.
ರಿಲೀವ್ ಆಗಿದ್ದೀರಿ ನೀವೀಗ.
Yes.
ಮತ್ತೆ ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿದ್ರೆ ಏನು ಉಪಯೋಗ ಆಗ್ತದೆ?
Very fine.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್,
Please.
ಪ್ಲೀಸ್ ಮ್ಯಾಟರ್ಸ್ ನೆಕ್ಸ್ಟ್
Great.
ವೀಕ್. ಏನ್ ಮಕ್ಕಳೆಲ್ಲ ಕಲಿತಾ ಇದಾರೆ, ಸ್ವಲ್ಪ ಮರ್ಸಿ ಗಿರ್ಸಿ ಇರ್ಲಿಲ್ಲ ಗೌರ್ಮೆಂಟಿಗೆ, ಏನೇನ್ ಡಿಫಿಕಲ್ಟಿ ಆಗ್ತದೆ ಅಂತ.
Obliged.
Grateful.
ಎಸ್
And request for a date if it is not. in-
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ತದೆ.
For the caveator, my lord.
ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪ್ರೊವೈಡೆಡ್ ದ ಸರ್ವಿಸ್ ಆದ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ನಾವು ಹೇಳಿಕ್ ಆಗಲ್ಲ, ಪೋಸ್ಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ಸರ್ವಿಸ್. ಓಕೆ.
For the petitioner, my lords.
ಎಸ್ ಬ್ರದರ್.
I'm challenging the order of the tribunal. This is a matter of transfer and posting, my lords. Challenge before the tribunal was with regard to my posting in place of respondent number 5. Respondent number 5 and petitioner both are in the cadre of account superintendent. Petitioner is from the state audit and accounts department, while the respondent number 5 is from the Panchayat Raj engineering department, my lords. Now, my lords, his challenge, he filed the application challenging my posting, my lords. The tribunal, in my humble submission, the tribunal has erred on 2 counts. The very first ground is that, my lords, tribunal has failed to read the government order dated 2/5/2017 as a whole, making certain part of that government order redundant. That is my first submission, my lords. The second ground is that tribunal has failed to consider another government order dated 30/10/2012, which is in my favor.
It is Chandra case consider ಆಗಿತ್ತು ಅದು 2012.
No, my lords. No, my lords. No, my lords. No, my lords. Let me support my submissions, my lords. These are the these are the 2 grounds on which I am challenging the order. First,
How these 2 grounds are treated by the tribunal? Take us
yes, my
to
lords.
that.
Kindly have page number 24, my lords.
24.
Yes, my lords.
Paragraph.
That's one single paragraph in that which runs through that page, my lords. 4th line from the top.
On the other hand,
Page number 24, my lords. Such
24.
being the fact, it is the defense of the respondents that the said notification existed only for a period of 6 years, and after completion of 6 years, the posts are to be interchanged. That is the part of the government order which has not been given effect to in my humble submission. Accordingly, the said government order comes to an end in the year
the
2023.
2/5/2017 order is not given effect to.
My lords, it is my submission is that only one part of it is being relied by the respondent number 5, which the tribunal has accepted. The other portion of that government order is not given effect to, making that redundant. That is my submission. I'll demonstrate.
First, demonstrate it now.
Yes,
The first one.
yes, my lords. Kindly have annexure A1, my lords. That is the government order.
Page number.
Page number 35, my lords. It starts at 35. Relevant portion, operational part of that order is 36.
37.
I would like to read from the twice. This is the operational part, my lords. By this government order, posts in Panchayat Raj department was earmarked on 50-50 ratio. 50-50 ratio. ಲೆಕ್ಕಾಧೀಕ್ಷಕ 31 ಹುದ್ದೆಗಳಿತ್ತು, 15-16 ಅಂತ ಮಾಡಿದ್ರು.
ನೀವು ಲೆಕ್ಕಾಧೀಕ್ಷಕದಲ್ಲಿ ಬರ್ತೀರಾ?
Yes, my lords. Both of them are from the same kid. Now, my lords, the operative portion says the posts are earmarked ಅಂತ ಹೇಳ್ತಾರೆ. The post, ಯಾವ post ಎಲ್ಲೆಲ್ಲಿಗೆ ಯಾರ್ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು ಅನ್ನೋದು earmark ಆಗಿದೆ. Page number 37, my lords. First line. ಈ ರೀತಿ ನಿಗದಿಪಡಿಸಿದ ಹುದ್ದೆಗಳನ್ನು ಪ್ರತಿ 6 ವರ್ಷಕ್ಕೊಮ್ಮೆ ಅದಲು ಬದಲು ಮಾಡುವ ಷರತ್ತಿಗೊಳಪಟ್ಟಿದೆ. My contention is that after 6 years, that post which was earmarked for PRE department lapses, it gets interchanged. Now the person from state accounts and audit department is eligible to hold the post. Now the tribunal's finding is that to give effect to this particular line of the order, another government order is to be passed. That is the finding returned by the tribunal.
No. Why another? This is a policy statement.
One submission.
Chandra says all these transfer guidelines have got statutory force. Why the tribunal says that one more order is required?
No, my lord, this government order is related to notifying or the identifying and notifying the post belong to the RDPR, my lord. 31 posts are there. Among that, 16 posts have been, it's a NKR post for the state accounts department, my lord. 16 posts have been allotted to state accounts department. 16 posts have been allotted for the RDPR, my lord. Annexure A1 nalle nodi swami. Annexure page 38, my lord. Panchayat Raj Engineering Division.
Column number 8.
8, my lord.
Row number 6 and
Page
7 is
38,
what
my
is
lord.
referring to.
38.
Panchayat Raj Engineering Vibhaga, 50-50 ratio, my lord.
Pamra im.
Panchayat Raj Engineering ಅಂತ ಹೇಳಿ ಲೆಕ್ಕಾಧೀಕ್ಷಕರು one post is notified for the RDPR, my lord, and that is being allotted for the RDPR. It is not notified by the state accounts department. And as per my learned brothers says that need to be adalu badalu. It is not a demoot clause, my lord. ಅವ್ರು ಹೇಳೋದು my learned brother ಈ ರೀತಿ ನಿಗದಿಪಡಿಸಿದ ಹುದ್ದೆಗಳನ್ನು 6 ಪ್ರತಿ 6 ವರ್ಷಕ್ಕೊಮ್ಮೆ ಅದಲು ಬದಲು ಮಾಡುವ
ಷರತ್ತಿಗೆ ಒಳಪಟ್ಟಿದೆ.
6 years ಆಗಿದೆ ಸ್ವಾಮಿ.
ಹಾ.
But that it is not a demoot clause, my lord. A fresh order need to be passed by the department.
We'll assume that fresh order is required.
Yes, my
Then
lord.
what happens to the pith and substance of this condition?
This condition is not demoot clause, my lord. There is,
That's the mandatory condition.
I need to continue
Huh?
because I belong to RDPR department, my lord. My learned brother belongs to State Accounts Department. This post is notified for the RDPR and I belong to RDPR, my lord. I belong to RDPR and I've been disturbed prematurely and I'm without posting.
When judges argue with each
Sorry,
other,
my lord. Sorry,
you should show the
Stop it, stop.
concession of being silent.
sorry, my lord.
You can defeat that. Brother, almost a nearby fact situation was considered by us. That madam who appeared, Kulkarni, you appeared in that other matter. Other day, was
Yes, my lord.
the first day of our sitting
Yes, my lord.
after the change.
Yes.
We considered almost nearby matter.
Similar matter was listed, my lord, but that day it didn't reach, my lord.
It did not reach.
Yes, my lord. There was one matter similar to this of this case, my lord.
Do you remember that or judge in the list what serial number? No, I believe it was argued. It was
I can
argued.
get it.
Huh?
I can get it afternoon.
Can get it.
Please.
Call this matter along with the WP number so and so, which learned AGA will furnish.
My lords, I am not relieved as of now.
They have not yet been relieved.
No, my
Lord,
lords.
one submission.
Therefore, my lords,
Relieve ಆಗಿದಾರಾ?
ಇಲ್ಲ ನನಗೆ I am without posting. ಆಮೇಲೆ one
with-
submission, my lord, one submission. He is holding the present post as well as the earlier post. 2 post ಇದೆ. Additional charge ಆಗಿದ್ದಾರೆ. 2 post ಇಟ್ಕೊಂಡು is working from the date of order, my lord.
You are holding two
Annexure
posts.
A4 may be looked into.
my lords,
And
additional
non-independent
charge, ನಂದು ಹಳೆ post additional charge ಹಂಗೆ continue ಆಗಿದೆ. ಇದು ಹೊಸ post ಗೆ I am transferred to. I have taken charge on 31st itself of 31st of July, and I'm continuing to work, my lords. I have not been relieved as of now. Therefore, an
He
order
is
of
holding
status quo.
both the post. I am without post.
Both the post ಅನ್ಲಿಕ್ಕಾಗಲ್ಲ. ಅದು ಇನ್ಚಾರ್ಜ್ ಅರೇಂಜ್ಮೆಂಟ್.
In charge, that is.
Incharge arrangement is not holding of the post.
I have been disturbed
DB says that way.
premature ಇದೆ ಮತ್ತೆ without post.
No, consider one. You have argued, na? Okay. Issue notice. Learned AG is requested to accept notice for the official respondents. Learned counsel, KV new.
Debates.
Learned counsel Sri so
GT.
and so represents the caveator. First off, he vehemently opposes granting of any reprieve to the petitioner. First off. Next, having heard the learned counsel for the parties, including learned AGA, Srimati so and so, we are of the considered view that matter requires a deeper consideration along with another similar matter, and therefore the reprieve needs to be extended to the petitioner till next date of hearing, since the admitted position is that he is not yet relieved. First off, call this matter week after next.
Date
Week
may
after
be-
next. Week after next. ನಿಮ್ಗೊಂದು ಪೋಸ್ಟಿಂಗ್ ಕೊಡಬೇಕು. ಇರಿ ಕನ್ಸಿಡರ್ ಏನೋ ಆರ್ಗ್ಯೂಯಬಲ್ ಪಾಯಿಂಟ್ಸ್ ಇದೆ. Tribunal says one more order needs to be passed on. We don't subscribe to that view. There are such judgments.
Date also.
Huh?
Date
ಬರ್ತದೆ 2 weeks ಕೊಟ್ಟಿದೆ.
Much obliged.
ಯಾವ್ದು?
ಅಲ್ಲೇ ಬೇರೆ ಪೋಸ್ಟ್ in the meanwhile it is open to the government to accommodate the caveator in an appropriate position subject to further outcome of this proceeding. All right.
Much obliged.
ಏನ್ರಿ ಅವರಿಗೆ ಪೋಸ್ಟಿಂಗ್ ಕೊಡಲ್ವಾ? Why do you keep people just waiting like this? All right. Next.
ನೀವು ಹೇಳ್ಬೇಕು.
Yes, brother.
Case of imposition of cost of 25,000 rupees. Lordship, we are the formal parties there.
one statement was not made before the tribunal, your lordship,
Yes.
in respect of a letter written by the first respondent to the second respondent, your lordship. Therefore, taking the serious view of 25,000 rupees is
ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ ಅನ್ಸಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ನಾವು ಇರ್ಲೇ ಇಲ್ಲ ಅದರಲ್ಲಿ. Actually, in fact, your lordship, her representation, her request was considered in accordance with the orders passed by the KAT. On merits, your lordship, provision list was also issued. And we have complied with the orders, your lordship, except 25,000 rupees cost, your lordship.
ಅಲ್ಲ, ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ ಅಕೌಂಟಬಿಲಿಟಿ ಇದೆಲ್ಲ ಇರ್ತದೆ. ಕಾಸ್ಟ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಡೆವಲಪ್ ಇನ್ ದಿಸ್ ಕಂಟ್ರಿ, ಸೈಡ್ ಜಸ್ಟಿಸ್ ಕೃಷ್ಣ ಅಯ್ಯರ್.
ನಮ್ದ್ರಲ್ಲಿ ಏನ್ ಇರ್ಲಿಲ್ಲ ಸರ್, ಫಾರ್ಮಲ್ ಇದ್ರು ನಾವು ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಆಗಿತ್ತು. One letter was not referred to, that's all, your lordship. Otherwise, it was complied with the orders.
Notice hoಯ್ತು.
We complied with the orders.
Issues, emergent, ಯಾರು ಕಾಸ್ಟ್ ಪೇಯಬಲ್ ಟು?
So, 3 ಜನರಿಗೆ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. 3 ಜನ ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ? ಇಬ್ಬರೇ ಆಗಲ್ವಾ? ಸುಧಾರಾಣಿ ಅಂಡ್ EE.
10,000 is payable to by the first applicant, 10,000 is payable to second.
Emergent notice, stay of direction for payment of cost.
Like.
But this is a second round of litigation.
Discuss
But in the first round, the caveator was held as not eligible. Sorry.
tomorrow, madam.
Tomorrow.
Please.
Very well.
Call tomorrow at the request of this. Next.
Matter pertaining to transfer, the petitioner has come to the present place,
ಏನ್ ಗ್ರೌಂಡ್ ಏನು? Retention period.
premature transfer. Premature transfer.
Retention period ಏನು?
Retention period is 4 years, my lord. Petitioner is in the cadre of my lord Group C. My lord, 4 years is the tenure. My lord, I was transferred on 22/7/2021 to Dodbalapur.
22/7/21.
21. My lord, before that, I was on OD in the very same place from 28 to 2021.
28 to
2021.
Before ಹೆಂಗಾಗ್ತದೆ ಅದು? After ಆಗ್ತದೆ.
22/7/2021.
Correct.
I am regularly posted to Dodbalapur.
Before that?
Before that, I was on OD
OD.
to very same place,
Which effect from?
28 to 2021.
28 February.
Yes, ma'am. February 2021. Lord, the respondent number 3 was working in Dodbalapur. Case was registered against her under section 7A, my lord, of the Prevention of Corruption Act. Lord, prosecuted. Under the impugned order, she has been brought back to the very same place, prematurely disturbing the petitioner.
What is?
Lord,
Yesterday I have entered the caveat, my lord. Papers have not been served on me.
Huh?
I represent the, am I permitted to
Now
represent?
we permit you to argue.
ಅಲ್ಲ,
See,
ನನಗೆ-
you are facing section 7 proceeding. And again, you are brought to the same place.
ಇಲ್ಲ, I have been transferred and relieved on 24th, my lord.
24th.
ಹೌದು, this one
Relieved from-
24th I have been relieved to the present post, my lord.
No, you are sought to be brought to the place where you committed that bribery charge.
Let them serve the copies, my lord. I will file the.
Issue notice, learned AG is requested to accept notice for respondents 1 and 2. Respondent number 3 has entered caveat and represented by her counsel. Full stop. Interim stay.
May I make one
Relieve ಆಗಿಲ್ವಾ?
Relieve ಆಗಿದ್ದೀನಿ ಸ್ವಾಮಿ.
May I make
24th,
one
24th.
submission? my
ನಾನು
lord?
relieve
The
ಆಗಿ-
order of the KAT, my lord, says that the earlier deputation order has not been placed before the tribunal. If the said document is produced, it would have been helpful for the tribunal to assess the period of application.
The question is not that. How is that a person who is facing trial under section 7 of 88 Act is being brought to the same place?
Same.
What is this? Unless there is something happening there, how can such an order be passed? Issue rule, stay as prayed for.
ಅಲ್ಲ, ಅದರಲ್ಲಿ I have been already.
Already ವಾಪಸ್ಸು next. See that Chamundi Muppet. Yes.
Matter for the complainants at the lordship order dated 26/10/2023. They are
Not complied, my lord.
Revival.
Please. Verify and submit to one.
Call after 2 weeks at the request of GA. Who accepts notice for R1 ಬೇರೆ ಇದಾರನಲ್ಲಿ ಅವ್ರಿಗೆ ಎಲ್ರಿಗೂ appeal ಆಗಿದೆ. One end.
Please.
Yes.
The petitioner, my lords. My lords, in this case, the writ petition was filed and subsequently we filed the memo of withdrawal, my lords. In the order part, it has mentioned as contempt, my lords, instead of writ petition. For that, we have filed an IA for the correction, my lords.
Correction.
Yes, my lords. The word, the contempt has been mentioned in the order part, my lords.
Print is strong. Revival ಇದನ್ನ ಮಾಡ್ಲಿಕ್ಕಿತ್ತು.
We have filed a memo, the withdrawal memo hakidi, my lords, for to file the with seeking liberty along with it. But the order part contempt anta means.
In view of the above, content complaint is disposed of ಅಂತಿದೆ. In view of the writ petition ಆಗಬೇಕಿತ್ತು. ಹೊರಳೆ ಸಾಹೇಬ್ರ ಅಷ್ಟೊಂದು ರಿಪೇರ್ ಮಾಡಿರಾಯ್ತು ಇಷ್ಟೇನಾ ಬರ್ಕೊಳ್ಳಿ. Counsel for the petitioner points out that the earlier bench in its order dated 17/11/2023 at the fag end has wrongly observed as under in action. Next paragraph. Since it is duty of the court to set right its mistake ex dubito justitiae, vide A.R. Antule, comma, the request of the petitioner is favored and the term inverse contempt of complaint inverse complaint needs to be substituted by writ petition as indicated in the subject application. First off, ordered accordingly. First off, registry to give supply a free copy of the order. Sorry, sometimes these mistakes happen.
Gratefully.
Next.
Gratefully.
Matter, pray for a week's accommodation. Pray for a week's accommodation.
Dispensation granted, call after 2 weeks as requested. Next.
Here.
Wish.
Yes. Appear for the petition.
Dispensation as ನೋಡಮ್ಮ ಎಲ್ಲ ಕಡೆ dispensation granted ಅಂತ ಅಲ್ಲಿ for the time being ಅಂತ ಮಾಡ್ತೀವಿ.
Matter relates to repatriation.
Repatriation.
Yes, madam.
From parent department.
From the borrowing department to the parent department.
From the borrowing department to
the parent department.
Parent department.
Without any consultation, without any posting.
Without, no. What is your right to continue in the borrowing department?
My lord, I was posted, my lords, to the, may I just take your lordship to the fact?
Yes.
My lords, I was deputed on 17/8/22, page number 49, my lords.
You were deputed on
17/8/2022.
You are in what cadre?
Lords, I am in the cadre of executive engineer.
17/8/22. From which department to which department?
From PWD to RDPR.
For what period?
Let's, the period is not stipulated.
When period is not stipulated,
Yes.
what the rules say?
Let's, the maximum tenure, my lords, under the guidelines is 5 years.
5 years.
Yes.
That is maximum period.
tenure.
Which is that guideline?
Let's, under the transfer guidelines itself. The
Transfer
maximum
guidelines.
transfer guidelines as well as section.
No, there are some
Government order, my
orders
lord,
under
old
section
government 17.
16
Yes, ma'am.
of
Yes.
the act.
Yes, ma'am.
Yes.
Maximum tenure is 5 years.
Huh?
Maximum tenure is 5 years.
No, it depends upon the designation, etc.
My lord,
2 years.
ಇಲ್ಲ 2 years.
ತೋರಿಸಿ
I'll just,
ಇಂಥದಕ್ಕೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡ ಇದು ಟೆಕ್ಸ್ಚುಯಲ್ ವರ್ಷನ್ ತೋರಿಸಿ.
may I just, would your lordships have a look at the judgment that I have produced where your lordships have quoted all those page 79, my lords. Annexure D, page number 79. My lord, at
Where
page,
is your deputation order?
my lords, annexure A1, page number 49.
Nine.
Yes, my lord, 49, serial number 1.
From PWD to RDPR.
RDPR.
Until further orders ಅಂತ ಇದೆ.
Until further orders. Then, my lords, I would go to RDPR, my lords, and then I am posted to the present place, my lords. I was originally posted to Ramnagar, modified, posted to the present place. When
Anyway, that is internal arrangement.
my lords, that was challenged before the tribunal, high court, and ultimately, my lords, I took
Our simple question to you.
yes,
Your right of lien
yes, my lords.
lies in the parent department.
Please, my lords.
What is your right to continue in a foreign department?
My lords, I have, my lords, my submission is, if there is consultation between the borrowing and the parent department, my lords, then my parent department, my lords, will be able to accord me a posting. Now, my lords,
Will direct your parent department to give a posting.
my lords, the third respondent who is facing departmental inquiries.
Why are you worried about it? Why you are worried about it? Let
My-
the government, which is that 78, 79 Supreme Court? That three judge bench decision, which considered right of the deputationist, he has no right to remain in the department.
Yes, my
Which
lord.
is that
I have-
judgment?
I have no right, my lords. A. Ramkrishna.
Correct.
Your lordship, my lord, but what has happened is I was posted to the present place in 23. I
What
meant,
is your right?
my lords, 2 years, my lords, in the present post.
There is nothing like that. That is for regular people, not for you.
Lord.
Which is that judgment?
My lord,
We
may-
used to
my
read
lord,
that in the
I'm
case.
not, my lord, on that, my lord. I have challenged the order of the tribunal refusing to grant me an interim order. My lord, then I had approached your lordship. The matter is posted tomorrow. My limited request
Do
before
you
your
want to
lordship.
withdraw this or wait to make some observation which will go against it?
My
Because covered by the
Yes,
judgment.
my limited request is, would your lordships, my lords, request the tribunal, my lords, to dispose it of
All.
tomorrow? That's my only request. Since the matter is posted tomorrow, I can't argue on merit.
You came here because reprieve was not granted.
Yes, my lords. My only request is it could be disposed of tomorrow.
Civil servant is knocking at the doors of writ court with the following prayers. First up, next paragraph. Having argued the matter for some time, learned counsel appearing for the petitioner very fairly submits that he would give up his prayers if a direction is issued to the service tribunal to consider his application number
Application number 4828 of 24, page number
24.
30.
expeditiously. First, with this proposal, learned AGA is agreeable. Agreeable, thane? Agreeable. First, in the above circumstances, this petition is disposed of, requesting the service tribunal to expeditiously consider and dispose of the subject application in accordance with law, keeping in mind other pressing works.
Obliged.
ನೆಕ್ಸ್ಟ್ ಇಲ್ಲಿ ನಮ್ಮ ಕೋರ್ಟಿಗೆ ಸ್ವಲ್ಪ ಸರ್ವಿಸ್ ಲಾ ನೋಡ್ಕೊಂಡು ಬರಬೇಕು, ಇಲ್ಲ ಸರ್ವಿಸ್ ಲಾ ಲಾಯರ್ನ ಇಲ್ಲಿಗೆ ಡೆಪ್ಯೂಟ್ ಮಾಡಬೇಕು. ನಾವೆಲ್ಲ ನಿಮ್ಗೆ ಟೀಚ್ ಮಾಡಿ ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಬೇರೆ ಅದರಲ್ಲೇ ಹೋಗ್ಬಿಡ್ತದೆ ಕೆಲಸ. 5 3 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಬೇಕು ಈ ಕೇಸ್, ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡು ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಎಸ್
My lord, and for the petitioner in this case, in violation of section.
Why you want to change the arbitrator?
My lord, be pleased to see, the conduct of the arbitrator, my lord, all through has not been non-partisan. Now, in this regard, my lord, I had filed a memo. My lord will get this. My lord, the conduct of the arbitrator, my lord, speaks for itself. For a moment, if my lord be pleased to turn to page number 36. An order, my lord, dated 25/10/2023. The respondent, my lord, files an application for amendment. The application is allowed. Now, the arbitrator, my lord, at page number 37, my lord.
No, not at all. Not at
Yes, ma'am. My lord, page number 37. Yes. Page number 37, if my lord be pleased to see the last paragraph. The amended counterclaim dated 13/2/2023 was filed by the respondent. As against this, the claimant has also filed its additional statement of defense. Therefore, the period of 1 year for completion of present proceedings will have to be reckoned from the date on which the additional statement of defense was filed by the claimant, as against the amended counterclaim. The additional statement of defense as against the counterclaim was filed by the claimant on 6/6/2023. And therefore, the period for 1 year for completion of the proceeding of this case will have to be reckoned from 6/6/2023. Case is posted so on. My lord, independently, my lord, be pleased to see a protest memo is filed by me before the arbitrator. My lord will get it at page number 278. I have, my lord, very categorically, clearly narrated as to why I feel that the arbitrator is not acting as a non-partisan person. Now, this protest memo, my lord, is dismissed. Thereafterwards, my lord, in violation of section 29A, my lord, page number 278, annexure P.
Judgment of citations, where the hell are those?
Now, again, this is backdrop, my lord.
These minutes. So instead of we passing order on merits, whichever we do not know, can't it be
I understand.
resolved?
That's
Because some some allegations are made, we have to treat it. That will be part of the record, whether this way or that way. And
There's
he's
only one
a very
difficulty.
respectable judge also.
There's only one technical difficulty, my lords, which my lords also, my lords, what happened is after this writ petition came to be filed, we filed an application for extension of the mandate, my lords. That, my lords, is recorded. My lords may turn to the order sheet. My short submission is extension of mandate petition has been filed before the commercial court, and that is pending for the orders, in which they have taken the counterclaim that arbitrator should be replaced. That is pending for orders on 30th.
ಸಾಲೆ ಇದಾಗ್ಬಿಟ್ರೆ ಅದು ಏನ್ ಗೊತ್ತಾ, ಈಗ ಹೆಂಗಿದೆ ನಿಮ್ದೆಲ್ಲ, ಈಗ ಜನರದ್ದು ಕಾಂಡಕ್ಟ್ ಹೆಂಗಿದೆ ಅಂದ್ರೆ, ಯಾವ್ದೋ ಪಾಪ ಒನ್ ಆಫ್ ದಿ ಬೆಸ್ಟ್ ಜಡ್ಜಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್,
Please, yes, ma'am.
I repeat,
am
one of the best judges of this court recused from hearing the matter.
Yes.
Recusal ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕು ಅಂತ ಹೊಂಟಿರಿ, ಎಲ್ಲಿವರೆಗೆ ಹೋಗಿದೆ? ಇನ್ನು ಇಫ್ ಐ ಕ್ಲಿಂಗ್ ಆನ್ ಟು ಎ ಕೇಸ್, no, I will decide this matter, that may be a ground for inquiry, investigation, because nobody is above this one. If a judge recuses, can it be a ground for investigation? Yes. Now, see, because we hold that particular judge in very high esteem, whatever be the objectivity of the proceedings and confidence. Suppose ನೀವು ಹೇಳ್ತಿರಪ್ಪ, ಸರ್ ಇದು ನೀವು ಡಿಸೈಡ್ ಮಾಡಬೇಡ್ರಿ ಅಂತ, ಇಲ್ಲ ನಾವು ಡಿಸೈಡ್ ಮಾಡೋಣ, ಹಂಗೆ ಕೂಡಿಗೆ ಬರ್ತದ, ನಾವು ಅದನ್ನ ಒಗಿಬೇಕು, ಬೇರೆ ಇನ್ನು 1000 ಕೇಸ್ ಇರ್ತಾವ, ಅದನ್ನ ತಗೋಬೇಕು ಅಲ್ವಾ? ಇದಕ್ಕೆ ಯಾಕಪ್ಪ ಅಂತದೇನು ನಾವ್ ಯಾಕೆ ಅಂತದ್ದು ಅಷ್ಟು ಕ್ಲಿಂಗಿಂಗ್ ಆನ್ ಟು ದಿ ಕೇಸಸ್, ಇಟ್ಸ್ ನಾಟ್ ಎ ಹ್ಯಾಪಿ ಥಿಂಗ್. ನಾವು ವಿ ಮೇ ನಾಟ್ ಬಿ ದಟ್ ಲಿಬರೇಟೆಡ್ ವಿತ್ ಲಾರ್ಡ್ ಕೃಷ್ಣ ಸೇಸ್ ಇನ್ ಗೀತಾ, ಬಟ್ ಎಟ್ ಲೀಸ್ಟ್ ನಮ್ಗೆ ಇಬ್ರು ಲಿಟಿಗಂಟ್ಸ್ ಬಂದು, ಇಲ್ಲ ಇನ್ ತಗೋಬೇಡ್ರಿ, ನೀವು ಒಬ್ಬರೇ ಹೇಳಿದ್ರು ಸಾಕು, ಇನ್ ತಗೋಬೇಡ್ರಿ ಅಂದ್ರೆ ಕೈ ಮುಗಿದು ಕೊಟ್ಟು ಬಿಡ್ಬೇಕು, ಇಷ್ಟು ಜನ ಇದ್ದಾರೆ ಹೋಗಪ್ಪ ಅಲ್ಲಿ ಅಂತ. ವೈ ಈಸ್ ಒನ್ ಆಫ್ ದಿ ಟಾಲ್ ಜಡ್ಜಸ್.
Yes,
ಜಡ್ಜಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್.
I understand what's falling from the bench.
ಇಂಥ ಸ್ಕೋಪೇ ಕೊಡಬಾರ್ದು. ನೀವು ಹಂಗೆ ಅಂತ ಏನ್ ಬೇಕಂತ ಹೇಳೋದಲ್ಲ.
Yes, my lord.
Tell you, since there is something, after discussing with my brother, we are putting it to you. ಇದನ್ನೆಲ್ಲ ಕೋರ್ಟಿಗೆ ತೊಗೊಂಬಂದು ಇದನ್ನೆಲ್ಲ ಮಾಡಬಾರ್ದು.
ಆಯ್ತು.
ಎಲ್ಲ ಒಂದ್ ಕಡೆ ನಿಮ್ಮಷ್ಟು ನೀವೇ ಮಾಡಿ, ಅಲ್ಲಿ ಹೋಗ್ಕೊಂಡು ನೀವು ಅವ್ರಿಗೆ, ಈಸ್ ಎ ಟಾಲ್ ಜಡ್ಜ್, ಅವ್ರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬೋದಿತ್ತು ನೀವು.
Request ಮಾಡಿದ್ವಿ, my lord. ಆಮೇಲೆ protest
That's exactly my problem, my lords. What has happened is that, my lords, they have the learned arbitrator, my lords.
ನೋಡಿ, ನಾವು
I'm not going on the merit of the case.
ನೋಡಿ, ಇಷ್ಟು ಬೇಕಾದಷ್ಟು ಜನ ಆರ್ಬಿಟ್ರೇಟರ್ಸ್ ಇದಾರಲ್ವಾ, ನೀವು ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಯಾರನ್ನ ಒಬ್ರು ಚೂಸ್ ಮಾಡಿರಿ, ಅಪಾಯಿಂಟ್ ಮಾಡಿ. ಇದನ್ನೆಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಬೇಡಿ, ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಇದನ್ನ ಅಷ್ಟು ಓದಿದ್ಮೇಲೆ ಮತ್ತೆ ಒಪಿನಿಯನ್ ಏನ್ ಮಾಡ್ತೀವೋ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದು ರಿಸ್ಕಿ ಆಗ್ತದೆ, ನಿಮಗೂ ರಿಸ್ಕಿ ಆಗ್ಬೋದು, ಅವ್ರಿಗೂ ರಿಸ್ಕಿ ಆಗ್ಬೋದು. ಆಮೇಲೆ ನಾವು ಈ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಇವ್ರೇನ್ ಅನ್ಕೋತಾರೆ, ಓ ಹೈಕೋರ್ಟ್ ಅಪ್ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಕ್ಕೇನೆ ಅವ್ರು ಅದನ್ನ ಮಾಡಿದ್ರು ಅಂತ. ಈ ಫೀಲಿಂಗ್ ಬೇಡ. ಒಂದು ಇಂಗ್ಲಿಷ್ ಕೋರ್ಟ್ನಲ್ಲಿ ಹಂಗೆ ಆಯ್ತು, ಇಂಗ್ಲಿಷ್ ಜಡ್ಜ್ ಮುಂದೆ ಇವ್ರು ಬೇಡ ನಮ್ಗೆ, ಇವ್ರನ್ನ ಬದ್ಲಿ ಬೇರೆ ಮಾಡ್ರಿ ಅನ್ಕೊಂಡು ಕೊಟ್ಟು, ಆಮೇಲೆ ಅವ್ರಂದ್ರು ನೀವು ಬೇಡ ಅಂದ ತಕ್ಷಣ ನಾವು ಬಿಡ್ಲಿಕ್ಕಾಗಲ್ಲ.
I would only say I'm in my lord's hand. Let us not decide who's the arbitrator. My lords may only decide the arbitrator.
ಬರೀ law of arbitration ಏನು? ನಿಮ್ಮಿಬ್ರು ಕೇಳ್ಕೊಂಡು ಮಾಡ್ಬೇಕು ನಾವು. ನೀವು ಒಪ್ಪಲೇದಾಗ ಈ ಪ್ರಶ್ನೆ, ವೆರಿ ದಿ ಬೇಸಿಕ್ ಪ್ರಿನ್ಸಿಪಲ್ ಆಫ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಲಾ ಈಸ್,
Mutually we are requesting, my lord.
ಇಬ್ರು ಹೇಳಿ.
My lord, we will leave it to my lord.
Appoint an
ಅಲ್ಲ
arbitrator.
ಮಾಡೋಣ, ಒಂದು ಹೆಸರು ಕೊಡಿ, 3 ಹೆಸರು
Because my lords have told this.
ಕೊಡಿ ಬೇಕಾಗ್ತದೆ. ದಟ್ಸ್ ಎ ಗುಡ್ ಥಿಂಗ್, ಬಟ್ ವಿ ಹ್ಯಾವ್ ಗಾಟ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಫಾರ್ ದಟ್ ಜಡ್ಜ್. Now we will not, since we don't want to pass an order, because it will be a court of record idu, so everything will remain in record. That's not a happy thing to happen. ಹೇಳಿ, 3 ಹೆಸರು ಕೊಡಿ, ಒಂದು ಬರೆದು ಕೊಡಿ, ಇಬ್ಬರೇ ಸೇರ್ಕೊಂಡೆ ಹೇಳ್ತಾರೆ. ನಾವ್ ಯಾವ ಮ್ಯಾಟ್ರಿಗೂ ಕ್ಲಿಂಗ್ ಆನ್ ಇರಬಾರ್ದು, ಅಟ್ಯಾಚ್ಡೇ ಇರಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾನೆ ಭಗವಂತ. ಬಟ್ ನಮ್ಗೆ ಆ ಲೆವೆಲ್ಗೆ ಹೋಗಕ್ಕಾಗಲ್ಲ. ಅಟ್ ಲೀಸ್ಟ್ ವಿ ಆರ್ ಅಟ್ಯಾಚ್ ಟು ದಿ ಬ್ರೀಫ್ಸ್. ಕಿತ್ ಒಗಿಬೇಕು, ಬೇಡ ಅಂದ್ರೆ ಬೇಡ, ತಗೊಂಡೋಗಿ ನಾವೊಬ್ಬನೇ ಅಲ್ಲ ಜಡ್ಜ್ ಇಲ್ಲಿ ಅಂತ. ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಹೇಳ್ರಿ, ಬೋತ್ ಯು ಆರ್ ಟಾಲ್ ಜಡ್ಜಸ್. He is a very tall judge. King ಮಾಡ್ತಾರೆ. We have great respect for him.
My submission before my lord is, I would leave it to my lord to.
ಇಬ್ರು ಕೇಳ್ಕೊಂಡ್ರೆ ಸುಮ್ಮನೆ ಇಷ್ಟಲ್ಲೇ 1 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಯೋ ಕೇಸಿಗಲ್ಲ, ಇಷ್ಟಿಷ್ಟು ದಪ್ಪ ಪ್ಲೀಡಿಂಗ್ಸ್ ಬರೀ ಇದ್ರಾಗ ಹೋಗ್ತದೆ ಎಲ್ಲ ಕೆಲಸ. ಇಂಥವಕ್ಕೆಲ್ಲ ಕನ್ಸೆನ್ಸುಲ್ ಬರ್ಬೇಕು.
That's me choosing.
ಇಬ್ರು ಇಬ್ರು ಒಪ್ಪಿದ್ರಾ?
Only two names, my lord,
Two names,
two
ನೀವು
names.
three ಬೇಡ ಅಂತನಾ?
Too young at the bar, my lords, to recall the names. So
We will leave it to my lord to,
So-
that would be best, my lord, leaving it to this court to appoint.
ಇದರಲ್ಲಿ ಬ್ಲೂ ಇಂಕ್ ಯಾರ್ದು, ಬ್ಲಾಕ್ ಇಂಕ್ ಯಾರ್ದು?
Blue ink namdu.
No black.
Blue ink.
Black ink namdu.
Blue ink.
Blue ink number.
ಅದೇ ಇಂಕ್ ವಿಲ್ ನಾಟ್ ಚೇಂಜ್ ದ ಬ್ಲಡ್ ಕಲರ್ ಆಫ್
I should have written our name. My lords.
ಬ್ಲಾಕ್ ಇಂಕ್ ಅಲ್ರಿ?
My lord.
ಹಾ.
I'll leave it to my lord.
ಲೀವ್ ಇಟ್ ಅನ್ಬೇಡ್ರಿ, ನಿಮ್ಗೆ ನಾವು ಕೇಳ್ತಾ ಇದೇವಪ್ಪ. ಇದು ಇಬ್ರು ಹೆಸರು ಹೇಳಿದ್ರಿ ನೀವು ಅಲ್ವಾ? ನೀವು ಇಬ್ರಿಗೂ ಒಪ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾವು ಇನ್ನೊಂದು ಹೆಸರು ಹೇಳ್ಬಿಡ್ತೇವೆ ಅಷ್ಟೇ.
I will leave it to this court, my lord.
Let's take it as an acceptance.
ಏನು ಅಕ್ಸೆಪ್ಟ್ ಅಂದ್ರೆ do you have any reservation about ರಿಸರ್ವೇಶನ್ ಅಲ್ಲಿ ಬೇರೆ ಏನಿರಲ್ಲ, ಏನೇನೋ ಕಾರಣಕ್ಕೆ ಇರ್ತದೆ ಅದು.
That's right.
ಅವ್ರು ಇವ್ರು ಬೇಡ
I would
ಅಂದ
only-
ತಕ್ಷಣ ಅವ್ರಿಗೆ ಅವರು ಸರಿ ಇಲ್ಲ ಹಂಗಂತಲ್ಲ, 100 reasons ಇರ್ತದೆ.
I would
ಬೇಕು
only
ಬೇಡ
want to
ಅಂತ.
press my suggestion. If my friend does not agree for it, my lord, most non-partisan thing both of us are bound to agree is my lord should appoint the arbitrator. Any third name, my lord, we will accept.
ಇವೆರಡು ಬೇಡ ಅಂತನಾ?
ಬೇಡ sir.
At 2:30 ಬನ್ನಿ,
Grateful, ma'am. Grateful.
ಸ್ವಲ್ಪ ವಿಚಾರ
Great.
ಮಾಡ್ಬೇಕು.
Obliged.
ಆದ್ರೆ you should also know,
Yes.
he is one of the tallest judges of this court.
Yes, my lord.
ಇದು ಕಣ್ ಮುಂದೆ ಇಟ್ಕೋಬೇಕು.
That's my learned senior, my lords, was not on record from beginning, so ಗೊತ್ತಿದೆ ಏನಾಯ್ತು ಅಂತ. But because the suggestion fell from your lords, I
Grateful, ma'am.
close it at that.
Grateful.
Pass over. Yes. Yes, Prashant Chandra.
My lord, the dispute, the list is between a site developer and a site seeker who's intended to seek a site from us. I am the site developer. He has made certain payments towards the installment towards purchase of the site. He did not make certain payment. However, there was some issue. He went to the consumer forum, took an order of direction, which is a specific performance, directing us to deliver the site.
Appealable ಅಲ್ಲ ಅನ್ನೋದು.
It is appealed, my lord. It is dismissed, against which, my lord, they preferred revision between National Commission. So before challenging the same before the Honorable Apex Court, now they are before this Honorable Court. They have suffered the order till National Commission.
Appeal to National Commission.
Yes, they have suffered the order, my lord.
ಅಲ್ಲಿ.
Allinu, ಇಲ್ಲಿ appeal ಕೂಡ suffered.
You are challenging that order also.
National Commission order. I'm only on this, my lord. I'm not getting into the merits also.
Easily resolve ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಆಗಲ್ವಾ?
ಆಗತ್ತೆ, ಅದಕ್ಕೆ ಹೇಳಕ್ಕೆ ಬಂದೆ ನಾನು. Specific performance is ordered, asking me to give him a site. I do not have this site. For various reasons, I do not have the site. That 2013 scheme is done already. If the same is converted to money decree, I'm ready to pay. Because he has also parallelly sought for money decree in the form of money decree by filing a.
Natively ನಾವು 10 ಪರಿಹಾರವನ್ನು ಕೇಳ್ತೇವೆ. ಅದಕ್ಕೆ
ಯಾಕಂದ್ರೆ with great respect, the commissions also have not looked into my merit. Delay
ಯಾವ್ದು
ಇದೆ.
ಸೈಟ್ ಅವೈಲೇಬಲ್ ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹಾಗೆ ಹೇಳಿದಿರಾ? Where have you taken up that stand?
I have not taken this stand.
Then why do you argue that? Why do you argue that?
I would
You are
file an
not supposed
affidavit
to
to that.
argue.
I would file that an affidavit because that was taken, orally I was taken because I was not appearing in the court below.
That makes no sense.
In the
That makes
state
no
commission,
sense.
I was
We
not
are on
a
the litigant, not on the counsel.
true, my lord. State
You have
commission,
not taken, otherwise you would have taken that ground before the court, before the commission.
no, my lord,
You
I
did
was,
not take that.
I was ex parte, that's the reason. I was ex parte in the court below.
Subsequently, ಅದ್ರ ಮೇಲೆ ಹೋಗಿದ್ರೆ ಎಲ್ಲರ ತೊಂಡ್ರ ತೋರಿಸಿ.
ಇಲ್ಲ.
Then why do you say that? Why
would-
do you say that?
I would file an affidavit to that effect.
That makes no sense now. At this
Because
length of
this has
time, you
come
may
to
not
my
have.
knowledge.
Question is, as on that date, you had one or not? That is the question.
May I
So
submit?
many things have happened since last 9 years. That's not the
May
criteria.
I submit, my lord? He files an execution case seeking for execution of this decree. Simultaneously or parallelly, he files a FIR and charges on me, and that is now stayed in the writ court where I have deposited certain amount, substantial amount. So he has already, when the case is pending here, the list is pending here in an execution, he opts for filing an FIR, and that has resulted in a writ petition where I have deposited certain amount. So he himself has converted into
ಎಷ್ಟು
a
ಅಮೌಂಟ್ ಕೊಡ್ತೀರಿ?
My lord,
ಸೈಟ್
principal amount
ಸೈಟ್ ಅಲ್ಲಿ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಅವ್ರು ಅವಾಗ?
1,50,000 ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವಾಗ?
ಡೇಟ್ಸ್ ಎಲ್ಲ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿದೆ. ಐ ಹ್ಯಾವ್ ಗಿವನ್ ಆಲ್ ದ ಡೇಟ್ಸ್.
ಲಾಸ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೆ ಅವಾಗ?
ಬಂದೆ ಸ್ವಾಮಿ. 2017 ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ತಿಂಗಳು ಕೊಡಬೇಕಾಗಿತ್ತು. ಲಾಸ್ಟ್ ಮಾಡಿದ್ದು 23 2017 ಮಾಡಿದೆ ಸ್ವಾಮಿ.
2017.
23/8/2017. The amount which he has paid is 1,50,000, correct? 1,50,000.
ಅವಾಗ ಜಾಸ್ತಿ. ಫಸ್ಟ್ ಪೇಮೆಂಟ್ ಯಾವಾಗ ಮಾಡಿದ್ರು? ಎಷ್ಟು ಮಾಡಿದ್ರು?
ಕೊಡ್ತೀನಿ ಸರ್. 2013 ಇರ್ಬೇಕು. 2013.
ಎಷ್ಟು ಅಮೌಂಟ್?
1,500,000. ತಿಂಗಳಿಗೆ 1,500,000 ಕಟ್ಟೋದು.
2 ವರ್ಷ.
2,500,000. ಓಕೆ.
2,500,000. Some amount ಸುಮ್ಮನೆ ಲಿಟಿಗೇಷನ್ ಹಾಕೋದು. ನಾವು ಇದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಇಟ್ವಿ ಅಂದ್ರೆ ಮತ್ತೆ 5 ವರ್ಷ ಸಿಗಂಗಿಲ್ಲ ಅವರಿಗೆ. 5 ಅಥವಾ 7 ವರ್ಷ. ನಾವು ನಮ್ ಸ್ಪೀಡ್ ನೋಡಿದ್ರೆ 8 ವರ್ಷ ಅಂತ ಅನ್ಕೋತೇವೆ ನಾವು. ಎನಿವೆ, ಅಸ್ಯೂಮಿಂಗ್ ದಟ್ ದೇರ್ ಆರ್ ಸಮ್ ಜಡ್ಜಸ್, some amount
Speak with my client and I will come back.
ಕ್ಲೈಂಟ್ ಕೇಳೋದು ಬೇಡ ಬೇಡ, ನೀವು ಹೇಳಿ. ಇಲ್ಲಪ್ಪ ನಾವು ಆರ್ಡರ್ ಮಾಡಿ ಹಾಕ್ತೇವೆ ಅಷ್ಟೇ.
Because since 2013, my lord, the sites were available at that time. Now also their sites are available. But he is not willing to give back because he is a retired teacher. But he has.
ಈಗ ಅಮೌಂಟ್ ಕೊಡ್ಸಿಬಿಟ್ರೆ ಅದನ್ನ ಅಮೌಂಟ್ ತಗೊಂಡು ನೀವು ಸೈಟ್ ತೊಗೊಳಂಗ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ಎಲ್ಲಿದು ಸೈಟ್?
ಚಿತ್ರದುರ್ಗ.
Challakere town.
ಚಳ್ಳಕೆರೆ ಟೌನ್.
But nearly 11 years, my lord, he waited.
ಅದು 1,500,000 2,500,000 ಕೊಟ್ಕೊತ ಹೋಗಿ.
ಅಲ್ಲ, ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಇದ್ದಿದೆ 2,500,000. Continuously 3.5 years he has paid, my lord.
ಆಲ್ ರೈಟ್.
At that
ಒಂದು
time,
ಚೀಟಿಯಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ತೀರಿ ಅಂತ ಹೇಳಿ
ಕೊಡ್ತೀನಿ ಸರ್.
ಬೇಗ ಬರ್ಕೊಡಿ. ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಂಗಿಲ್ಲ. ಅದರ್ವೈಸ್ ಯು ನೋ ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಆರ್ಡರ್ಸ್ ವಿಲ್ ಪಾಸ್.
I have filed a.
ಟು ಬೋತ್ ಆಫ್ ಯು.
My lord, I have filed a
ಬೇಗ ಹೇಳ್ಬೇಕು.
date of deposit ಅವ್ರು ಕೊಡು.
ನಲ್ಲಿದಾರ
give it.
ಕೇಳಿ ಮೇಷ್ಟ್ರೆ, ಸುಮ್ಮನೆ 10 ವರ್ಷ ಫೈಟ್ ಮಾಡ್ಕೊತ ಕೊಡೋದು ಬೇಡ. ಎಲ್ಲರಿಗೂ ಆಯುಷ್ಯ ಮುಗಿದು ಹೋಗ್ತದೆ. ಆಡ್ತಾ ಆಡ್ತಾ ಆಯುಷ್ಯ ನೋಡಿರಲ್ಲ ನೀವು. ನಮ್ಮ ಜ್ಞಾನಪೀಠ ಅವಾರ್ಡಿ ಅವರ ಆಟೋಬಯೋಗ್ರಫಿ.
ಬೇರೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ ಅದೇ ನೋಡಿ, ಮತ್ತೆ ಈಗ ನಾವ್ ಇದನ್ನೇನ್ರ ನಾವು ಕೇಸ್ ಹಿಡಿದು ಬಿಟ್ವಿ ಅಂದ್ರೆ 5 ವರ್ಷ ಹೋಗ್ತದೆ. ಎಷ್ಟು ವರ್ಷ ತಮಗೀಗ? ತಾವು ರಿಟೈರ್ ಆದಂಗೆ ಕಾಣ್ತೀರಿ. ಹಾ, ಮತ್ತೆ ಅದಕ್ಕೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಒಂದು ಜಸ್ಟಿಸ್ ಆಗ್ತದೆ. ದುಡ್ಡು ತಗೊಳ್ಳಿ, ನಿಮ್ಗೇನು ಸೈಟ್ ಅರ ತಗೊಳ್ಳಿ, ಮನೆಯರ ತಗೊಳ್ಳಿ, ಜನತಾದರ ತಗೊಳ್ಳಿ.
Sites are there, my lord.
He is saying sites are not there ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
There are, my lord.
ಇದಾವ?
Till today it is there. That is our grievance, my lord.
ಬೇರೆಯವರಿಗೆಲ್ಲ 8-10 ಲಕ್ಷಕ್ಕೆ 15 ಲಕ್ಷಕ್ಕೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Tomorrow you file affidavit that you don't have sites.
8 ಸೈಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೇರೆಯವರಿಗೆ.
Yeah, they have sold nearly 15 lakhs of site, my lord.
ಈಗ 15 ಲಕ್ಷ
No.
ಅದೇ ಅಮೌಂಟ್ ಅನ್ನು ಕೇಳ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಏನು ಅಮೌಂಟ್ ಇದೆ ಅದ್ ನೋಡ್ಕೊಂಡು ನಾವೇನೋ
Sites are available, my lord.
ಅಲ್ಲಿ ಆ ಏರಿಯಾದ ಸೈಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆ ಅಲ್ಲೆಲ್ಲ?
15 ಲಕ್ಷ.
ಇವಾಗ 15 ಲಕ್ಷ ಇದೆ ಸರ್.
ಎಷ್ಟಿದೆ ರೀ?
15 lakhs.
10 to 15.
15 lakhs.
15 lakhs.
10 to 15 lakhs.
15 lakhs ಕೊಟ್ಟು ಮುಗಿಸೋಣ. ಸೈಟ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಈಗ ಅಮೌಂಟ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಅಮೌಂಟ್ ವಾಪಸ್ ಇಸ್ಕೊಳಿಕ್ಕಲ್ಲ, ಸೈಟಿಗೆ.
I understand.
ಮತ್ತು ರಿಟೈರ್ಡ್ ಟೀಚರ್ ಅವರು.
Normal appreciation of a money is about
ಅದೆಲ್ಲ
18% ತಗೊಂಡ್ರೆ.
ಅಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು. ಅದು 18% ಬರೀ ದುಡ್ಡನ್ನು ವಾಪಸ್ ಕೊಡೋಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಆಕ್ಟ್ ನಲ್ಲಿ ನಾವೇನೇನೋ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಇದು ಇಂಟ್ರೆಸ್ಟ್ ಆಕ್ಟ್ ಅಲ್ಲ, ಇದು ರೀಕಂಪನ್ಸೇ. ಇಲ್ಲ, ಸೈಟ್ ಪರ್ಚೇಸ್ ಮಾಡ್ಕೊಂಡು ಕೊಡಿ. 50 ರೂಪಾಯಿಗೆ ಪರ್ಚೇಸ್ ಮಾಡಿ ಸೈಟ್ ಅನ್ನು ಕೊಡಿ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, ಅದು ಮತ್ತೆ
ಅದು ಕೊಡಿ. ನಿಮ್ಗೆ ಅದು ಬೇಕು, ಇದು ಜಸ್ಟಿಸ್ ಆಗ್ಬೇಕೋ ಬೇಡ?
I agree. That's why I'm not going into the merits. Only question is amount.
ಒಂದು ಸೈಟ್ ಪರ್ಚೇಸ್ ಮಾಡಿ ಕೊಡಿ ನೀವು. ಸಿ, any ಯಾವುದೇ ಒಬ್ಬ ಸಿವಿಲೈಸ್ಡ್ ಪರ್ಸನ್ ನ ಲಕ್ಷಣ ಏನು ಅಂದ್ರೆ ಪ್ಯಾಕ್ಟಾ sunt servanda, to which you have agreed, abide by
I
it.
will not argue at all, man. Because he said 10 to 15, I'm just saying to say in between a step.
ಇನ್ ಬಿಟ್ವೀನ್ ಬರೋದಿಲ್ಲ. 15 lakhs ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಇಷ್ಟು ವರ್ಷ ಫೈಟ್ ಮಾಡಿದ್ದಾರೆ ಮೇಸ್ಟ್ರು, ಅವರಿಂದ ಎಷ್ಟು ಜನರಿಗೆ ವಿದ್ಯಾದಾನ ಆಗಿರ್ತದೆ, ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಟ್ಟರೆ ಏನ್ ದೊಡ್ಡ ಪ್ರಶ್ನೆ.
Even going by 18%, it comes to about 3 lakhs.
ನಾನು ಪರ್ಸೆಂಟೇಜ್
5 times my just.
Buy, my brother said now, buy a site for a song, give the site, simple.
Court may record and give on 10 days so that I will abide by it. Just
Within 10 days you have to.
ಅಲ್ಲ ಒಂದು ಕನ್ಸೆಂಟ್ ತಗೊಂಡ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ ಅವ್ರು ದುಡ್ಡು ಕಟ್ಬೇಕಲ್ಲ ಅಷ್ಟೇ.
ಈಗಲೇ ಹೇಳ್ಬೇಕು, ಸಿಂಪಲ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ, ಫೋನ್ ನಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ, ಕೊಡಿ. ಅವ್ರಿಗಾಗಿದ್ರೆ ಕೊಡ್ತಿದ್ವಿ ಟೈಮ್, ನಿಮಗೆ ಕೊಡಲ್ಲ ನಾವು. ಬಿಲ್ಡರ್ ಆಫ್ಟರ್ ಆಲ್, ನಾಳೆ ಜಸ್ಟಿಸ್ ಎಲ್ಲ ಯಾರು, ಪೀಪಲ್ ವಿಲ್ ಲೂಸ್ ಫೇತ್ ಆನ್ ದ ವೆರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. 2:30 2:30 ಹೇಳ್ಬೇಕು.
Petitioner, the insurance
Yes.
petitioner, the insurance company,
Ah.
the risk that was covered was accidental injury resulting in death. The insured dies due to natural causes of a heart attack.
He died of heart attack,
Heart attack,
not accidental injury.
not accidental
Whether
injury resulting.
accidental injury
Injury.
contributed to heart attack?
Pardon, there was no injury.
Accident ಆಗಿತ್ತು.
Not the risk.
Accident ಆಗಿದ್ದು ಯಾವಾಗ?
No,
Let us see the time proximity.
Pardon,
When the
no?
accident happened.
No, madam. The risk,
Answer the question.
there was no accident at all,
No
madam.
accident.
No accident at all. He dies due to natural causes of a heart attack. The risk covered is bodily injury resulting in death. Not page 33 is the terms, my lord. Peril specified under section 1, borrower shall sustain bodily injury due to accident followed by death,
Injury leading to death.
leading to death.
The policy is a uni-home care policy, not any insurance, as my learned friend is saying, my lord. If you see the policy at page 31, 30, annexure D, these policies are issued to the bank so that the loan issue covered is secured.
So widow should not suffer. ಅಂತ.
Yes, my lord. That's the substance.
ಎಲ್ಲಿದೆ ಇದು? Is it statutory policy?
It is not a statute.
Not a statutory policy.
Contractual. If you see the bank is the insured and my account is taken care of. And the policy is for the period 2015 to 2032 till my loan is cleared.
How this question is considered by various high courts in the country?
My lord, the terms of the policy have to be strictly construed. That is the.
ಇದೇ ಕೇಸ್ ಸರ್, ಅದು ಬಿಡಿ. ಜನರಲ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಯ್ತು, ನಿಮಗೂ ಗೊತ್ತಿದೆ, ನಮಗೂ ಗೊತ್ತಿದೆ.
In a similar case,
Ah.
in respect of a fire or a
No,
theft,
what your friend says appears to be sensible. The objective is
my lord,
that the borrower dying in harness nalli, family should not suffer. She should be in a position to retain the house.
I agree, my
ಮಾಡಿದ್ದಾರೆ.
I agree, my lord. Harness subject to, it should be an accidental death. The idea itself is accidental death.
Where is that term?
My lord, page 33.
33.
Page 4 of, I just read it out, my lord. In consideration of the.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ?
Page 33, my lord.
ಅಲ್ಲಿ ನೀವು ಕಂಡೀಷನ್, ನೀವು ಹೇಳಿದ ಕಂಡೀಷನ್ ಎಲ್ಲಿದೆ?
ಅದೇ page 33 ಅಲ್ಲಿ.
ಅದು ಹೋಗಕ್ಕೂ ಮುಂಚೆ your lordships may kindly see page 31. Section 2 ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಆ section 2 ನಲ್ಲಿ ಇಲ್ಲ. If you see the sum. 31 is the policy. Some insured ಅಂತ ಇದೆ ನೋಡಿ, first column end ಅಲ್ಲಿ. On the building, 10 lakhs, on the person, nil. So they are trying to go into section 2, which is not available.
No, it is available. ತಪ್ಪು
ಕೇಳಿಲ್ಲ ನೀವು ಹೇಳೋದು.
Page 31, my lord.
31.
ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಇನ್ಶೂರ್ಡ್ ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕು, ಸೆಕೆಂಡ್ ಕಾಲಮ್ ಅಗೇನ್ ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕು.
Correct.
ಥರ್ಡ್ ಒನ್ ಇಸ್ KR ಸರ್ಕಲ್ ಮೈಸೂರು. ಪೀರಿಯಡ್ ಆಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಅದು ಡೇಟು, ಅಕೌಂಟ್ ಆಫ್ ಮಂಚಯ್ಯ, ಬಿಸ್ನೆಸ್ ಆಕ್ಯುಪೈಡ್, ದೆನ್ ಸಮ್ ಇನ್ಶೂರ್ಡ್. ಸಮ್ ಇನ್ಶೂರ್ಡ್ ನಲ್ಲಿ ಸೆಕ್ಷನ್ 1 ನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ 10 lakhs.
ಸೆಕ್ಷನ್ 1 ನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್.
ಹೌದು. ಸೆಕ್ಷನ್ 2 ನಲ್ಲಿ ಆನ್ ಪರ್ಸನ್ Personally, accident insurance
Zero.
ಇಲ್ಲ, zero. So anything that is reading on page 33.
ಪರ್ಸನ್ ಇರೋ ಇನ್ಶೂರೆನ್ಸ್ ಅಲ್ಲೇ ಇಲ್ಲ ಇದು.
Accident ಗಲ್ಲ, accident ಗಲ್ಲ.
ಅದು ಸೆಕೆಂಡ್ ಇದ್ದಿದ್ರೆ ಆಕ್ಸಿಡೆಂಟ್ ಗೆ ಹೋಗ್ತೀವಿ.
ಹೌದು.
ಅದರ್ವೈಸ್ ಹೋಗೋ ಪ್ರಶ್ನೆ.
So whatever he is reading.
ಅವ್ರು ಹೇಳಿ ಸರ್, I should not interfere.
ಅವ್ರಿಗೆ ಸೆನ್ಸಿಬಲ್ ಅನ್ನಿಸ್ತದೆ ನಾವು ಅದಕ್ಕೆ.
Whatever they are.
ಎರಡು ಇನ್ಶೂರೆನ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ.
ಹೌದು.
ಒಂದ್ ನೀವು ಮಾಡಿಸಿಲ್ಲ, ಪರ್ಸನ್ ಮೇಲೆ ತಗೊಂಡಿಲ್ಲ.
That is why if your lordship see the page.
ಫಸ್ಟ್ ಪಾರ್ಟ್ ಅಷ್ಟೇ ಬರ್ತದೆ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆಕ್ಷನ್.
So they have to, if you see the page 30 also, previous page.
ಅಲ್ಲ, ಇನ್ಶೂರೆನ್ಸ್ ಮನಿ becomes payable on the happening of an event.
Event.
ಯಾವ event?
When the loan is not repayable by the death of the loanee.
Whatever be the cause of death.
Whatever. That is why the insurance is the bank. And its loan. The policy itself is issued to the bank. If you see, your lordship may kindly see page 30.
Syndicate bank.
Yes, ma'am. They have taken to secure their loan. I am the beneficiary there.
ನಿಮ್ಮ ಕಂಡೀಷನ್ ಯಾವುದು ನೀವು ಹೇಳೋದು?
Page 33, my lord. The next page. Home care insurance policy. In consideration of the insured named in the schedule herein having paid to the United India Insurance Company Limited, hereinafter called the company, the full premium mentioned in the schedule, the company agrees, subject to the terms and conditions and exclusions contained herein or endorsed or otherwise expressed herein, that if after the payment of the premium, the property insured described in the schedule or any part of such property.
One second.
Be
Described in the schedule, said schedule,
yes,
or any part of such property
be
destroyed or damaged by any of the specified
in section 1.
subsection 1.
And or the insured person or borrower
shall
sustain bodily injury due to accident followed by death. This is an additional feature which we are giving them. Usually we cover the building. Additional supposing he was the employee of the bank. Aurgu enadru akasmat he sustains an accidental death, we pay 10 lakhs.
ಈಗ ಈ ಟರ್ಮ್ ಯಾವುದೇ ಹೈಕೋರ್ಟ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿಲ್ವಾ? ಹೈಕೋರ್ಟ್
ಮಾಡಿದ್ದಾರೆ.
ಯಾವ?
The Supreme Court itself in 2023, which the.
You have that judgment?
I have in a fire policy that since there is no ambiguity, my lord.
We'll come to that one. Now you say, sir, you are saying that there is a judgment of apex court. But what about
page 17? I didn't bring my page 17 it has been referred.
Pass over ಮಾಡೋಣ ಅಥವಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ, ನಾವು ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀವಿ, ನೀವು ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀವಿ.
Next week.
ಇಷ್ಟೇ ಪಾಯಿಂಟ್ ತಾನೆ?
Yes, ma'am. All the concurrent points.
ಅಲ್ಲಿ ತನಕ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೆಸ್ ಮಾಡ್ಬೇಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತನಕ.
Next week.
We'll post this matter next week.
ಇಲ್ಲ, ಈ 21 ನಲ್ಲಿ stay ಇದೆ. They had to deposit the entire amount.
That we have deposited. Let
They
it
have
be
not
there.
deposited. Then why they are frightened? They have not deposited.
My lord, it's an insurance company. ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
3 ವರ್ಷದಿಂದ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ವಿ.
ಇಲ್ಲ.
ತಮ್ಮ ಮುಂದೆ
ತೋರಿಸಿ ಬಜೆಟ್ ಮಾಡಿರಿ, ತೋರಿಸಿ, ಮುಗಿದ ಹೋಯ್ತು. ಇವೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ, ಪೇಪರ್ಸ್. ಯಾವತ್ತಾಗಿದೆ ಅಂತ ನಮಗೆ ಕೊಟ್ಟು. He is saying, your friend is saying not deposit. You are saying deposited. ಇದನ್ನ ನಾವು ಯಾವ್ದೋ ಒಂದು ಡಬ್ಬಿಯಲ್ಲಿ ಹಾಕಿ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದ? ನಿಮ್ ಪೇಪರ್ಸ್ ತೋರಿಸಿ ಹೆಂಗ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್.
That I will bring it. I will bring it to the court and show it. That amount is.
Call this matter next week. ಅಷ್ಟೇ ಕೇಸ್.
Still then it shall let it not be executed. Let it not precipitated matter.
He has given assurance. Should not we? Why we should disbelieve him? He's a senior member of the. ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿ ತೋರಿಸ್ತಾ ಇಲ್ಲ.
21ನೇ ಇಸ್ವಿದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಇನ್ನೂ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ. ಇವಾಗ ಡೌಟ್ ಮಾಡ್ತಾರೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ತೊಂಬರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಇದೇ ಪಾಯಿಂಟ್ ಅನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಯಾರ.
Yes, Petitioner, my lord, in this matter, we are challenged by agreeing the order passed by the National Consumer Dispute Resolution Commission in first appeal 95 of 2017, my lord. In this matter, my lord, the rent which has been exorbitantly ordered in respect of, while considering the order, my lord, they observed that there was a minor works were pending as on the date of appointing the commissioner before the state commission on my application, my lord. After appeal,
ಅವರಿಗೆ ಯಾರು ನಿಮ್ಮ ಅಪೋನೆಂಟ್ ಯಾರು?
opponent to
Fresh
complaint.
matter,
Yes, fresh matter.
issue emergent notice, returnable within 1 week.
Correct. That same may be correct. We have deposited already 10 lakhs before the state commission, my lord. Now they have executing the remaining amount. They are executing the execution petition and they have got the warrant. That's why, my lord. We already
Warrant of-
deposited 10 lakhs, my lord.
Warrant of what?
Warrant for balance amount as per the order of the National Commission. In para number 12 of the impugned order, they observed that, my lord, we already deposited 10 lakhs, my lord.
Interim order as prayed for till next date of hearing. First off, this reprieve is granted on the assertion of counsel for the petitioner that his client has already deposited a sum of rupees 10 lakh in the National Commission, in the registry of National,
State Commission.
in the
As
state,
per the order
in the
of National-
registry of the State Commission. First, if assertion proves to be untrue, consequence will follow.
In para number 12 of the impugned order, that same has been confirmed,
Mention ಮಾಡಿದ್ದಾರೆ.
mentioned ಮಾಡಿದ್ದಾರೆ.
Not. When have you changed your name?
No, my son.
Ready?
Colleague, my lord. Stake.
ಏನು ಸಂಜೀವ್?
Here, what has happened? my
Here
lord,
for
is
respondent number 3, aviator.
20, my lord, the petitioner was transferred to the.
Huh.
The petitioner was transferred to the said post, my lord. And thereafter, my lord, from day one, she has been transferred, my lord, I filed the synopsis, my lord. 22, my lord, she has been posted to this particular place. Immediately thereafter. Yes, my lord, yes, my lord.
It
The
is
government as well as the petitioner went to the Supreme Court as against an order passed by this honorable court, my lord. My lord, that order, my lord, an interim order was passed, passing all sorts. May I pass on that order, my lord? It's not produced. I have also filed it, my lord. The honorable Supreme Court, my lord, passes 2 orders, my lord, they are subsequent to that. It was stayed. Initially, my lord, page 35, I have produced the stay copy, my lord. Thereafter, my lord, 47, again they transferred me. As against that, with my lord, we went there before the Supreme Court. In 47, the honorable Supreme Court said to go back to the KAT. According to that, my lord, we went back to the KAT. Yes, it was, the option was given to the petitioner to go before the KAT. KAT, my lord, passes an order saying that posting should be given to the petitioner. And thereafter, petitioner was given the same posting. Now, my lord, again they transfer.
In none of the litigation, my lord, the respondent number 3 was the party. For the first time, my lord, the.
He has no
Now I was
understanding.
waiting for the posting, my lord. Now I have been. I am also, my lord, one of the same cadre officer, my lord. Now I have been posted, my lord, in the post where earlier she was serving. But what happened is, my lord, this is the appointment under 371J, my lord, where she has to serve in a cadre, my lord, of 371J.
It was not
In-
the
in
case
the
all along. my
Hyderabad,
lord.
Kal-
Even
Gulbarga
before the
district, my
Supreme
lord.
Court, it was
That-
not that case.
That is one aspect, my lord. Now she is a probationer. No, I was not there. I am not the party at all, my lord. Now, my lord, my case is. Yes, my lord, state has taken.
No,
No. No, in this matter, my lord, that has been observed by the court also, my lord, saying it is one, she is a probationer. Her probationer is not declared and nor, no, my lord, material placed on record to say. Or so far as the right over the post,
At no point of time,
right over the
government had
post
taken
is
that
concerned.
intention.
he cannot, my lord, claim as a matter of right, my lord, because some, my lord, difference between the permanent employee. No, my lord, one of the, my lord, judgment of, my lord, put it, judgment. This. ಎರಡು ಕಾಪಿ ಕೊಡಿ.
Not one remark, my lord, against
No, my lord,
against that lady, my
I
lord.
was,
She's
I was
been
waiting for
harassed.
the post, my lord. Now I have been accommodated, my lord, where she was working. And she has been given in some other post, my lord. And my lord, she has spent, my lord, being a probationer, she has spent, my lord, time on the litigation. And my lord, my lord. Lord, no. Now, my lord, no, my lord, my lord, so there is one judgment, my lord. But the rest of the things, my lord, so far as, my lord, the right over the post is concerned, she cannot. That is what, my lord, the Justice Ramajoy's judgment, my lord, in L. Kumar Chandra versus State of Karnataka. Lord, para 16. Maybe, my lord, but so far as, my lord, the position of an employee is concerned, they cannot claim as a matter of right.
But third respondent has no right.
Probationary means, my lord, temporary employee. That is the definition also given, my lord. No, my lord, my lord, that is what, my lord, the circular, my lord, issued under civil service, my lord, says, my lord, that it is a temporary, my lord, appointment only, my lord. May I please, my lord, the notification, my lord, in this judgment, my lord, para 16, lord, where the coordinate bench says, my lord.
Then, my lord, Gangadhar, there are two. First judgment is Justice Patil and other. Gangadharaya versus State.
From 2020, she's been working, my lord. Not 2 years is already over also.
She has completed her term, my lord, in the said post, my lord. Now, my lord, now only this is a fresh posting. She has to go one or the other place, my lord. That is, and more interestingly, my lord, 371J, my lord, makes it mandatory to work in, my lord, Hyderabad, Karnataka area. She has not been, my lord, taken there. When she was posted, my lord, she. But that.
My lord, after all this.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇನ್ನೊಂದು my lord, the coordinate bench where, my lord, Justice Anushwaraman, my lord, was the party, my lord, and Justice Ramnath Hegde. There they said, my lord, it is mandatory, and therefore, my lord, government has posted her, that candidate, my lord, in the Hyderabad, Karnataka region, my lord. May I pass on this statement?
Government's case.
Siddesh Nayak anta.
You don't understand why my learned friend, senior counsel.
No. Because now I have been posted there, and I have been, my lord, my submission this much. She has completed her tenure there, and my lord, now I have been posted and taken charge
After
there.
all the litigation,
Therefore, my lord,
18/8, she resumes charge. 18/8, 2004.
Work ಮಾಡಿದ್ದಿತ್ತಲ್ಲ, work ಮಾಡಿದ್ದೆ. Mostly I miss ಹಾಗೆ ಕೊಟ್ಟು. Work ಮಾಡಿದ್ದೆ.
Even government went, my lord, as against that interim order. Also went. Government also filed a appeal against that order. 18/8/24, she is now settled.
Lord, he has, my lord, already taken charge, my lord, and but so far as, my lord, this judgment is concerned, my lord, Lord, she is completing her post, my lord. In fact, she spent, my lord, 2 years. My lord,
18/24, after all this litigation. Like,
Yes, Mr. Raghavan.
The Karnataka Inter-alia Development Board is before this court, my lord, questioning.
One assurance you have to give us.
My lord,
Many stalwarts of the bar of your stature have written biographies, autobiographies.
yes,
A person who has extensively traveled, so many things. Father's biography is not written by anybody. Not written. Mr. Raghavan, father's biography is not written.
no, my lord, not yet, not yet.
You have one option now.
I'll
Write father's biography or write your autobiography. To which condition you will agree? Yes.
It will be easier to write the first one. He has achieved much more than, so.
The great judge. Our judgments ಎಲ್ಲ ನೋಡಿದ್ರೆ
I
I read almost all judgments of your father.
Yes.
ಅವರು
Our-
ಸಭಾಜ್ ಸಾಹೇಬ್ರದ್ದು, ಹನ್ನೇಗೌಡ್ರದ್ದು, ಎಷ್ಟು ಚಂದ ಜಜ್ಮೆಂಟ್. ಸ್ಮಾಲ್ ಶಿವಶಂಕರ್ ಭಟ್ ಸಾಹೇಬ್,
Yes.
ಇವನ್ ಗೋವಿಂದ್ ಭಟ್ರದ್ದು, ವೆರಿ ಸ್ಮಾಲ್.
they were all-
ಹನ್ನೇಗೌಡ್ರ ಜಜ್ಮೆಂಟ್, ಕೊಂಬೇಗೌಡ್ರದ್ದು
Absolutely.
ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ. ಯಾಕೆ ಅಷ್ಟು ಲೆಂದಿ ಜಜ್ಮೆಂಟ್ ನಾವು ಬರಿತೀವಿ ಅಂತ ತಿಳಿಯೋದಿಲ್ಲ ನಮಗೆ. ಬಹಳ ಲೆಂದಿ ಜಜ್ಮೆಂಟ್ ಬರಿತೀವಿ ನಾವು. ಅವರೆಲ್ಲ ಎಷ್ಟು ಕಾಕ್ಸ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಕೇಸಸ್ ಅನ್ಕೊಂಡು, ಕಾಕ್ಸ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ರಿಪೋರ್ಟ್ಸ್ CCCR 2 ಪೇಜಸ್ಸು ಇಲ್ಲ. ಎಷ್ಟು ಬ್ಯೂಟಿಫುಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಫ್ ದಿ ಸಬ್ಜೆಕ್ಟ್, ಲ್ಯಾಂಗ್ವೇಜ್. ಈಗ ಯಾವ ಜಜ್ಮೆಂಟ್ ನಾವು ಎಲ್ಲ ನಾವು ಓದಿಬಿಟ್ರೆ, ಅಂದ್ರೆ ನಮ್ಮ ಜಜ್ಮೆಂಟ್ ನಾವು ಓದಿದ್ರೆ ನಾವು ಮತ್ತೆ ಸ್ನಾನ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಅಷ್ಟು ಪೊಲ್ಯೂಟ್ ಆಗ್ತದೆ ಲ್ಯಾಂಗ್ವೇಜು, ಕಂಟೆಂಟ್. ಅಂತದೇನಿಲ್ಲ. ಎಸ್.
ಇಲ್ಲ, now to be quite apart from anything else, my lord. When we read your lordship's judgments, my lord, we are enlightened. Not only on the legal subject, but also on so many other aspects. And it's such a, it is an education, my lord. I mean, I must, sometimes even if the case may not require, we read it because it is educative.
ಅಲ್ಲ, ನಾವು
Educative, my lord.
ಏನಾಗ್ತದೆ, ಬೇರೆ ಕೆಲ್ಸ ಇಲ್ಲ ನಮ್ಗೆ. ಈಗ ಸೆಕ್ಯೂರಿಟಿ ಕವರ್ ನಲ್ಲಿ ಇರೋದಕ್ಕೆ ಯಾರು ನಿಮ್ಮಂತ ಯಾರು ಮನೆಗೆ ಬರಕ್ ಬರಲ್ಲ. The books are the only, my friends, right from very early days also. Now, nobody who comes to my house to ask me, how are you? Nothing. ಸಿ ವಿನಾಗೇಶ್ವರಂಕ ಎಂದು ಬರೋದೇ ಇಲ್ಲ. ಮೊದ್ಲಿಗೆ ಭಾಗವತ್ ಬರ್ತಿದ್ದ, ಅವನು ನಿಲ್ಸ್ಬಿಟ್ಟ. ಹಿಂಗ ಹಾಕೊಂಡು, we have no other job than reading.
Right.
ಹಂಗಾಗಿ ಮೋಸ್ಟ್ ಆಫ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಏನಿರುತ್ತೆ, ಬೇರೆ ಕೆಲಸ ಇಲ್ಲ. ಸ್ವಲ್ಪ ಫಾಸ್ಟ್ ರೀಡಿಂಗ್ ಇರೋದಕ್ಕೆ ಅದು ನೋಡ್ಕೊತ ಹೋದಂಗೆ ಗೊತ್ತಾಕೋತ ಹೋಗ್ಬಿಡುತ್ತೆ.
But ಅದು ತಾವು ಬರೀ ಫೈಲ್ the amount of other information.
ಫೈಲು ನಿಮ್ಗೆಲ್ಲರಿಗೂ ಯಾಕೆ ಅಲೋ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ, ನಿಮ್ ಕ್ಲೈಂಟ್ ನಿಮ್ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೋಬಾರ್ದು ಅನ್ನೋದಕ್ಕೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಅಲೋ ಮಾಡ್ತೀವಿ. ಕೆಲವೊಂದ್ಸರಿ ಒನ್ ಸೈಡ್ ಒಪಿನಿಯನ್ ಫಾರ್ಮ್ ಮಾಡ್ತೀವಿ, ಅದು ಬಹಳ ಅನ್ಯಾಯ ಆಗ್ಬಿಡುತ್ತೆ. ಹಂಗಾಗಿ ಜಸ್ಟ್
But your lordship, I mean, it is a, we don't want judgments to be so crypt, my lord. Because there's so much more that we learn from judgments than merely the law. The way it is expressed, the way, the language, the approach.
we have to learn. Still we have to learn only.
My lord, that is a constant process. Constant process. If in this field of law, my lord, anybody says that they know the law, then, my lord, I would put them in one of two buckets. Either they are ignorant or they are liars.
ಡೆಪ್ಯುಟೇಷನ್ ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ, 2 ನಿಮಿಷದ ಕೆಲಸ. 78 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 3 ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಸಿಷನ್ ಇದೆ. ಡೆಪ್ಯುಟೇಷನಿಸ್ಟ್ ಹ್ಯಾಸ್ ನೋ ರೈಟ್.
I don't write. Yeah, you are. Yes.
So simple. ಎಷ್ಟು ಅಷ್ಟೆಲ್ಲ 18 ಪೇಜ್, ಟ್ರೈಬ್ಯುನಲ್ ರೈಟ್ಸ್ 18 pages. ಅವು 18 pages ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ ಪಾಪ ಲಾಯರು. ಅವು 18 pages ನಾವು ಕಮೆಂಟ್ ಕೊಡ್ಬೇಕು ನಮ್ಗೆ. ಅವ್ರು ಏನೇನ್ ಬರ್ದಾರೆ, ಯಾವ ಬಸ್ಸಿನಲ್ಲಿ KT ಹೋದ್ರು, ಎಲ್ಲಿ ಇಳ್ಕೊಂಡ್ರು, ಅಷ್ಟನ್ನು ಬರಿಬೇಕು ನಾವು. ಒಂದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು. Yes, sir.
My lord, the KDB is before your lordships, my lord, a statutory body being agreed, my lord, by an order passed with the state commission as confirmed by the national commission. My lord, the allegation of the respondent was that a site had been allotted, industrial site had been allotted, which in an industrial layout where facilities of road and electricity were not provided. And on that ground, it is alleged that they have suffered damages and therefore, my lord, a complaint was laid before the state commission. The state commission, my lord, passed an order, and I would say so, my lord, with responsibility, without any reasons, and said, I'll give 20 lakhs. Absolutely no evidence.
National Commission in.
My lord,
National Commission.
National Commission also same, I may say so, my lord, with due respect, same. They just confirmed it.
ಏನ್ ರೀಸನ್ ಕೊಟ್ಟಾರೆ ನಿಮ್ ಪ್ರಕಾರ?
My lord, I would say, my lord, on the basis of the allegations in the complaint, nothing. The principal allegation, my lord, is electricity connection is not given. That is not my responsibility. What am I going to do? If electricity is not given, it is to be given by BESCOM. What can I ask myself, KDB do if electricity connection is not provided by BESCOM?
ಅಲ್ಲ, ಬೆಸ್ಕಾಮು
It is
ನಿಮ್ಮ ಆಕ್ಟಿವಿಟಿ ಕಾರಣದಿಂದಾಗಿ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ.
not a
You
whisper.
fall ಅಂತ hold
Not
ಮಾಡಿ.
a whisper. Your lordship may see the complaint, man. I showed your lordship the complaint. Please be kind enough, my lord, to turn to page 18. I have, of course, my lord, I'm reserving my.
But you had undertaken to provide that facility.
My lord, I did not a question of undertaking. I am governed by the provisions of the statute. What are my powers? My lord, I have to provide the necessary infrastructure facilities. If I can't provide electricity, I can only enable the electricity to be provided. If BESCOM does not provide electricity for whatever reason, good or bad, and I'll assume it is bad, how am I responsible is a question I ask myself.
But
We have deposited, my lord, we have deposited 15 lakhs.
ಅಪೋನೆಂಟ್ ಇಲ್ಲ.
Illa, first time.
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಾ?
15 lakhs 80,000 rupees has been, 15 lakhs 25,000 rupees has already been deposited in the execution petition before the learned state commission.
Issue emergent notice. Interim order ಏನ್ ಕೇಳಿರಿ?
My lord, interim order, my lord, is to stay the.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ಮಾಡೋಣ.
ಹೌದು, execution petition ಸಾಕು, ಅಷ್ಟು ಸಾಕು. ನಾವು ಆರ್ಡರ್ ಅಂತ ಕೇಳಿದೀವಿ, ತಾವು execution petition number.
ಬೇಡ, ಇರ್ಬೇಕು.
Execution petition number. ನಿಮ್ಮ ಫೋನಲ್ಲಿ ಇತ್ತಲ್ಲ. Petition number 1 is. No, it is execution petition number 1 of 2018.
1 of 2018.
Yes, my lord, respectfully.
6 ವರ್ಷ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟದ ಆಲ್ರೆಡಿ.
And we have deposited, my lord, by
Till next date of hearing.
the state, national
First-
commission ಹೋಗಿ ಅಲ್ಲ.
This interim relief is granted on the assertion of learned senior advocate Mr. KG Raghavan appearing for the petitioner that his client has already deposited a sum of rupees 15,25,000 in the
Execution petition before the state commission.
registry of the state commission.
My lord, to be exact, it is 15 lakhs 29,975.
ನೋಡಮ್ಮ.
This, of course, my lord, I am reserving my submission at a later point of time as to whether a petition like this can lie at all.
ಅದು ಆ ಪಾಯಿಂಟು ಇದೆ, ಬಟ್ ನಾವು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಹಾಗಾಗಿ ಇದನ್ನ ಅಡ್ಮಿಟ್
Lucknow development case ಎಲ್ಲ ಇದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್. Yes.
These are the land grabbing act.
Yes, sir.
But a complaint came to be filed by the Tahsildar on 14/9/2021, complaining of grabbing of 2 guntas of land. 2 guntas.
ಅಲ್ಲಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು, ಇದು ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ಇದೆಯಾ ನಿಮ್ಮಲ್ಲಿ
ಅಲ್ಲ,
ಜಡ್ಜ್ಮೆಂಟ್?
ಇದ್ರಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ ಕೇಸೇ ಹಾಕಿಲ್ಲ, ಭಾರತೀಯ ಏರ್ಟೆಲ್ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಅದೇ point
ಆಮೇಲೆ
ಮೇಲೆ-
ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಅವ್ರನ್ನ ಬಿಟ್ಟು ಬಿಡ್ತಾರೆ. ಇದೆಲ್ಲ ರಿಯಲ್ ಲೈಫ್ ಅಲ್ಲಿ ಆಗುತ್ತೆ, ರಿಯಲ್ ಲೈಫ್ ಅಲ್ಲಿ ಆಗುತ್ತಾ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಅಂತ ಅದೇ ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ವೇರ್ ಹಿ ವಾಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ ಅಟ್ ಆಲ್, ಅದ್ರ ಮೇಲೆನೆ ಒಂದು
ಅಂಡ್ ಜೊತೆಗೆ ನಾವೇನ್ ಮಾಡಿದೀವಿ ಅಂತಂದ್ರೆ, ವಿ ಹ್ಯಾವ್ ಈವನ್ ರಿಮೂವ್ಡ್ ಅವರ್ ಟವರ್ ಆಲ್ಸೋ. ನಾವು ಟೆನೆಂಟ್
government.
ಗವರ್ಮೆಂಟ್ ಅಲ್ಲ, ದಿ ಕಂಪ್ಲೇಂಟ್ ought to
this
have been
matter-
against the landowner,
This matter, my
not
lord,
against a tenant. And I have surrendered the lease, removed the tower also.
issue emergent notice, learned
AGA.
issue emergent notice to issue emergent notice, learned AGA, Mr. So and so accepts notice for the respondent state, interim order as prayed for.
Please.
Partition. What kind of commission, please? Nobody should tell. Is not
ಅಲ್ಲ, ನಾವೊಬ್ರೇ ಇರೋದು ಗವರ್ಮೆಂಟ್.
not a party.
No, earlier is the my lordship agreement
Correct.
order.
Correct, we have seen that.
Subsequently, my
Covered
lordship,
judgment.
no, earlier, my lordship, their name is Indus. Subsequently, my lordship, Bharti Airtel. Now, my lord,
Gone,
yes,
ಛೇ, ಛೇ,
it is
ಛೇ,
the
ಛೇ.
case.
ಭಾರತಿ ಏರ್ಟೆಲ್ ಬೇರೆ, ಇಂಡಸ್ ಬೇರೆ.
ಅವ್ರು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ.
See, a company, right from the days of Solomon versus Solomon, I think 1600 judgment. They said company is different, the shareholders are different, directors are different. ಅಂತ hold ಮಾಡಿದ್ದಾರೆ. Very old judgment which we used to study.
I will file my
which summoned on jurisprudence, any standard book on jurisprudence.
ಭಾರತಿ ಏರ್ಟೆಲ್ ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಬೇಡ ನೀವು ಹೋಗಿ ಅಂತ.
All right. Very good.
In that petition, my lordship. Regarding that petition, my lordship,
Ah,
that I think it's a dispensing versus union of.
correct. Correct.
Serial number 29, man.
ಹಾ,
Short accommodation.
ಶಟ್ರ್ ಸಾಮಾನ್ಯ ಅಕಾಮಿಡೇಷನ್ ಕೇಳಲ್ಲ. ಯಾವತ್ ಬೇಕು?
Any convenient.
Next week ಆಗಲ್ಲ, week after next ಹಾಕೊಳ್ಳಿ. At the request of. Result judgment ಕಳ್ಸಿ.
ಇಲ್ಲ ತಗೊಳ್ಳಿ. ಮಾಡ್ತೀರಾ?
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಯಾವುದಕ್ಕೆ ಕೇಳಿದ್ರು?
ಏನ್ ಮಾಡಿದ್ರು ಇದು? ಎಂತ? ಇಲ್ಲ ಇಲ್ಲ ಹಾಕ್ಬೇಕು ನೋಡೋದು. ಡೇಟ್
ಪಾಸ್ ಓವರ್ 230 ಪಾಠ ಏನಾಯ್ತಾ ಮಧ್ಯಾಹ್ನ? ಪಾಠ ಓಕೆ.
ಮೆನ್ಷನ್ ಮಾಡಿದಾರಾ? ಮೆನ್ಷನ್ ಮಾಡಿದಾರಾ? ಯಾವಾಗ? ಜಿಯೋ ಆಗಿಲ್ವಾ? ಹೌದಾ? ಹೌದು, ಅದೇ ತಗೊಂಡು ಹೇಳಿದ್ದಾರೆ. ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ, ಇವ್ರು ಇರ್ತಾರೆ. ನಿಮ್ದೇನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್? ಹೌದು, ನಾನೇ ಹೋಗಿ ಹೇಳಿದೆ ಸರ್, ಕೆಳಗಡೆ ಅಂದ್ರೆ ರಿಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಲಿಕ್ಕೆ. ಥ್ಯಾಂಕ್ ಯು. ಎಸ್
ಏನ ಕೇಸಲ್ಲಿ ಏನೇನೋ ಸುಮ್ಮನೆ ಕೇಸ್ ಆಗ್ತವೆ ಸ್ಟಡಿ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ನಾನು ಓದಿದ್ದೀನಿ, ಬಟ್ ಸಿನ್ಸ್ 24 ಬರ್ತಾ ಇರಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಇರಲ್ವಾ ಸರ್?
O'clock, 2:30 ಬರ್ತೀನಿ.
ಹಾ ಬನ್ನಿ. Thank you.
And with regard to mandate extension, there's a judgment of the Supreme Court which says that only civil court can do it. And that's where the difficulty I was trying to make.
No difficulty. If both the sides are agreeable, since you agreed that some other person be appointed without going into this one, and you gave the names also. You gave the names also. You also gave the
Yes, Madam.
name.
Yes.
And when with those names you are not agreeable, in principle, that some new arbitrator should be appointed is your stand.
That's no further merits. I would not say no further.
What's your stand?
I stand by what my.
Do you want to argue on merits or
No, my
what?
lord, no, no, my lord.
That's, in that case, that's whatever my learned friend has given a suggestion, that can be agreed upon.
Which one?
ಅದು blue ink ಬರ್ದು ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಅದು ನಾವು
But I leave it to my lord, my lord.
ಏನ್ ಬೇಡ ನೀವು ಮಾಡ್ಕೊಟ್ಟಿದ್ದು ಒಪ್ತೀವಿ ಅಂತ ಹೇಳ್ಯಾರಲ್ಲ ಅವ್ರು.
Last time ಹಂಗೆ ಆಯ್ತು. It was their
The
suggestion.
reason,
change
my
ಮಾಡೋದು
my lord,
ಹೋಗ್ಬಾರ್ದು.
my submission is, my lord, let this court appoint the arbitrator because, my lord, tomorrow, we do not want that I and my friend should otherwise disagree. Let this court appoint any.
But he is in all.
I leave it to my
saying we are agreeable to the name which you have suggested.
I thought it is better that it comes to this bench. It is always better.
Coming to
So
a
that
bench only, no?
I would press with my request, my lord, that this court be pleased to appoint any arbitrator, my lord, I stand by.
And a time frame may be fixed, my lords, because it's at the last leg, my lords, where I have to be cross-examined. I am the respondent before.
ಅಲ್ಲ ಇಲ್ಲಿವರೆಗೆ ಏನಾಗಿದೆ ಅದು ಹಂಗೆ ಉಳಿತಲ್ಲ
ಅಷ್ಟೇ.
Yes.
ಯಾವ್ದನ್ನು ಅಪ್ಲಿಟ್ರೇಟ್ ಮಾಡಲ್ಲ.
Yes.
Because he is one of the tall judges,
Yes, ma'am.
former judge of this court.
Please, my lords.
ಇಂಥವೆಲ್ಲ ಇಶ್ಯೂ ಮಾಡಿಕೊಂಡು ನೀವು ನಾಳೆ ಯಾರು ಆರ್ಬಿಟ್ರೇಷನ್ಗೆ ಬರಲ್ಲ. ಎಲ್ಲ ಮಾಡಿದ್ರು ಒಳ್ಳೊಳ್ಳೆಯವರೆಲ್ಲ ಎಲ್ಲ ಕೆಟ್ಟ ಜನರು ಜೊತೆ ಆಪರೇಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಅಷ್ಟೇ.
Can go with this suggestion, my lords. We can go with Sunil sir's, Dr. Sunil Shastri's suggestion.
ಅಲ್ಲ ಬಿಡಿ ಅವ್ರದ್ದು ಬೇಕು ಅಂತ ಇಟ್ಕೋಬೇಡಿ. ನಾವ್ ಇನ್ನೊಂದು
ಅಲ್ಲ. Leave to the court.
ಅವ್ರು ಹೇಳಿದ್ದು ಒಪ್ಕೊಂತಿಲ್ಲ ಈಗ. Because he said it was just got ಮಾಡ್ಬೋದಾ?
I do.
ನೋಡಿ
Yes, ma'am.
ಮಾಡ್ಬೋದಾ?
Yes, ma'am.
As mentioned, my lords, it's too young at the bar, so I've not appeared before anyone.
ಮತ್ತ ಅವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡೋದು ಮಟ್ಟದು
ಇಲ್ಲ,
ಮಾಡಂಗಿಲ್ಲ.
ಇಲ್ಲ, ಇಲ್ಲ, not at all.
That's an one
ನಾವು
more
appoint-
request.
ಅದು ನಮ್ಮ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡ್ದಂಗ.
No, no.
Let them not
ನೀವು
take,
ಹೇಳಿದ್ರಿ ಅಂತ ನಾವು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ವಿ ನಾವು
ಇಲ್ಲ, ಇಲ್ಲ, no, ma'am.
ಅಂತ ಅನ್ಬಾರ್ದು ನಮ್ಮ ಮೇಲೆ.
let them not take this as a ground, my lords, in case whatever might be the outcome of the arbitration proceedings, my lords. This should not be a ground that arbitrator change ಅದು ಅಂತ section 30.
ತೊಡಂಗಿಲ್ಲ.
ಇಲ್ಲ, ಇಲ್ಲ, I will not.
Huh?
I will not take it.
At the preliminary round of hearing, parties were asked to suggest. Parties agreed to, parties suggested two names, each not agreeing with the other. First off, we need not mention the name of arbitrators. Those arbitrators. First off, matter was passed over in the morning session so that they can think again and come back in the meanwhile. First off. Next paragraph. Both the sides standing tall at the bar agreed that Shri so and so be appointed as the new arbitrator who would continue with the proceedings, treating everything on record as continuing with impunity. With impunity. First off, counsel for the petitioner on instructions agreed that he would not make the appointment of new arbitrator in any circumstance as one of the grounds
The 34.
for laying a challenge to the outcome of proceeding,
Yes, my lord.
outcome of proceeding. Full stop. Next paragraph. In view of above development, ಅದಕ್ಕೆ ಏನ್ ಮಾಡಕ್ಕೆ ಈಗ ಇವನ್ನೆಲ್ಲ ಬರ್ದಿರಲ್ಲ ನೀವು ರೆಕಾರ್ಡ್ ನಲ್ಲಿ.
Without reference to that, my lord.
Both the sides agree that the petition and the documents accompanying the same be permanently kept in a envelope, and copies thereof shall not be issued anyone except with the, save with the leave of the Honorable Chief Justice. ಅಥವಾ ಯಾರ ಲೀವು ಬೇಡ ಅಂತ ತೆಗೆದಿಟ್ಕೊಂಡು, because that arbitrator is a tall arbitrator.
In fact, if they can even not press the prayer A, my lords, prayer B is what my lords have done.
That's all. Nothing in the petition or in this order shall be construed as casting any aspersion whatsoever on the learned arbitrator, Honorable Justice so and so, as agreed at the bar.
Time limit, my lords. It's almost.
The new arbitrator is requested to assume charge at the earliest and dispose of the arbitration proceedings within a period of
15 to 30 days. my
Hey.
lords. 15, 30.
ಅವ್ರಿಗೆ
crossing them.
ಈಸ್ ಆಲ್ಸೋ ವೆರಿ
Nice.
ಮತ್ತೆ ಅವ್ರದ್ದು ಇದು ನಿಮ್ದು ಕಡಿಮೆ ಬೇಕಾಗ್ಬೋದು, ಬಟ್ ಬೇರೆ ಕ್ಯಾಲೆಂಡರ್ ಎಲ್ಲ ನೋಡ್ಕೋಬೇಕಾಗತ್ತಲ್ಲ.
6 months. my lord.
Within 6 months ಮಾಡ್ಲಾಗ, within 3 months, 3
3
months,
months, great.
within an outer limit of 3 months, subject to all just exceptions.
Grateful,
That's grateful.
grateful.
ಮುಗಿಸ್ತು, ಒಳ್ಳೇದಾಯ್ತು.
Obliged.
Lords,
ಇಲ್ಲ,
can I just
petition
place
is
those
ordered
judgments?
accordingly and petition is disposed of.
Can I just give those judgments, my lords, if in case in
ಏನು
future?
ಬೇಡ ನಮ್ಗೆ.
ಈ ಕೇಸ್ ಕಲ್ಲ. ಇದಕ್ಕೆ
ಬೇರೆ
ಏನಾದ್ರು-
ಕೊಡಿ, ಏನ್ ಬೇರೆ ಕೆಲಸ ಇಲ್ಲ, ಓದ್ತೇನೆ. ಕೊಡಿ.
We have prepared it also. Grateful.
ಎಂದು ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ the stand of both the sides is recorded in the in the live stream proceed, in the record of are available in the record of live stream proceedings of this court. ನೀವು ಗೊತ್ತಾಗಲ್ಲ, ನೀವು ಅಲ್ಲಿ ನಾವು ಪಾರ್ಟಿ ಅಲ್ಲ ಏನಿರಲ್ಲ, ಜಡ್ಜ್ಗಳು ನಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ತಾರ, ಏನ್ ಹಿಂಗ್ ಹೇಳ್ತಾ ಇದಾರೆ ನೋಡಪ್ಪ, ಏನ್ ಅಂತ ಅನ್ಕೊಂಡು ನಮ್ ನೋಟಿಸ್ ಕೊಡ್, ನಮ್ಮಿಂದ ಏನ್ ಹೇಳ್ಕೊಂಡ್ರು ಗೊತ್ತಾಗಲ್ಲ.
Grateful.
ನನ್ನ ಒಂದ್ ಸ್ವಲ್ಪ ಅದಕ್ಕೆ ಇದು ಜಸ್ಟ್ ಫ್ರೇಮ್ ಆಫ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದು,
I will have a look.
ಆ ರೀತಿ ಮಾಡಿ ಸ್ವಲ್ಪ ಬದಲಾವಣೆ. ಓಕೆ,
Please.
My lord, only on the market value, I will just give some documents. The market value as per the guideline value, which was fixed by the government last year, September, is 200 rupees per square foot.
ಅದ ರೀತಿ ತಂದು ಕೊಟ್ಟು ನೀವು ಕೊಟ್ಬಿಡಿ, ನೀವು ಒಂದು ತಗೊಂಡು ಕೊಟ್ಟು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಬಗ್ಗೆ ಯಾಕೆ ವರಿ ಮಾಡ್ತೀರಿ? ಇಟ್ಸ್ ಎ ಕಾಮನ್ ಸೆನ್ಸ್ ವಿಚ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟೇಕನ್ ನೋಟ್ ಆಫ್. ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂಸ್ ಇನ್ ದ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂಸ್, there is a lot of difference between these two. Tangabalam versus Swines. See that judgment so beautifully, very pragmatically it is. ಅವೆಲ್ಲ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. ನೀವು ಅವ್ರು ನಿಮ್ಗೆ ನಾವು ಕೇಳಿದ್ವಿ, ನೀವು ಹೇಳಿದ್ವಿ 10 ರಿಂದ 15 ಲಕ್ಷ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿ, ಇವರು 15 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ, ಅಷ್ಟಾಗ್ತದೆ ಅಂತ ಹೇಳಿ, ಹೌದಾ?
But ಅಷ್ಟಿಲ್ಲ ಅದು.
Lord,
Not even 10% of it.
Lord,
ನಿಮ್ಮವರು ಹೇಳಿದ್ದು
ಇಲ್ಲ, ಅದು ನಾನು ಮಾಡಿದ್ವಿ, ನಾವೀಗ ಚೆಕ್ ಮಾಡಿದ್ವಿ, ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ನಾನು ಹಾಕಿರೋದಕ್ಕೆ 200 rupees per square.
ಇದು ಅವೈಲೇಬಲ್ ಇದೆ.
True, but that he doesn't know the value there, but
ಹಂಗಾರೆ ನೀವು ಕಡಿಮೆ ಇದ್ದಿದ್ದನ್ನು ತಗೊಂಡು ಕೊಟ್ಟು ಬಿಡಿ ಅವರಿಗೆ.
Lord, I inquired with the contractor. He
Huh?
told me that 1,800 rupees for square feet, 21 lakh 660,000 rupees is going on in that area, that is Vinayakanagar.
Not,
Because my lord, it's a highway, my lord, towards Pavagada. It is very much available and
ಅಲ್ಲೇ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಹೆಂಗಾಗತ್ತೆ?
allala,
ಒಂದು
ಅಲ್ಲಿ-
some
as on today, my lord.
solution.
please, my lord.
ನೋಡಿ, ಆ ಶೇಕ್ಸ್ಪಿಯರ್ ಮರ್ಚೆಂಟ್ ಆಫ್ ವೆನಿಸ್ ನಲ್ಲಿ ಪೋರ್ಷಿಯಾ ನೈಫ್ ತಗೊಂಡ್ ಮಾಡ್ಕೋ, ನಾಟ್ ಇವನ್ ಎ ಡ್ರಾಪ್ ಆಫ್ ಬ್ಲಡ್, ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ
ಇಲ್ಲ,
ಬರ್ತದೆ.
ಅಲ್ಲ.
ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅನ್ನೋದೇ ದಿ ಮೆಸೇಜ್ ಆಫ್ ದಿ
ಅಲ್ಲ sir,
ಡ್ರಾಮಾ.
ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದಿದ್ದು. ಅಂದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಆಗಲ್ಲ. ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಲೆಕ್ಕ ಹಾಕಿದ್ರು 21 lakh 60,000.
ಕೈ ಬಿಡಿ,
15 lakhs we are ready, my lord.
ಕೇಳ್ಬಿಟ್ಟು ನಮಸ್ಕಾರ. ಕೂತ್ಕೊಳ್ಳಿ, ಕೂತ್ಕೊಳ್ಳಿ, ಕೂತ್ಕೊಳ್ಳಿ.
As your lordship suggested, 15 lakhs we are ready, my lord.
ಇಲ್ಲ
Will
sir,
receive.
ಅಷ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ. ನಾನು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಡಬಲ್ ತಗೊಂಡು, ಗೈಡ್ ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಡಬಲ್ ತಗೊಂಡ್ರು 5 lakhs ಬರ್ತದೆ.
ನೀವು ತಗೊಂಡು ಕೊಟ್ಟು ಬಿಡಿ,
ನಾನು ಅದನ್ನ ಹೇಳಕ್ ಬಟ್ ಈ 15 lakhs ಅದು ಇಲ್ಲೇ ಇಲ್ಲ.
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇವೆ, ನೀವೇನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ,
First,
ಕೊಡ್ರಿ.
please.
ಕೊಡಿ. Dismissed, reasons to follow. Yes.
Grateful.
May I argue, my lord?
What is that? You are wasting time of the court.
No, not at all. I will just say, what is the argument?
Therefore, we have dismissed.
Please.
Lord, I should be given an opportunity to say
What
something.
opportunity? We have come.
Lordship in the
What is
morning
this?
said.
Your
No,
appeal
no.
is over? Review is over?
No, my lord. Lordship said, can you make it very short? Therefore, I propose this.
All right, argue, ಕೊಡಿ.
I had not argued on,
All right, argue. Argue.
Lordship may kindly go to the consumer complaint prayer 122, page number annexure G.
ಟೂ 2017 ಅವ್ರು ದುಡ್ಡು ತುಂಬ್ಯಾರ.
Yes, my lord.
ಅವರು ಟೀಚರು
ಹೌದು.
2,500 ರೂಪಾಯಿ ಅಂತ ತುಂಬ್ಯಾರ, ಕೆಲವು ಡಿಫಾಲ್ಟ್ ಇತ್ತು, ಅದನ್ನ ಮೇಕ್ ಗುಡ್ ಮಾಡ್ಯಾರ.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು 1.5 ಲಕ್ಷ, 2.5 ಲಕ್ಷಕ್ಕೆ.
ಆಮೇಲೆ ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ಏನು ಅಂದ್ರೆ,
ನಾನು ಯಾವ್ದು ಲೆಕ್ಕ ಹಾಕ್ತಲ್ಲ ಸ್ವಾಮಿ, ಐ ಆಮ್ ಗಿವಿಂಗ್ ಮ್ಯಾಕ್ಸಿಮಮ್.
ಅಲ್ಲ ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ಏನು ಅಂದ್ರೆ
ಹ್ಮ್.
ಸೈಟ್ ಅವೈಲೇಬಲ್ ಇಲ್ಲ ಅನ್ನೋದು ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್.
Yes.
ಹೌದು,
ಆ ಸ್ಟ್ಯಾಂಡ್ ಎಲ್ಲೂ ತಗೊಂಡಿಲ್ಲ.
ಹೌದು, ಒಪ್ಕೊಂಡೆ. ನಾನು ಯಾವ್ದನ್ನು ಹೇಳ್ತಾ ಇಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಷ್ಟೇ ಸ್ವಾಮಿ, 2.5 ಲಕ್ಷ ರೂಪಾಯಿಯ ಸೈಟಿನ ಬೆಲೆಗೆ 1.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೆಲ್ಲ ಬಿಟ್ಟು ನಾನು ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಐ ಆಮ್ ಗಿವಿಂಗ್ ಇಮ್ ಅಟ್ ರೇಟ್ ಆಫ್ 2,200 rupees per square foot ಬದಲು 400, ವಿಚ್ ಇಸ್ ಟ್ವೈಸ್ ದಟ್. ಈವನ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇದ್ರೂ 60% ಜಾಸ್ತಿ ಇರ್ಬೋದು. ನಾನು ಅದೇ ಮಾತಾಡ್ತಿದ್ದೆ, ಗೈಡ್ ಲೈನ್ ವ್ಯಾಲ್ಯೂಗೂ ಮತ್ತು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಡಿಫ್ರೆನ್ಸ್ ಇದೆ. 200 ಬದಲು 400 ಮಾಡ್ಕೊಡ್ತಾ ಇದ್ದೀನಿ ನಾನು.
ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ
400 ಮಾಡೋನು ಅವ್ರಿಗೆ ಅಷ್ಟು ಬರ್ತಾ ಇಲ್ಲ.
ಮಾರ್ಕೆಟ್
ಅವ್ರು 15 ಲಕ್ಷದ ಹೇಳ್ಬಿಟ್ರೆ ಇಲ್ಲ ಆಗಸ್ಮಿ.
ನೀವೇ ತಗೊಂಡು ಕೊಡ್ರಿ.
ರೆಡಿ ಇದೀನಿ ನಾನು, ಅದು ರೆಡಿ ಇದೀನಿ. ಇಫ್ ದಟ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್, ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಹೌ ಟು ಎನ್ಫೋರ್ಸ್ ಇಟ್ ಅಷ್ಟೇ. ನಾನು ತಗೊಳ್ಳೋದು, ಇವ್ರನ್ನ ಕರಿಬೇಕು, ಸೇಲ್ ಡಿಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್. ಐ ಆಮ್ ಓನ್ಲಿ ಆನ್ ದಟ್. If that entire matter gets over by money, it's easiest. He can buy it himself. If that is the offer, as Justice Joshi put it, I'm ready. If that is the alternate offer, I had to go search, get it, give it to him. Court has to pass an order to that extent.
That's 5 years back, he himself has sold the same measurement for rupees 8 lakhs for 30-40 only.
ಅಲ್ಲೇ
ಹೌದು. He
ಅಲ್ಲ,
himself,
ಇದೆಯಾ?
my lord, we will produce those sale deeds.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು.
We have our sale deeds, my lord. We will produce it, my lord. And moreover, my lord, today, my lord, today when my client has inquired, 1,800 square feet is going on, 21 lakh 60,000 it will come. For that, my lord, we are ready even for 15 lakhs also. He doesn't want to give even alternative site in that area.
ಅವರು 15 ಎಷ್ಟಕ್ಕೆ ಮಾರಿದ್ದಾರೆ? 8
8
lakhs.
ಲಕ್ಷಕ್ಕೆ ಅದು 5 ವರ್ಷದಿಂದನೇ ಮಾರಿದ್ದಾರೆ. 19 ಅಲ್ಲೇನೆ. When complaint was pending.
ಅದೊಂದು ಕಾಪಿ ಕೊಡಿ. We'll call this matter tomorrow.
Lord,
Day
we'll
after
produce
tomorrow.
it day after tomorrow. Please,
Call this matter for further hearing
please.
day after tomorrow.
Grateful.
Stay with this. ಈ execution ಒಂದು ಇದೆ,
Execution
ಅದಕ್ಕೆ.
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord.
ಪ್ರೆಸ್ ಮಾಡಬಾರ್ದು.
Please. Grateful.
My lord would be pleased to see page 232 of my volume 1 of my appeal memo. I had made an application for change of land use in the year 2018, my lord.
Yeah.
This is the third round of litigation. The planning authority in the first instance did not decide my application. Second instance rejected it, which was set aside by the learned single judge. And then now, my lord would see at page 232. If my lord would see the index on the far right of the page.
What was the case about?
It's for an application for change of land use, my lord. In this, it says that in the
It's filed under which provision of which law? 95?
section 14A of the
14A of
Karnataka Town and Country
Town
Plan.
and country planning.
My lord, my
That
lord.
was
would see it-
rejected.
It was rejected, my lord, because it says in
One
the.
second, we are putting few questions. After
Yes.
reading, we are
Yes,
asking you.
yes.
It was rejected on what ground?
My lord, in the first instance, it was rejected on the ground that there was no access road.
No
My lord,
access road.
sitting single, had decided this matter and had remanded it to the Tahsildar, asking for a verification of whether or not there is an access road. All other grounds on which my application was rejected was quashed. The Tahsildar files a report saying that there is a 10-meter access road from my property to NH 209. Thereafter, they rejected, my lord, on the ground that there is quarrying activity near my property. The learned single judge finds that the quarrying activity is more than 100 meters away from my property, so therefore it does not attract the bar under the KMMC rules. Then, my lord, the learned single judge rejects it on the ground that the town planning map reserves 0% of the land for agriculture, and therefore finds
What?
that, my lord, if my lord would only see page 232 for a minute.
232.
My lord. If my lord would see the index on the far right of the page on 232, the third square, my lord, which says proposed land use analysis, Harohalli conurbation. 232.
Yes.
And it says agriculture 0%, which means the proposed land use analysis for Harohalli conurbation, my lord, is that 0% of the land will be used for agriculture eventually. But the court
Hey,
finds.
one sentence. Stop. We have to process your sentence.
It says master plan 2031 for Kanakpura local planning area. Then there's a key map, my lord. Then there is the index. Then there is the proposed land use analysis in Harohalli conurbation. There it says land use, residential, commercial, industrial, public and semi-public, park and open space, public utility, transportation, agriculture. My lord would see residential is 33.24% that the planning authority assumes will be used of the conurbation area. Residential use will cover 33%. Commercial is 4.24%, my lord. Industrial is 29.67%. Agriculture is 0%, my lord.
Means what?
Means that by 2030, but the proposed land use is that all agricultural land will eventually be utilized for one of the other purposes.
Not other than an
So
agriculture.
the learned single judge has assumed that 0% of agricultural land will be permitted to be converted. That cannot be, it says proposed land use analysis, my lord. That is the proposed land use.
Proposed possible land use analysis.
Land use. That is what the master plan is providing for. It says that eventually in the proposed.
It should have gone in your favor.
It should have
not
gone in my
against
favor.
you.
Yes, my lord. The learned single, if my lord would see the reasoning at
Where
page
is the
40.
reasoning?
At page 40. May I read, my lord, para 21?
Second. Though the contention of V.V. Shukman and the council by referring to development planning that 0% of that area has been reserved for development. Any restriction on usage? I am unable to agree with the submission of that 0% development shown as regards the proposed usage by the planning authority. And in this case, the planning authority is not proposing to use any of those land for any development activity, but has remarked the same only for. This reasoning appears to be defective.
My lord, in respect of my respectful submission is, my lord, 0%, my lord, those who are land is not within the conurbation area. Conurbation area means, my lord, definition is there in the Karnataka Town and Country Planning.
Now, on what ground you denied a conversion facility?
Because of, my lord, there are 8 grounds are there, my lord, in the impugned order.
Now, out of 8,
Please, my lord,
when it came before me, when sitting as single judge,
please.
I had remanded the matter for consideration afresh with regard to one ground, that is whether there is access road or not.
Please, ma'am.
So rest of the 8, that is 7 will pale into
Say
insignificant.
that, my lord, all contention kept
Are kept open.
kept open, my lord.
But my lord.
Fresh consideration is there. And also, my lord, based on, my lord, at the time of during the pendency of the writ petition, this honorable court directed the Mines and Geology Department to file a report. And that regard, my lord, kindly see 602 of the
May I,
page number 602, volume number 3, my lord. Volume number 3, my lord. The filed affidavit, my lord,
Saying,
saying that, my lord, may I read, my lord, that paragraph, especially that paragraph. Page number 604, para number 7. We start from, my lord, 602. May I read, my lord?
para number
7. I state,
4. I state that.
my lord, with regard to query number 3, stone quarrying activities are permitted, and at the present there is 4 queries activities carrying the boundaries of on the date. The details of the queries as enclosed along with affidavit document number 1, 2, 3, 4. Further mining activities valid up to 2036. Renewal so and so. I stated that regard to query number of blasting activities as per the license given, present 4 mining owners blasting activities are permitted. The permission for the blasting activities as per the provision, rule 602 of the Karnataka Mines and
Mineral concession.
Mineral Concession Rules 1994, as per the renewal condition of lease issued the present 4 mining owners, point number 1 and 1 subclause 10. It is mentioned that the stone quarrying activities involved the blasting and also permitted the same. And that is the reason, my lord.
Who is this lady,
Lord, the special
theologist?
authorization. And also, my lord, kindly see the photographs, my lord, the lands of the,
No, 1 second.
May I
That's in
respond?
process, ma'am.
please, please.
Your contention is blasting activities ಎಲ್ಲ ಆಗ್ತದೆ ಹಾಗೆ ಈ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಕನ್ವರ್ಷನ್ ಕೊಟ್ರೆ it will expose the residents to the danger ಅನ್ನೋದು
Please,
ನಿಮ್ದು.
please. And also, my lord, there's tomorrow they will come say that, my lord, ಅವ್ರನ್ನ ಕ್ಲೋಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. ಯಾಕಂದ್ರೆ 2036 ತನಕ ಅವ್ರಿಗೆ ರಿನ್ಯೂವಲ್ ಇದು ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ.
may I meet
And
that
tomorrow, my
contention?
lord, not ಸಣ್ಣ ಸೆಗ್ಮೆಂಟ್ ಇಲ್ಲ ಅದು, ತುಂಬಾ ದೊಡ್ಡ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ.
May I meet that contention?
Kindly be seated. Be seated. I'll hear you. We will not pass any adverse order
I
without
apologize.
hearing you.
I apologize.
Please be seated.
I apologize.
Resist your temptation to argue. Please be seated.
I apologize.
Please be seated. Sit down. Yes. ಇದೇ ರೀತಿ ಇರೋ ಬೇರೆವೆಲ್ಲ ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಇದೇ ರೀಸನ್ ಕೊಟ್ಟಿಲ್ಲ, ಉಳಿದದೆಲ್ಲ ನಾವು ಆತರ ಅವ್ರು ತೋರಿಸ್ಬಿಟ್ಟು ನಾವು ಹೇಳ್ಬಿಡ್ತೀವಿ ಸ್ವಾಮಿ.
ನಿಮ್ಗೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾವು ನಿಮ್ ಕೋರ್ಟ್ ನಿಂದ ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
ಪಕ್ಕದಲ್ಲಿರೋದು ಯಾವ್ದು?
ಇದೇ ರೀತಿ ಇರೋ ಸಿಚುವೇಶನ್ ದಲ್ಲಿ
ಪಕ್ಕದಲ್ಲಿ
have you denied as per your records, have you denied the permission facility, conversion facility?
Why? Because I have stated that, my lord, as per the remand by this honorable court.
No, you are not answering the question.
Please, my lord.
This question
Please, my lord.
admits binary answers. You can
Please.
explain.
Please.
Yes or no is the binary answer.
Please.
We are asking you.
As per instructions, my lord, we are not given any permission.
You have not given any permission
Please,
to
please.
anybody in the given circumstances.
Please, my lord.
Whether this is one of the reasons which you stated in the denial order?
Please, my lord. ಅಲ್ಲ, ಅದು ತಾವು ಒಂದ್ಸಲ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಓದ್ಬಿಟ್ರೆ ನಾವು ನಿಮ್ಗೆ ಅದು ಕ್ಲಿಯರ್ ಆಗ್ಬಿಡುತ್ತೆ.
ನೀವು ನಂಬೋದು ಬೇಡ ನಾವು.
ನೋ, ಅಲ್ಲ, ಅದು ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಹೋದಾಗನೇ ಬ್ಲಾಸ್ಟ್ ಆಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಬರ್ದಿದ್ದಾರೆ.
Okay.
At the time of, my lord, inspection, some explosion has been.
Yes, madam, what do you say?
May I take my lord to paragraph 35 of the impugned order? That 34, if I may be permitted to read from paragraph 4. The
Paragraph?
answer, the court, paragraph 14, my apologies. Paragraph 14 at page 34. Paragraph 14, the court considers the endorsement.
Internal page.
Internal, paragraph
12.
34, page 34, paragraph 14. Page 34 of my appeal memo.
Internal
volume
page, my
1,
lord, 12.
Internal page number 12, paragraph 14. That is where the court considers the planning authority's contention. Then at paragraph 15, the court answers the contention, which is on page 35. In view, if I may be permitted to read paragraph
Of
15.
rule 6(2).
The safer zone now being 100 meters in respect of quarries where blasting activities are taking place, though the contention of respondent number 2 at the time of rejection was correct, today that aspect would not arise for consideration since the distance of the property in question is more than 100 meters. Therefore, restriction under rule 6(2) of the KMMC rules would not be applicable to the property of the petitioners.
So
Thus-
that has been held in your favor.
Yes, my lord. And if I may just point out at paragraph 15 of my appeal memo, if my lord would only consider for a moment, page 15 of my appeal memo, my lord. The affidavit that my friend read out is an affidavit dated 22/2/2023. My lord would see that a geologist from the Department of Mines and Geology had filed that affidavit. At page 15 of my appeal memo, for the convenience of this court, I had extracted it in the appeal memo.
Page 15.
Yes, my lord. Which is at subpoint 4 of paragraph 17. This is the affidavit that my learned friend read from. What he did not read, my lord, is the next paragraph 18. Thereafter, pursuant to order dated 23/6/2023, passed by the learned single judge, the additional director of land records, ADLR Kanakpura, carried out a survey and filed the following report dated 1/7/2023, setting out the distances between the lands belonging to the appellants and the quarries in question. That report, I have extracted the table from that report, my lord. My lord would see there is a complete variance in the distances.
Beyond 100 meters.
Beyond 100 meters, whereas only in order to bring this within the rejectable framework, Manjunatha Stone Crushers is held in survey number 277 to be 95 kilometers from my land, whereas in
95
ADLR
kilometers.
Sorry,
meters.
95 meters, my apologies, 95 meters. Whereas the ADLR's report, my lord, which has been carried out under direction of the learned single judge, shows that it is in fact, Manjunatha Stone Crushers is 139.60 meters.
Not 95.
Not 95, because it was not done.
Adeli there.
It is on page 16, 277, if my lord would see. I've listed the survey numbers in the left-hand most column. 277, Manjunatha Stone Crushers is 139.60. The learned single judge takes note of this, my lord, and dismisses the claim, and rejects the ground of rejection.
Your
by the
ground is
planning
not
authority.
accepted by the learned single judge.
Lord, on that point, my lord, the honorable court directed to the petitioner to file affidavit to whether if you have, my lord, developed the land with this kind of the lacuna, we will be noticed to the third party. Lord, kindly see, my lord, page number 40, impugned order, 41, my lord.
Allah, ultimately, learned single judge denied relief.
Please,
On what ground?
to say that, my lord, that not filed affidavit. Tomorrow, my lord, to say that they will say, my lord, to adjacent land is concerned, there is a query is there. Development.
Meters are beyond it there.
Allah, in respect-
139.60
Allah,
meters.
first 200 meter ittu. Thereafter, my lord, is amended on 100 meters. At the time of filing, idak 200 ittu.
ಅವಾಗ ಏನ್ರ ಇರ್ಕೊಳ್ಳಿ ಈಗ ಅಮೆಂಡ್ ಆದ್ಮೇಲೆ ಏನ್ ಅದ್ ನೋಡ್ತೀರಾ
At the time of, during the pendency, my lord, the amend ಆಯ್ತು.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗ್ತದೆ.
Please, I'm not disputing that, my lord. May say that, my lord, kindly see, my lord, page number, my lord, 41, my lord. May I read, my lord, para 22,
22.
please.
A perusal of the above would indicate.
The perusal of the above would indicates that the authority has to decide to.
Plan development of land needs to say change of land is an exception to it, which is required for the authorities to specify.
22 and 23, man.
23.
And 23.
These are consider. No, this I can comply with, na, this affidavit
Yeah,
requirement.
The Kagalahalli Gram Panchayat, within whose jurisdiction I'm situated, has given an NOC stating that it has no objection to grant civic amenities.
No, that's all right. But
Even-
this learned judge says, kindly read that.
My lord, to file an affidavit if the petitioners were not interested in obtaining civic amenities for now. And also that they would inform the probable purchasers of the safety hazards which have been enumerated by the
Please.
planning authority.
ಅಂತ
May I
affidavit
just make,
ಹಾಕೊಳ್ಳಿ.
may I just make two submissions in this regard, my lord? The Karnataka minor mineral rules basically states that no quarry can come up within 100 meters of an area in which building is there. It is not a requirement under the Town and Country Planning Act. my lord would see that in fact on 8/2/2018, my application is made in January of 2018. 1 month later in February, they take out paper publication as per the requirement of section 14A. Their own website and their own requirement states that paper publication is only taken out after prima facie application of mind, my lord, that my application is in fact fit for consideration. Under the KTCPA, there is no requirement that they can't grant change of land use within 100 meters of a quarrying zone. Under the minor mineral rules, it states that no quarry license can be granted unless it is more than 100 meters away from a quarrying zone. The civic amenities are not provided by the planning authority, my lord. They're provided by the Gram Panchayat. And the Gram Panchayat has given me an NOC in January of 2018, which I had filed along with my application. That is at page 85 of the appeal memo. This, my lord, this affidavit and this requirement that my lord, if I'm developing a residential layout over there and I say that I will advertise that there is quarrying activity carried out beyond a 100-meter radius, my lord, and some of these quarries are not even active anymore. Their concern appears to be that ultimately somebody may seek a cancellation of the quarry license. So therefore, I must advise all the prospective purchasers that there are quarries so that they do not go and seek cancellation of a quarrying license. So it's speculative, my lord. It's purely speculative. My lord, they're basically forcing me to depress the value of my land and of my property when no such requirement, their own guidelines, my lord, which they've produced and which my lord had considered on an earlier occasion. It is at page 204, if my lord would
But
see.
all contentions are kept open, na?
My lord, but my lord returns a finding saying that all the other considerations which they had taken were all unsustainable. There is a finding. The court remands the matter for reconsideration in respect of the access road. And their own guideline says that if there is an access road, then change of land use is permissible.
ಬ್ಲಾಸ್ಟ್ ಆದಾಗ ಎಷ್ಟು ದೂರ ತನಕ ಸಿಡಿತದೆ ಅದೆಲ್ಲ ಸಾಮಾನ್ಯವಾಗಿ
100 meter, 200 meters ಒಳಗಡೆ ಆಗುತ್ತೆ. Based on the my lord, ಅದ್ರ ಮೇಲೆ ಇದ್ರ ಮೇಲೆ
ಹಂಗಾಗಿ ರೂಲ್ ಮಾಡಿದ್ದಾರೆ.
Please, my lord.
100 meters ಮಾಡಿದ್ದಾರೆ ಈಗ.
In respect of, that is a particular case, my lord. That is a particular.
200
ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರಲ್ಲ, ಇಷ್ಟೇ ಮಾಡಬೇಕು.
ಹೀಗಾಗಿ 100 degrees ತನಕ ಅಂತಾರೆ. Which is that rule? 100 meters ಅಂತ ಹೇಳೋದು ಯಾವ ರೂಲ್ ಅದು?
Not concession rule, maintenance jewelry.
ಕೊಡ್ರಿ.
Karnataka minor minerals concession rules.
KMMC rules ಕೊಡಿ.
14A is, my lord, very clear. Only topographical, cartographical changes ಮಾತ್ರ consider ಮಾಡಬೇಕು. Topographical, cartographical changes ಇದೆ ಮಾತ್ರ consider ಮಾಡಬೇಕು.
Proposal? ಮೈಕಿಗೆ ಸರಿಯಾಗಿ ಹತ್ತಿರದಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ಮಾತಾಡಿ.
14A is, my lord, very clear is there, my lord. Only cartographical, topographical changes ಇದ್ರೆ ಮಾತ್ರ consider ಮಾಡಬೇಕು ಅಂತ ಇದೆ. And that basis, my lord, Honorable Apex Court has been decided. Decision is also there. To regarding that, my lord, when the change of land use will be considered.
No, you have given ABCD reason.
Please. No,
So on that basis, we have to adjudge, not anything else.
Please.
Is it not? Because of Mohinder Singh Gill.
Because,
The grounds which you have given.
please.
They will provide the yardstick for judging whether your action is right, wrong.
In the SM Chandrasekhar judgment, my lord, the lordship, my lord, passed an order in the respect of Karnataka is concerned. Honorable Supreme Court say that, my lord, change of land use, my lord, at the consideration change of land use, my lord, very particularly based on the public interest should be considered. On that basis, my lord, the
Public interest are very
ಅಲ್ಲ
very
ಈಗ
elastic. What is that public?
ಯಾಕಂದ್ರೆ ಈಗ ಲೇಔಟ್ ಅಪ್ರೂವ್ ಆದ್ರೆ ಥರ್ಡ್ ಪಾರ್ಟಿ ರೈಟ್ ಇಸ್ ವಿಲ್ ಕ್ಲಿಯರ್ ಮೇಲೆ
ಆಯ್ತು.
ದೆನ್ ಮೈ ಲಾರ್ಡ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್.
ಏನು ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ?
ಯಾಕಂದ್ರೆ ನಾಳೆ ಮನೆ ಕಟ್ಬೇಕು, ಈಗ ನಾವು ಲೇಔಟ್ ಗೆ ಪರ್ಮಿಷನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ರೆ ನಾಳೆ ಮನೆ ಕಟ್ಬಿಡಿ ಅಂತ ಹೇಳಕ್ಕೆ ಬರಲ್ಲ.
ಅದು ಮನೆ ಕಟ್ಬೇಡಿ ಅಂತ ಯಾಕೆ ಲೇಔಟ್ ಪರ್ಮಿಷನ್ ಕೊಡೋದೇ ಅದ್ರ ಸಲುವಾಗಿ.
ಸೆಕ್ಷನ್ 15 ಕೆಳಗಡೆ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ಲಾನಿಂಗ್ ಬಂದೇ ಬರ್ತಾರೆ. On that, my lord, they will, my lord, say that ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲೇ ಬ್ಲಾಸ್ಟಿಂಗ್ ಇದೆ, ಹಂಗಾಗಿ
ಪಕ್ಕದಲ್ಲಿ 100 meters ಅಂತ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಪಾಲಿಸಿ ಡಿಸಿಷನ್ ಆಗಲ್ವಾ?
ಪ್ಲೀಸ್
ಈಗ 200 ಇದ್ದಿದ್ದನ್ನು that has been reduced to 100 meters.
ಪ್ಲೀಸ್
ಅಲ್ವಾ?
ಪ್ಲೀಸ್
100 meters means within 100 meters ಅವತ್ತೆಲ್ಲ ಏನೇನಿದೆ ಅದನ್ನೆಲ್ಲ ಮಾಡಿ. How can you curtail right to property? One is a constitutional guarantee.
We are not curtailed, my lord. On honorable single judge has been dismissed on the basis of they are not filed affidavit.
Now,
Please.
Madam is saying the question of filing affidavit arises not in this situation.
Please.
Because admittedly, after the amendment to the rules, now from 200 to 100 meters, you have brought it down. Is it not?
Please, please.
This rule is brought, is amended with lot of experience with the quarrying activities. It is not that some FDC will amend the rules.
And
They
in
will
the,
get all data,
in the,
experience.
in the year of 2023 ಅಲ್ಲೇ amend ಆಗಿದೆ.
ಮಾಡಿದ್ದಾರೆ.
Please.
ಅಂದ್ರೆ 66 ರೂಲ್ಸ್ ಯಾವಾಗಿಂದದು?
66.
ಅಂದ್ರೆ 66 ನಿಂದ 23 ವರೆಗೆ ಅಕ್ಯುಮುಲೇಟೆಡ್ ವಿಜ್ಡಮ್ ಇಟ್ಕೊಂಡು ರೂಲ್ಸ್ ಅನ್ನು ಮಾಡ್ಯಾರ.
Please, please.
ಅದರ ಬೆನಿಫಿಟ್ಸ್ is entitled to take ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
If I may, my lord, only controlled blasting is permitted now, my lord. No open blasting is
No open
permitted
blast, that's
anymore.
what my brother was saying. Control blasting ಅಂತದೆಲ್ಲ ಈಗಿರೋದು.
Please.
ಹಂಗಾಗಿ ಈ ಸಿಸಿ ಹಿಡಿದು ಹೋಗಿ ಯಾರಿಗೂ ಗಾಯ ಆಗೋದು ಮಾಡೋದು ಪಾಸಿಬಿಲಿಟಿ ತುಂಬಾ ಕಡಿಮೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
In respect of my lord, at the time of my lord, we have inspected my lord. The adjacent land is my lord blasting activities as there. On that basis, my lord, it is not to residentially ಇದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾವು. Because
ಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಮಾಡೋ ಲಾಯರ್ ಅನ್ನು ಕರ್ಕೊಂಬರಿ.
please,
We'll have this next week. If rules provide, how can we curtail right of the citizen? ನಿಮ್ಮ
Please, lords.
amended 100 meters ಮಾಡ್ಯಾರ.
May I just make one factual,
ಬರ್ಬೇಕು ಬಂದ್ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀವಿ.
one factual correction if I may just make, my lord.
ಅವ್ರು ಬರ್ಲಿ ಬಂದ್ಮೇಲೆ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಫುಲ್ ಇದೆಯೇನೋ? ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. ನಿಮ್ಮ ಮೈನಿಂಗ್ ಲಾಯರ್ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Please, lords.
Share that judgment with madam.
please, please.
Apex court judgment ಕೊಡಿ. Yes, just look into. That was myself and Varalesaf's judgment.
ಅಲ್ಲ ಅದು ಜಸ್ಟಿಸ್
ಬೇರೆ
ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಜಸ್ಟಿಸ್ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ನಜೀರ್ ಸಾಹೇಬ್.
Ajit sir.
Please.
Okay.
Lord is pleased to fix the date, man.
ನೋಡ ಒಂದ್ ದಿವಸ ಅಕಸ್ಮಾತ್ ಬರ್ಲಿದ್ರೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಬರುತ್ತೆ.
May I?
ತೊಳ್ತೇನೆ. We remember. Okay. Brother, ಒಂದೇ ನಿಮಿಷ. You filed an affidavit saying that within 100 meters, we have not, within 200 meters earlier,
Please, please.
we have not given any permission.
Please.
The council.
ನೀವು
the
My lord,
respondent.
We have filed.
filed by the government.
Government has.
Government yes.
ಯಾಕೆ government?
ಅವ್ರು ಹಾಕಿದ್ರು ಅವ at the time of direction of the honorable court.
Mining and geology.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ, ಇವರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಹಾಕ್ಸಿದ್ರು.
ಅಲ್ಲ, ಈಗ ನೀವು ಅದನ್ನ ಪರ್ಮಿಷನ್ ಕೊಡೋರು ಯಾರು?
ಮೈನ್ಸ್ ಅಂಡ್ ಜ್ಯುವೆಲ್ಲರಿ.
ಮೈನ್ಸ್ ಅಂಡ್ ಜಿಯಾಲಜಿ.
ಪ್ಲೀಸ್, ಪ್ಲೀಸ್.
ಇವರ ಕೊಡೋದು?
ಹೌದು.
ಅಲ್ಲ,
Mines are our quarrying license gate. Their planning authority is rejecting.
ಪ್ಲಾನಿಂಗ್
the
ಅಥಾರಿಟಿ
planning
ನೀವು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದು, ನೀವು ಹೇಳ್ಬೇಕು, ಅವ್ರಿಗೆ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಪ್ಲೀಸ್, ಪ್ಲೀಸ್.
Planning authority, respondent planning authority is directed to state on affidavit as to whether in any case since the last 1 decade, any conversion facility has been accorded within the radius of, and now within 100 meters after amendment.
Please.
Amendment. Okay, buddy. Yes.
Lordship may kindly have it next week.
Quick, please.
A case of correction of pay.
Call week after next, at the request of learned AG. Next.
That's for the petitioner. That's in the subjections are yet to be filed by the respondents.
Don't worry about that. If you are ready, you argue. Our file ಮಾಡ್ಲಿ ಮಾಡ್ದಂಗಿರ್ಲಿ.
That case, if it is taken up next week, I'll make sure it is done.
ಹೇಳಿ, ನೀವು ರೆಡಿ ಇಲ್ಲ ಅಂತ.
Statement of objections, draft objections from next week I will file it. And
1 week on request is granted for filing of objections, failing which right to file objections stands extinguished. Okay. Next week, help it. Small matter.
I appear police, council police.
Yes.
Petitioner practicing advocate who lost his son while he was in service.
May I
And he
submit?
claimed not benefit of, not
AG Pradeep is appearing. We need to file objections in this one.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡ್ತೀರಿ?
2 weeks, my lord.
Death has happened.
Yes, my lord.
Yes,
I know their short claim is
this
requested.
third round litigation. Lord. Earlier, Lord,
His
this court remanded the matter. On remand, this order is filed.
Yes. ಯಾವ ಡೇಟಿಗೆ?
2 weeks, my lord.
2 weeks ago.
Objections filed.
Date ಕೊಡಿ.
The objections are filed before the tribunal.
It is filed.
ರಾಮಕೃಷ್ಣ ಅವರ.
Oh,
He lost his wife, my lord, and his son.
Yes, yes, I know.
It's a pathetic.
ಒಂದು ಡೇಟ್ ಕೊಡಿ. 13th of November, finally, at the request of learned AG. No further time will be granted.
statement of objections are filed before the tribunal.
And here also.
Case of suicide.
All right.
ಆ ಡೇಟಿಗೆ ಮಾಡ್ಬೇಕು.
Please.
ಬಟ್ ಟೈಮ್ ಕೊಡಲ್ಲ.
Yes, ma'am.
ಯಾವಾಗೂ
My is an emergency matter. Before you leave, can you hear me, please? I'm care of footpath, sir, please.
ಯಾವ್ದು?
Not no matter, but I'm in the bar association. I have kept things. Police are harassing me due to politicians. I'll tell you later.
ಅಲ್ಲ ಇಲ್ಲಿ ನಮ್ಮ ಮ್ಯಾಟ್ರ್ ಈಗ
I think not, but I am on the road. You are the guardian of constitution. You are my not in age.
Correct.
I'm 73. You are like my father. You have to protect me today. I have no money, nothing.
ಯಾರು?
I'll sit here after, before you getting up, you hear.
ಅಲ್ಲಮ್ಮ
Please, please.
ಅಲ್ಲ ಪ್ಲೀಸ್ ಸ್ವಲ್ಪ ಕೇಳಿ, ನಾವು ಹೇಳೋದನ್ನು ಕೇಳಿ. ನಿಮ್ದು ಯಾವ್ದು ಕೇಸ್ ಇದೆ? ನಮ್ಮ ಮುಂದಿದೆಯಾ?
ನಂದಿಲ್ಲ ಸ್ವಾಮಿ, ನಂದು FTP number 2 of 2000 ಅಲ್ಲಿ ನಮ್ದು 2 ಎಸ್ಟೇಟ್ ಇದೆ. ಐ ಬಿಲಾಂಗ್ ಟು ದ ಬಾರ್ಬನಿ ಫ್ಯಾಮಿಲಿ. ನಾನು ಚಿಕ್ಕಮಗಳೂರಲ್ಲಿ ಹಾಸನಲ್ಲಿ 2 ಇದೆ. ನನ್ನ ಅಣ್ಣಂದಿರು ತಾಲೂಕ್ ಬೋರ್ಡ್ ಅವ್ರು ಬಂದು ಸರ್ವೆ ಮಾಡಿದ್ಮೇಲೆ ಪಾಣಿ ಚೇಂಜ್ ಮಾಡಿಬಿಡಿ, ನಾವು ಅವಳಿಗೆ ಮೂವಬಲ್ ಇಮ್ಮೂವಬಲ್ ನಾವೆಲ್ಲ ದುಡ್ಡು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ 25 years ಆದ್ರೂ ಒಂದು ಪೈಸೆ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಐ ಆಮ್ ಕೇರ್ ಆಫ್ ಫುಟ್ಪಾತ್. ಮೈ ಡಾಟರ್ ಇಸ್ ಕೇರ್ ಆಫ್ ಫುಟ್ಪಾತ್. ಮೈ 13 years ಗ್ರ್ಯಾಂಡ್ ಡಾಟರ್ ಇಸ್ ಮೆಂಟಲಿ ಎಫೆಕ್ಟೆಡ್ ಅಂಡ್ ಮೈ ಡಾಟರ್ ಇಸ್ ಆಲ್ಸೋ ದೇ ಆರ್ ಹರಾಸಿಂಗ್.
ಕರೆಕ್ಟ್. ನಮ್ಮ ಮುಂದೆ ಏನಾರ ಕೇಸ್ ಇದೆಯಾ?
ಸ್ವಾಮಿ, ನಾನು ಬೀದಿ ಮೇಲೆ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. ನನ್
ಅದು
ಸ್ವಲ್ಪ ನಮ್ಮ ಅಣ್ಣನಿರ ಹತ್ರ ಒಂದ್ ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಡ್ಸಿ DJG ಅಲೋಕ್ ಮೋಹನ್ ಹೇಳ್ತಾರೆ, ಅವ್ರಿಗೆಲ್ಲ ಗೊತ್ತು ನನ್ನ ವಿಷಯ.
ಅಲ್ಲ ಇಲ್ಲಿ ನಮ್ಮ ಕೇಸ್ ಇದೆಯಾ ನಿಮ್ದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು
ಮತ್ತೆ
ನಂದು
ಹೆಂಗ್ ತಗೊಳ್ಳೋದು?
ರಕ್ಷಣೆಗೆ ಬಂದಿನಿ. ಪೊಲೀಸರ ಹತ್ರ ಹೋಗಕ್ಕಾಗಲ್ಲ. ಪೊಲೀಸ್ ಆರ್ ದ ಪ್ರಿಡೇಟರ್ಸ್. What shall I do? Where shall I go? When justice was
ಲೀಗಲ್ ಅಸಿಸ್ಟೆಂಟ್,
Virama was there.
ಲೀಗಲ್ ಏಡ್ ಯಾರೋ ಇದ್ದಾರಲ್ಲ.
Sir, legal aid board, police are recommending.
ಒಂದ್ ಸ್ವಲ್ಪ ಕೇಳ್ಕೊಡಿ.
Okay.
ನಿಮ್ ಕೇಳಿದ್ವಲ್ಲ ಈಗ. ಈಗ ನಿಮ್ಗೆ ಲೀಗಲ್ ಏಡ್, ನಿಮ್ಗೆ ಲೀಗಲ್ ಏಡ್.
Justice did the same. Today I am care of footpath. I have kept all my things in the bar association. They're telling me will throw your things. Where shall I go? I don't have money also.
ಈಗ ನಿಮ್ಗೆ ಲಾಯರ್ ಬೇಕು ಅಂತ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಹೋಗಿದ್ರಾ?
ಇಲ್ಲ,
ಹಾ?
ನನ್ ಥಿಂಗ್ಸ್ ಇಡಕ್ಕೆ ನನ್ಗೆ ಪ್ಲೇಸ್ ಇಲ್ಲ, ಇಡಕ್ಕೆ ದುಡ್ಡಿಲ್ಲ. ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಮನಿ. ನನ್ ಬ್ರದರ್ಸ್ ಕೊಡ್ಬೇಕು. ಚಿಕ್ಕಮಗಳೂರಲ್ಲಿ 6 ತಿಂಗಳು ಟೈಮ್ ಮಾಡಿದ್ರು ಕೊಡ್ಲಿಲ್ಲ. SP ಅವ್ರನ್ನ ತಗೊಂಡಿಗೆ ವೃದ್ಧಾಶ್ರಮಕ್ಕೆ ಸೇರಿಸ್ತಾರೆ, ಫ್ರೀ ವೃದ್ಧಾಶ್ರಮಕ್ಕೆ. 3 crores ಪ್ರಾಪರ್ಟಿ. I have my 3 crores. Why should I stay in a ವೃದ್ಧಾಶ್ರಮ? And my daughter-in-law is care of footpath. They are trying to, my ex-husband's family is trying to push her into prostitution. Can you imagine? 13 years daughter, since 3 years, she is not concentrating in the class. And United Nations has said, keep up the health of the mental health of the children in India and stop the violence on women and prevent suicide, because highest rate in India in the world. So please protect my family.
ಅಲ್ಲಮ್ಮ
Protect.
ಕರೆಕ್ಟ್. ನಾವು ಪ್ರೊಟೆಕ್ಟ್ ಅಂದ್ರೆ ನಮ್ಮೊಂದೊಂದು ಪಿಟಿಷನ್.
ಏನಿಲ್ಲ ಸ್ವಾಮಿ,
ಅಲ್ಲ,
ನಾನು
ನಾವ್ ಹೇಳೋದು-
ಕೊಡ್ತೀನಿ. ಅಲೋಕ್ ಮೋಹನ್ ಅವ್ರಿಗೆ ಹೇಳಿ, ಅಚಲ ಗಣಪತಿ ನಿಮ್ಮ ಹತ್ರ ಎಷ್ಟೊಂದು ಕೊಡ್ತಾರಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಪಿಟಿಷನ್ಸ್. ಒಂದ್ ಚೂರು ಹೆಲ್ಪ್ ಮಾಡಲಿಲ್ಲ ನೀವು, ಪ್ರಾಪರ್ಟಿಗೆ ಇದ್ರ ನಾವು ಕೋರ್ಟ್ ಆರ್ಡರ್ ತಗೊಂಡ್ ಬಂದು ದುಡ್ಡು ಕೊಡ್ಸಿ ಅಂತ ದುಡ್ಡು ಕೊಡಿಸ್ತಾರಂತೆ. ಅವಾಗ ದುಡ್ಡು ಕೊಡಿಸ್ತಾರಂತೆ.
ನಿಜ. ಈಗ ನಮ್ ಮುಂದೆ ಒಂದು
First now today you get me some money to join some PG. Later tomorrow I come with this thing, original documents. They can file with petition
ಎಷ್ಟು
before
ಅಮೌಂಟ್?
this honorable court.
ಎಷ್ಟು ಅಮೌಂಟ್ ಅದು?
ಈಗ ಒಂದು 20,000 10,000 ಡೆಪಾಸಿಟ್ ಕೇಳ್ತಾರೆ, ಇನ್ನೊಂದು 10,000 ನನಗೆ PG ಅಲ್ಲಿ ಕೇಳ್ತಾರೆ. ಸ್ವಾಮಿ, ಒಂದ್ ಪೈಸಾ ಇಲ್ಲ ನನ್ನ ಹತ್ರ. ಇವತ್ತು ಹಾಸನಾಂಬಾಗ್ ಹೋಗಿ ಅಲ್ಲಿ ಪರ್ಸು ಕಳ್ದಾಕೊಂಡ್ಮೇಲೆ ಯಾರು ಕಲ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹಾಸನಾಂಬಾಗಲ್ಲಿ ಚಿಕ್ಕಮಗಳೂರಿಂದ ಬರುವಾಗ.
ನೀವು ಹೇಳ್ದಷ್ಟು ಕೊಡೋದು ಅಷ್ಟೆಲ್ಲ ಶ್ರೀಮಂತರಲ್ಲ ನಾವು ಜಡ್ಜ್.
ಅಯ್ಯೋ,
ಆದ್ರೂ ಸಹಿತ ನಿಮ್ಗೆ ಕೊಡ್ತೀವಿ, ಕೂತ್ಕೊಳ್ಳಿ.
Not, not Alok Mohan. Within 1 minute, my brothers will transfer it on my mobile. They are multi-billionaires they have become. Coffee planters, the richest people now in the world. It is the highest market, demand in the market.
ನಾವು ಮಾತಾಡ್ಬೋದಾ?
No, Swami.
ಕೇಳ್ತೀರಾ? ನಮ್ಮಲ್ಲಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದು ಪ್ರೊಸೀಜರ್ ಇದೆ. ಏನು? ಪಿಟಿಷನ್ ಇದೆ, ಒಂದು ಅಪೀಲು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಹಾಕ್ಬೇಕು. ಪೂರ ಕೇಳ್ಕೊಳ್ಳಿ. ನೀವು ಹೇಳಿದ್ದೆಲ್ಲ ಕೇಳಿಲ್ವಾ? ಮತ್ ನೀವು ನಂಗೆ ಆ ಫೆಸಿಲಿಟಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು.
ಏನ್ ಮಾಡಿ ಸ್ವಾಮಿ, ನನಗೆ ಅಷ್ಟು BP ಇದೆ, ಶುಗರ್ ಇದೆ, ಎಲ್ಲ ಇದೆ. ನಾನು ಏನ್ ಮಾಡ್ಲಿ? ಸ್ಟ್ರೋಕ್ ಹೊಡ್ಬೇಕು ಆಗ್ತಾ ಇದೆ. ಏನ್ ಮಾಡ್ಲಿ? ಯಾರು ಹೇಳಿಲ್ಲ ನಂಗೆ ನೋಡ್ಕೊಳಕ್ಕೆ. ನನ್ ಡಾಕ್ಟರ್ ಇಲ್ಲ, ನನ್ನ ಮೊಮ್ಮಗಳಿಗೋಸ್ಕರ ಇಲ್ಲಿ ಬಂದು ನಾನ್ ಜಂಪ್ ಮಾಡ್ತೀನಿ ನದಿಗೆ ಹೋಗಿ. ಐ ಡೋಂಟ್ ಮೈಂಡ್.
ಎಲ್ಲಿ ಜಂಪ್ ಮಾಡೋದು ಬೇಡ. ಒಂದು ನಿಮಿಷ, ಯಾರಾದ್ರೂ ನಮ್ಮ ನೋಡ್ರಿ, ಏನ್ ಬಂದ್ರಿ ಕೇಳ್ಕೊಡ್ರಿ ನಿಮ್ದು ಅವ್ರೇನೋ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಕೇಳ್ಕೊಳ್ಳಿ, ಕುತ್ಕೊಳ್ಳಿ, ಒಂದ್ ಕಡೆ ಕುತ್ಕೊಂಡು ಸಮಾಧಾನವಾಗಿರಿ. ಏನಾಗಲ್ಲ, ಭಗವಂತ ಎಲ್ಲಾರನ್ನೂ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಾನೆ. ನೀವು ಅಷ್ಟೊಂದು ಟೆನ್ಷನ್ ಮಾಡ್ಕೋಬಾರ್ದು, ನಮಗೂ ಟೆನ್ಷನ್ ಮಾಡ್ಬಾರ್ದು.
ಇಲ್ಲಿ
ನೋಡ್ರಿ, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಏನ್ ಡಿಫಿಕಲ್ಟ್. ಯಾರು ಒಬ್ರು ಲೇಡಿ, ಒಬ್ರು ಸಮ್ ಲೇಡಿ
Speak to Rala sister.
ಹೋಗಿ ಅವ್ರು ಕರ್ಕೊಂಡು ಹೋಗಿ. ವಿಲ್ ನಾಟ್ ಡ್ಯಾಮೇಜ್ ಯುವರ್ ಮ್ಯಾಟರ್. ಗೋ ನೌ, ಗೋ ಟೇಕ್ ಹರ್. ವಾಟ್ ಅಸಿಸ್ಟೆನ್ಸ್ ಹಿ ನೀಡ್ಸ್.
Yes.
If small amount, anything, even I can give, no issue. Ah. 37.
ಗೊತ್ತಿಲ್ಲ, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಐ ಡೋಂಟ್ ನೋ.
3 RFAಗಳು ಕ್ರಾಬ್ ಇದೆ. 2 RFA, 1 ಕ್ರಾಬ್.
ಯಾರು?
2 RFA, 1 ಕ್ರಾಬ್.
ಅವರು ಉತ್ತರ ಕೊಡ್ಬೇಕಲ್ಲ, ಅವ್ರು ಎತ್ತೆತ್ಲಾಗ ಇರ್ತದ ಅವ್ರದ್ದು. ಅದೇ ಇನ್ನೂ ಮುಗಿತಾ ಇಲ್ಲ. Surana, you are a senior member of the bar. Give attention to the judges.
Please.
What are you doing there? What do you think?
Allah.
What Allah?
I'm sorry. I was told that.
What is that Allah?
One second, 1 minute. I am told that.
You are being told now by us. Give attention to the judges.
Yes.
Don't make tamasha here.
Illa. The LR 1A is stated to be dead about 4 days ago. That's the information he was giving to me. I listening to him.
ಕೆಲಸ ಮಾಡಕರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕೆಲಸ ಮಾಡಕ.
I'm sorry. He was, my friend was telling to me.
ನ್ಯಾಯ ಸ್ಥಾನಕ್ಕೆ ರೆಸ್ಪೆಕ್ಟ್ ಕೊಡ್ಬೇಕು ನಾವೆಲ್ಲ.
ಅಲ್ಲ,
ಏನೋ ಒಂದು ಎಂಥದೋ ಒಂದು ಗ್ಯಾಲರಿ ಆರ್ಗ್ಯೂ ಮಾಡೋದು.
My friend was telling me. I was not.
ಇಲ್ಲೆಲ್ಲ ನಡೆಯಲ್ಲ.
No, I was not aware. My friend was telling me.
We are warning you. Do not do that.
ಇಲ್ಲ ಮಾಡ್ತೇನೆ. LR 1A is stated to be dead ಅಂತ.
Yes.
ಲಕ್ಷ್ಮಮ್ಮ.
ಕೊಡಿ.
ಎಲ್ಲರಿಗೂ.
Yes, ಆಗಿ.
Appellate 1A is stated to be dead ಅಂತ.
1A is dead.
4 days back.
ಯಾವಾಗ ಡೆತ್ ಆಗಿದ್ದು? 4 days back. LR's application.
ಇಲ್ಲ, already there, LR's already record, my lord. 1A is daughters and sons, children's already is there record.
1A himself is dead ಅಂತ ಹೇಳೋದು.
1 ತೀರೋದ್ಮೇಲೆ 1A, 1B, 1C, 1D ಅಂತ ಮಾಡಿದ ಅಷ್ಟೇ.
Who is dead?
Only memo ಹಾಕಿರೋ ಸಾಕು.
ಲಕ್ಷ್ಮಮ್ಮ is dead.
ಲಾಸ್ಟ್ ಮಂಡೇ ತೀರೋಗಿರೋದು ಅವರು.
1 second. ಲಕ್ಷ್ಮಮ್ಮಗೆ ಯಾರ್ಯಾರು ಮಕ್ಕಳಿದ್ದಾರೆ?
All are record, only formally memo.
Record. Where is that?
Memo, we will.
Not necessary. Perkali. Srimati Lakshmamma, who happens to be one of the LRs of deceased appellant, Mr. Gopal Reddy, and she is designated as respondent number 1 small a, is stated to be dead. And the counsel for the appellant agrees that respondent numbers 1B, 1C and 1B, 1C, 1D and 1E represent estate of the deceased Lakshmamma.
And are the only heirs.
Correct.
And are the only heirs.
Being the only, not heirs, only representatives, being the only legal representatives. First stop. Therefore, the appeal has not abated and there is no need to bring anyone on record. Yes. Arya.
The first suit is filed for partition in the year 1990.
Partition suit.
Partition suit. First suit was filed.
Perhaps others may not wait. This will take its own time. Next 2 weeks repeat ಮಾಡ್ತೀವಿ ಲಿಸ್ಟ್ ಅನ್ನು ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ. ನಿಮ್ ಬೇಕಾದ್ರೆ ಇರ್ಬೋದು ಬಟ್ ಕೇಸ್ ನಡೀತದೆ ಅಂತ ಕಾಯೋದು ಬೇಡ ಅಷ್ಟೇ. ಅದೇ ಹೇಳಿ. Yes, Mr. Surana.
Yes, ma'am. Yes, ma'am.
This is a partition suit.
Suit partition. This is second suit for partition.
Second suit for partition.
The first suit for partition was filed in OS 7127 of 90.
7127
of 90.
That was earlier partition.
Earlier partition suit.
OS
7127 of 90.
90. What happened to that? Who were parties?
Yes, the same, very same plaintiff and the third defendant. I am referring
So
to the
plaintiff's appeal, no?
either defendant's appeal, 1 and 2.
Defendant's appeal.
Defendant's appeal.
Same plaintiff had filed the
Same-
earlier suit.
Earlier suit was filed by two brothers.
Two
The
brothers,
present- Two brothers, Srinivas Reddy and his brother,
Srinivas Reddy and
and his brother.
Gopal Reddy.
No, Gopal Reddy is not. Srinivas Reddy, kindly take, the plaint is available, 475, page number.
Kodi, paper book kodi. ಪೇಪರ್ ಬುಕ್ ಏನೋ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದಾರಂತೆ.
ಇಲ್ಲ ಹಾಕಿದೀವಿ.
ಹ?
ಹಾಕಿದೀವಿ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇರ್ಬೇಕು ನಾವು.
ನಾವು ಹಾಕಿದೀವಿ.
ನೀವು ಹಾಕಿದ್ರಾ? Earlier suit was filed by
Narayan Reddy and Srinivas Reddy,
Srinivas Reddy and Narayan Reddy.
both the sons of Krishna Reddy.
They had filed it against whom?
Against Gopal Reddy and Krishna Reddy.
Against Gopal Reddy and father Krishna Reddy.
The Krishna Reddy is brother.
But you said Srinivas Reddy and Narayan Reddy are sons of Krishna Reddy.
Yes.
There is another Krishna Reddy?
No, Munswami Reddy. The suit
Not
was
Krishna
filed by Srinivas Narayan Reddy and Srinivas Reddy. Both are sons of Krishna Reddy.
Genealogical tree alide.
I don't know, they have not supplied it here, yes. Exhibit.
Tree ilva?
ಹಾಕಿದ್ದಾರೆ.
Armenian, your lordship may refer to volume 3, page 475. ನೋಡಿ, volume 3 ಕೊಡಿ.
ಅದೇ ನೋಡ್ತಾರೆ ಅದು.
ಇಲ್ಲಿ ಕೊಡ್ತೀನಿ ನೋಡಿ.
ಇಲ್ಲಿದೆ ಜಿಯಾಲಜಿಕಲ್ ಟ್ರೀ ಇದೆ.
ಕರೆಕ್ಟ್?
Yes, 475.
ಒಂದು small narration ಕೊಡಿ. How case arose? What happened? Why are you here?
Yes, yes. Narration.
Head.
The first, the suit is filed saying that there are, in the earlier suit, about 26 or 27 items were included.
In the earlier
In
suit,
the first suit.
whether in the second suit, same items or different,
No. In the second suit, only 4 properties are included.
which were included in the earlier suit also?
And one of the properties was not included, it is included herein. But in one of the properties was schedule was correct, but survey number was different. ಆ ಹಳೆ suit ಅಲ್ಲಿ ಏನು ಒಂದು schedule ಕೊಟ್ಟಿದ್ರು,
Wrongly
ಅದೇ
described.
schedule was correct. Survey number was not correct. But the same property is included. So 4 properties are, the present suit is filed only for the purpose for partition of 4 properties. And a statement is made in the present plaint stating that we reserve our liberty to pursue. So for other properties are concerned, that is not possible. Other properties are concerned. Now in that suit itself, in 1990 suit itself, 6 acres of land in survey number 37 was asserted to be purchased by the defendants in that suit. That is my Gopal Reddy.
Gopal Reddy.
Gopal Reddy.
That is Srinivas Reddy and Narayan Reddy's brother.
Illa.
Who is Gopal Reddy?
Yes. Gopal Reddy is.
Son of?
I'll come to that. Kindly bear in mind, this Munswami Reddy and Krishna Reddy are the brothers.
You say Srinivas Reddy and Narayan Reddy are brothers. Adu correcta?
Narayan Reddy and Srinivas Reddy both are brothers, sons of Krishna Reddy.
Krishna Reddy.
Exhibit 3-1 ತಗೊಂಡ್ರೆ ತಾವು ಬಂಪರ್ ಬುಕ್ಸ್ ಇದೆ.
ಅಲ್ಲ ನಿಮ್ಮ ಬುಕ್ಸ್ ಬರೋವರೆಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹೌದಾ? 224.
Volume 2. Volume 2. ಆಯ್ತು, ಮುಂದೆ ಹೇಳಿ.
ಕೃಷ್ಣ ರೆಡ್ಡಿ.
ಅಲ್ಲ, ನಮ್ಗೊಂದು ಬೇಕಾಗಿತ್ತು. ಕೃಷ್ಣ ರೆಡ್ಡಿಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು?
ಕೃಷ್ಣ ರೆಡ್ಡಿಗೆ 2 ಮಕ್ಕಳು.
ಇಬ್ರೇ?
ಇಬ್ರೇ.
ಯಾರು? ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ, ನಾರಾಯಣ್ ರೆಡ್ಡಿ.
ನಾರಾಯಣ್ ರೆಡ್ಡಿ.
ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ, ನಾರಾಯಣ್ ರೆಡ್ಡಿ OS 7127 of 1990 ಹಾಕಿದ್ರು. ಕರೆಕ್ಟಾ? ಕರೆಕ್ಟಾ?
OS 7127/90.
ಕರೆಕ್ಟ್. 1990. ಯಾರ್ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು?
Filed against Gopal Reddy and Munswami Reddy. Am I right?
Against Gopal Reddy
and Munswami Reddy.
ಇವ್ರು ಯಾರು?
Gopal Reddy and Munswami Reddy are both sons of Munswami. Gopal Reddy and Krishna Reddy.
Both sons of?
ಇವ್ರಿಗೆ 3 ಜನ ಮಕ್ಕಳು. ಅಲ್ಲ, ಇಲ್ಲಿ ಡಬಲ್ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಇದೆಯಲ್ಲ. Krishna Reddy. Gopal Reddy and M. Krishna Reddy, both sons of Munswami Reddy.
Other plaintiffs and father Krishna Reddy, defendants father
He is Munswami Reddy.
Muniswami Reddy are brothers.
Brothers. They are the sons of one Chinnappa.
Munisiddappa.
ಅಲ್ಲ, ಚಿನ್ನಪ್ಪ ರೆಡ್ಡಿ.
Chinnappa Reddy is propositus.
Propositor.
ಹಂಗ ಅನ್ಕೋಬೋದಾ? ಚಿನ್ನಪ್ಪ ರೆಡ್ಡಿ is propositus. Krishna Reddy, Muniswami Reddy are sons. S1, S2. ಕೃಷ್ಣ ರೆಡ್ಡಿಗೆ 2 ಮಕ್ಕಳು, ಒಬ್ರು ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ, ಇನ್ನೊಬ್ಬ ನಾರಾಯಣ್ ರೆಡ್ಡಿ. ಮುನಿಸ್ವಾಮಿ ರೆಡ್ಡಿಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು?
ಮುನಿಸ್ವಾಮಿ ರೆಡ್ಡಿಗೆ 2 ಮಕ್ಕಳು.
ಯಾರ್ಯಾರು?
There is Gopal Reddy and M. Krishna Reddy.
ಅಲ್ಲ, ರಾಂಗ್.
ಅಲ್ಲ, he is also Krishna Reddy. Described in the plaint.
ಅವರು ಕೃಷ್ಣ ರೆಡ್ಡಿನೇ.
ಈ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಚಿಕ್ಕಪ್ಪನು ಕೃಷ್ಣ ರೆಡ್ಡಿನೇ.
ಸೇಮ್ ಹೆಸರಿನವರೇ ಇದ್ದಾರೆ.
The allegations in the plaint is that the 10 acre 10 guntas of land in survey number 37 was ancestral property. Judgment could trial court. Trial court. Volume 1 ಅಲ್ಲಿ.
ನಾರಾಯಣ್ ರೆಡ್ಡಿ is brother of ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ. ಅದಕ್ಕೆ ನೀವು ಒಂದು ನಾವು ಅವ್ರು ಪ್ಲೇಂಟ್ ಹಾಕ್ಲಿ ಬಿಡ್ಲಿ, ನೀವು ನಮಗೆ ಇದನ್ನ ಕೊಟ್ಬಿಟ್ರೆ ನಾವು ಸಕ್ಸೆಷನ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ. ಅವಾಗ ಸೋ ಈಸಿ ಇದೆ.
The family tree is filed at exhibit.
ಮಾಡಿದಾರ?
ಕೊಟ್ಟಿದ್ದಾರೆ, exhibit P1. Volume 2. There is a spare book, I will pass.
ನಾವು ವಾಪಸ್ ಕೊಡ್ತೀವಿ ನಿಮ್ಗೆ.
Spare book.
ಅಲ್ಲ ಇದೆ, ನೀವು ಕೊಟ್ಟರದೆ.
ಕೊಡಿ. ಅವ್ರ ಹತ್ತಿಗಿದೆ ಅಂತ ನೋಡಿ. ಪಾರ್ಟಿಷನ್ ಆಗಿ ಇಷ್ಟೇ ನೋಡಿಬಿಟ್ರೆ ಎಲ್ಲೆಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ. ನಂಜುಂಡರೆಡ್ಡಿ ಚಿನ್ನಪ್ಪ ರೆಡ್ಡಿ ಸನ್ ಆಫ್ ನಂಜುಂಡರೆಡ್ಡಿ. ಗುಳ್ಳಮ್ಮ ಇಸ್ ವೈಫ್ ಆಫ್ ಚಿನ್ನಪ್ಪ ರೆಡ್ಡಿ. ಕರೆಕ್ಟಾ? Both dead. They have 4 sons. Munishama Reddy, Nanjundappa, Narayan Reddy, Krishna Reddy. Correct?
Correct.
Munishama Reddy, Guramma Reddy.
Munishama Reddy's 2 sons, Gopal Reddy and M. Krishna Reddy, the defendants.
Gopal Reddy and Krishna Reddy
were the defendants in the earlier suit.
Pre-amendment suit ಎಲ್ಲ ಇವು. Pre-amendment suit ಎಲ್ಲ ಇದು. Old suits ಅಲ್ಲ. 90s.
Yes. ಅಲ್ಲ 90 suit is dismissed. The second suit filed.
ಅಲ್ಲ ಅದಾಯ್ತು. ಅಲ್ಲಿ ಡಾಕ್ಟರ್ಸ್ ಯಾರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿರ್ಲಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೆ ಕೇಳಿ. ತೊಳಿ. ವಾಲ್ಯೂಮ್ 2 ಕೊಡಿ.
Page number 224.
224, first page.
ಈ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಮಕ್ಕಳು is Narayan Reddy and Srinivas Reddy. My lord, but to take the volume 3 at page 475, the facts will be clear about the relationship parties.
Volume 3,
page 475. So Narayan Reddy and Srinivas Reddy both were the sons of Krishna Reddy.
Correct. ಈ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಯಾರು ಅಂತ ನಿಮ್ಮ ಇದರಲ್ಲಿ ಅಲ್ಲಿ 3 ಕೃಷ್ಣ ರೆಡ್ಡಿ ಇದ್ದಾರೆ.
This Krishna Reddy
ನಾರಾಯಣ ರೆಡ್ಡಿ ಇಬ್ಬರಿಗೂ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಅಂತ ತೋರಿಸಿದೆ.
Krishna Reddy is the father of the Narayan Reddy and Srinivas Reddy, plaintiff 1 and 2.
Krishna Reddy is father of plaintiffs 1 and 2.
In OS 7127.
Another Krishna Reddy. Correct. He is another Krishna Reddy. D2. Correct.
The uncles and brother's son having same name.
Correct.
So this Munshami Reddy's son is also called as Krishna Reddy.
Defendant number 2, Krishna Reddy.
Krishna Reddy is the son of
happens to
Munshami
be
Reddy.
uncle of plaintiffs 1 and 2. Correct?
Plaintiff 1 and 2. Cousin ಆಗ್ತಾರೆ ಅವರು.
Cousins ಆಗ್ತಾರಾ?
ಹೌದು. Krishna Reddy and Munshami Reddy are the brothers. So Krishna Reddy has 2 sons, Narayan Reddy and Srinivas Reddy. Plaintiff 1 and 2 in OS 71727. The defendants are the sons of Munshami Reddy.
ಅವ್ರ ಎರಡನೇ ಮಗನು ಕೃಷ್ಣ ರೆಡ್ಡಿ.
ಕೃಷ್ಣ ರೆಡ್ಡಿ.
ಓಕೆ. ಕಾಮನ್ ಎನ್ಸೆಸ್ಟರ್ ಚಿನ್ನಪ್ಪ ನಂಜುಂಡ ರೆಡ್ಡಿ ಆಗ್ತಾರ, ಚಿನ್ನಪ್ಪ ರೆಡ್ಡಿ ಆಗ್ತಾರ.
Chinnappa Reddy. They are this Munswami Reddy and Krishna Reddy, the sons of Chinnappa.
Okay, understood. Plaintiffs and defendant number 3 represent one branch. Defendants 1 and 2 represent another branch. Yes, yes, brother.
Yes.
Hmm.
Now this suit was filed.
Ah.
Kindly go to the schedule at 481. About 22 properties are included.
ಇದು
Earlier suit.
previous suit. 22 properties are there.
There.
ಎರಡನೇ ಸೂಟ್ ಯಾವುದು?
ಎರಡನೇ suit is the present suit filed on 11/4/2004.
OS number
7702/2004.
This is in respect of which properties?
Only 4 properties.
Whether those 4 properties were there in 22?
Only, sorry, 5 properties. 5 properties. All the 5 properties can be said to have been included because there is only a change in number.
Survey number.
Survey number so far as the item number.
Agrees schedule description is correct except the survey number.
Survey number with regard to one property.
That means all properties in the second suit, where the properties in the earlier suit is your version.
It can be understood that way.
What understood? What is your stand in the WS? Petition.
The 29.
Where is the stand in your WS ನಲ್ಲಿ ಏನಂತ ತಗೊಂಡ್ರಿ?
29(2)(a) was the schedule is same.
Where is the stand you have taken in your pleadings?
In the first written statement, we have said that, kindly turn to page 491.
491. Item 1 of the social property belongs to one of the scheduled property.
Para 7 ಅಲ್ಲಿ 12th line.
12th line.
Boundaries in respect of item of scheduled property is not correct. The land in survey number 37 belongs to this defendant, is bounded by east to west and north by government land and south by fertilizer factory. The boundaries of this property of this defendant is given to item number 1 in the schedule.
But same property. In the suit ಏನಿತ್ತು ಅದೇ ಪ್ರಾಪರ್ಟಿನೇ. Correcta? That's right. But description is a bit different. But in the schedule same, survey number varied.
Survey number, actual survey number is 37. ಇದರಲ್ಲಿ ಕೊಟ್ಟಿರೋದು 29/1A. ಈ ಸೂಟಲ್ಲಿ ಕೊಟ್ಟಿರೋದು schedule 1 ಅಲ್ಲಿ
ಅದೇ ಪ್ರಾಪರ್ಟಿನೇ.
Same, it can be said to be same property.
ಯಾಕೆ ಸೇಕ್ ಟು ಬಿ ಅಂತೀರಿ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
Because schedule is same. 29/2A ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. That's how the pleading is that.
All right. All right, proceed on that basis. Let us see.
Now this 37 in the present plaint, kindly see the averment in the present plaint.
Volume 1.
Volume 1 ಅಲ್ಲಿ. In para 8 ಅಲ್ಲಿ they say page 13 ಅಲ್ಲಿ.
ಇದು ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ, in para 12 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವರು. In para 12, in page 12, page 7.
Share of the plaintiff.
Allah, what they say is, according to the plaintiff, at page 19, at page 11, page 11, para 7.
Page 11, para 7.
7. It is submitted that, married will, submitted that the land bearing 37 situated at Aralagunte village, Begurubli, Bangalore, South Taluk, Bangalore, measuring 10 acre, 10 guntas, which is subreported Yeshil property, to the plaintiff is the joint family property, and the entry stood in the name of grandfather of the plaintiff herein. Whereas the entries in respect of the land bearing 36 and all that. That is all say. Now kindly come to para 6 letter. 2 lines above para 6. The plaintiff is not seeking partition in respect of the
aforesaid properties.
Aforesaid properties. Aforesaid properties.
Number 1 to
Aforesaid properties are stated in paragraph 4.
These were a subject matter of earlier partition.
Earlier suit. Now kindly bear in mind, 29 2A Aralagunte village, measuring 7 acres, 20 guntas.
29 2A.
29 2A, measuring 7 acres, 20 guntas, was the schedule 1 property in the earlier suit. If we go back to
Plain schedule,
Plain
or even
schedule.
paragraph 4, paragraph 4 nagirbodala.
What in the schedule of the earlier suit.
Adella paragraph 4 nallalva. Survey number?
No, if we will go, kindly.
All right, nim survey number heli.
29/2A.
29/2A.
Para 4A.
Page 5.
Page 5.
29/2A.
Of Aralagunte village, Begurubli, Bangalore, South.
Item number 1.
So ಇದಕ್ಕೆ ಇವರು ಪಾರ್ಟಿಷನ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ. But kindly go back to page 481. Volume 3. Land in survey number 29/2A.
Schedule nang mention ಮಾಡಿದ್ರು.
What we said is, in the next statement, so far as the item number 1 is concerned, survey number is not correctly mentioned, boundaries are same. It relates to
Survey number ಯಾವುದು?
37. Kindly.
ಅದೇ ರಾಂಗ್ ಆಗಿದೆ ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇರೋದು.
Now, what 29/2A
is none
referable
other
to
than
37.
37 ಅಂತ
37. In the next step, the schedule of the schedule, the item number 1 in the earlier suit at 481 tallies with 37, which we own.
Tallies ಅನ್ಲಿಕ್ಕೆ ಬೌಂಡ್ರಿ ಪ್ರಕಾರ tallies
Boundaries ಪ್ರಕಾರ tallies. Extent ಪ್ರಕಾರ
ಯಾವ ರೀತಿ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ರು? ಓಲ್ಡ್ ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡ್ಯಾರ ತೋರಿಸಿ. ಅರ್ಲಿಯರ್ ಪ್ಲೇಂಟ್ ನಲ್ಲಿ 481. Land in survey number 29/2A of Aralagunte village, Pegur Hobli, 7 acres, 20 guntas bounded on government road, government land, government road, private fertilizer factory. Go to.
Now kindly go to A schedule in page 29 of volume 1.
In 9 of volume 1, schedule A. Survey number 37, situated with 10 acres, 10 guntas. ಅದನ್ನ ಎಷ್ಟು ಎಕರೆ ಅಂತ ಹೇಳಿದ್ರು ಅವರು?
7 ಎಕರೆ 20 ಗುಂಟೆ.
7 acres, 20 guntas. ಇದು 10 acres, 10 guntas. ಒಂದು ಎಕ್ಸ್ಟೆಂಟ್ ವೇರಿ ಆಗ್ತದೆ. ಕರೆಕ್ಟಾ?
ಅಂಡ್ ಸರ್ವೆ ನಂಬರ್ ವೇರಿ ಆಗುತ್ತೆ.
ಯಾವ ಪಾಳ್ಯ? ಸೇಮ್ ಉಳಿದಿದ್ದೆಲ್ಲ ಸೇಮೇ ಇದೆ.
Same.
ರೋಡು ಕೆರೆ, ರೋಡು ಫರ್ಟಿಲೈಸರ್ ಫ್ಯಾಕ್ಟ್ರಿ, ರೋಡು ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅಂದ್ರೆ ಕೆರೆ ಅನ್ನೋ ಬದ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅಂತಾರೆ. ಇನ್ನು ಉಳಿದಿದ್ದೆಲ್ಲ ಸೇಮೇ ಬರ್ತದೆ ಅಂತ.
Same.
ಬಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ವೇರಿ ಆಗ್ತದೆ,
Extent vary ಆಗುತ್ತೆ.
ಸರ್ವೆ ನಂಬರ್ ವೇರಿ ಆಗ್ತದೆ.
Sub number vary ಆಗುತ್ತೆ. So in the present suit, they say we are not claiming anything about this item number 1.
That item for para 4 ನಲ್ಲಿ ಹೇಳಿದ್ದನ್ನು ನೀವು
Para 4 ಅಲ್ಲಿ. Now in
last 2 lines.
Para 4, there are about number of properties described from page 5 to page 8.
Item A to
X.
X. Okay. A itself is 29/2A.
Yeah.
But that was 10 acres, some guntas.
Now what they say is, kindly go to the amendments made in the paragraph 4. Originally said properties belong to one Chinnapareddy alias Chinnaya, who is none other than the grandfather of the plaintiff and defendant 1 and 3. They said Chinnapareddy Chinnaya and had 3 children by name Krishna Reddy deceased, Munswami Reddy deceased, Gurumma are the daughter, sons of late Chinnapareddy and Chinnaya Reddy. The sons of the said Chinnapareddy, Chinnaya were residing in the together without there being any division of the property. The said Chinnapareddy, Chinnaya had died intestate, leaving behind his 2 sons referred to above and daughter Gurumma. The daughter of the said Chinnapareddy and Chinnaya, Gurapareddy, was married long back and she has no more. After death of Chinnapareddy, Chinnaya, his sons Krishna Reddy and Munswami Reddy continued to enjoy the property jointly left behind by their family. During the lifetime of Krishna Reddy and Munswami Reddy, also there was no division of properties.
There was no division of property during his lifetime.
That's what they say.
ಇದನ್ನು ಹೇಳಿದ್ದು ಸೆಕೆಂಡ್ ಸೂಟ್ ನಲ್ಲಿ.
Second suit ಅಲ್ಲಿ.
ಮತ್ತೆ ಫಸ್ಟ್ ಸೂಟ್ ನಲ್ಲಿ ಫಸ್ಟ್ ಸೂಟ್ ನಲ್ಲಿ 10 acres ಇತ್ತಲ್ಲ.
10 acres ಸೇರಿಸಿಲ್ಲ ಅವರು. 7 acres. ಸರ್ವೆ ನಂಬರ್ಸ್ ರಾಂಗ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬಟ್ ಅದೇ ಪ್ರಾಪರ್ಟಿ.
ಶೆಡ್ಯೂಲ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ ಆಲ್ಸೋ ರಾಂಗ್.
ಎಕ್ಸ್ಟೆಂಟ್ ವೇರಿಯೇಷನ್ ಅಂದ್ರೆ ಶೆಡ್ಯೂಲ್ ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
In
ಬೌಂಡ್ರೀಸ್ ಆರ್ ಸೇಮ್ ಅಷ್ಟೇ.
In the WS,
ಡಿಫರೆನ್ಸ್ ಇದೆ. ಒಂದು ಕೆರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು, ಒಂದು ಚತುರ್ಗಡಿಯಲ್ಲಿ ಒಂದು ಗಡಿ ಕೆರೆ, ಇನ್ನೊಂದ್ ಕಡೆ ಗೌರ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಇಷ್ಟ ಹೇಳ್ತಾರೆ ಅವರು.
A gap could be supplied, dismissed for default, not on merits.
Oh.
And the honorable court says, it's no res judicata. For res judicata.
There is no res judicata.
ತಾವು ಹೇಳಿದ್ರಿ res judicata ಹೇಳಿ ಅದಕ್ಕೋಸ್ಕರ ಎದ್ದಿದ್ಕೊಂಡ್ರೆ ಅಷ್ಟೇ.
Then all other things will not be necessary.
And issue number 6 is the relevant issue. It has been decided against him.
I'll come to that, sir.
Partition, ಮೊದಲಿನ partition suit not decided on merits.
That is true. Dismissed for default. Now the party, according to the governments in the plaint earlier suit, the partition is refused. Limitation is 12 years.
Provided the severance of status has happened and division of estate has happened.
Or ouster.
Or ouster should happen. These are the 3.
Kindly look at page
Raghvacharya
191.
decides.
Page 191.
Yeah.
That's the reasoning given.
Anyway, we'll come, we will not disturb him. Yeah, in his way, let him proceed.
And then, see,
Only
according to the allegations in the plaint.
First point is on limited. Suit is time barred antana.
Time bar.
Okay, I'll ಬರ್ಕೊಳ್ಳಪ್ಪ.
Because
Mr. Surana appearing for the appellants who happened to be the defendants in the court below submits that. The first suit in OS number 7127/1990 having been dismissed for non-prosecution. The second suit founded on the same cause of action is time barred.
Now in first suit, see the cause of action.
SP Shankar, present senior advocate appearing for the plaintiffs animo. Respondent plaintiffs repels the contention, contending that as long as properties are held in joint, or as long as none is excluded, ousted from the possession, comma, the right to seek partition will have a continuing cause of action,
Recurring cause of action.
recurring cause
Very
of
well.
action. Correct, you are
Now
right.
kindly see,
Not continuing, recurring cause of action. You are right.
in para 7 of the plaint in the earlier suit, at 479,
ಅಲ್ಲಿ ಒಂದು ಸೆಕೆಂಡ್ ಕೇಳ್ಬೇಕು, ಸ್ವಲ್ಪ ಕೆಳಗಡೆ ಬರ್ಬೇಕು. Mr. Surana submits that item number 1 in earlier suit, namely land in survey number 29/2 capital A is nothing but the land in survey number 37, which figures as item number
1 in the present suit.
1 in the suit in OS number 7702 of 2004. First,
Kindly see paragraph 7.
1 second. He concedes that the extent of the farmer is shown to be 10 acres plus, whereas that in the later is shown to be 7 acre plus. Correct? 7 acre plus. First off. He also concedes that, he adds that the boundaries of this property, both in the earlier suit and in the later, substantially tally with each other. First, however, we notice that one of the boundaries varies, namely, it says one schedule says Kere and the other says government land, government property in Sarkarada Sutta, government land.
Limitation will. Limitation.
All right.
Now kindly see the averments in para 7
Para 7.
of at page 479. Adala, idhar limit.
479.
9. Idhar limitation. Yaka hing ಮಾಡಿದ್ದೀರಿ? ಎಲ್ಲ deal space ಇದೆ. Well, idhar limitation is right. The plaintiff further submits that after death of their father, they could not live with the defendants in
joint family.
jointly. They could not live with the defendant in joint family. They are not in a position to tolerate the mismanagement and harassment of the first defendant. They demanded for partition of the scheduled properties among themselves, but the first defendant went on postponing the partition on some other pretext. Finally, defendant stated that he is not going to effect any division of the scheduled properties, as he is the only person who protected and safeguarded scheduled properties by paying kandayam and other things. Thereafter, second plaintiff got issued a legal notice dated 21/11/90 to the defendant to the notice served on so-and-so date. The first defendant neither replied nor partitioned the scheduled property. The plaintiff are entitled to their half share in the scheduled properties, which are jointly.
ಯಾಕೆ ಇದನ್ನ ಗೊತ್ತಾ ಇದೆ ಯಾವ ಕಾರಣಕ್ಕೆ?
ಕಾರಣಕ್ಕೆ ಅಂತಂದ್ರೆ, see, there is a refusal to partition the property is the government.
He denied, he said, no, I am the only person who will protect the family property ಅಂತ ಹೇಳ್ತಾನೆ. ಅನ್ಕೊಂಡು they refused to partition. They had sought for partition. He did not agree with that.
So therefore, there is a refusal to partition among the parties which has come up in the way of in 1990 itself.
So it is time barred anta nimdu.
Therefore, the limitation starts from that.
From the date of refusal to
Refusal,
partition.
refusal to partition.
Barkali. Mr. Surana next draws our attention to averments in para 7 of the plaint, which is at the page 477 of volume 1. Volume 1, 3.
Volume 3.
Volume 3. That the respondent plaintiff had sought for partition of property and the appellant defendants had refused to partition it, stating that it is only he who can protect the family property. Correct? First, therefore, Surana adds that the second suit was time barred.
I rely upon 2004 to.
In support of this
Refuted,
contention.
declined.
Huh?
That word here.
Refused.
Declined.
No, already, finally, the defendant stated that it is not going to affect, declination. This seems.
Not going to
declining,
affect is
declining,
refusal.
Not refute.
I am
Refuted
not
ಅಂದ್ರೆ-
going to, I am not going to partition means refusal only. Kolkata, CWC 35606
Stop there, yeah.
says this that way.
I rely upon 2004-12
In
SCC.
support of his contention, he banks upon 2004-12 SCC
SCC, page 754, 754,
754 paragraph
paragraph 22.
20.
ಇದೆಯಾ?
All right.
ಹಾಕಿದೆ, pin
All
ಹಾಕಿದೆ.
right. ನಾಳೆ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ.
ಆಯ್ತು.
ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಯಾವ್ದಿದ್ರಿ? ಎಷ್ಟು ಗಂಟೆಗೆ ಇಟ್ಕೋಬೇಕು? ಮಧ್ಯಾಹ್ನ ಬಂದ್ಬಿಡಿ.
ಆಗ್ಬೋದು.
ಅಷ್ಟು ನೋಟ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
I'm sorry, my attention he
No, no,
drew,
it's
my
all
friend.
right. He also take liberty.
ಅಲ್ಲ, ನಾನು, I'm here not to listen to the, that's, say that I will not listen to the court.
ಹಂಗಲ್ಲ, ನಾನು ನಿಮ್ಮನ್ನ ಡಿಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಬೇಕಿತ್ತು. ಯು ಆರ್ ಫೈರಿಂಗ್ ಯುವರ್ ಕಲೀಗ್.
ಅಲ್ಲ, ಅವರು ಹೇಳ್ತಾರೆ, ಇವ್ರು ಹೇಳ್ತಾರೆ, so my attention went that side.
Don't mistake us also.
ಅಲ್ಲ, I am not.
We never bear all these things.
Yes, yes.
We forget it in seconds.
ಕೊಡಿ ಅದು, judgment ಕೊಡಿ ಅವ್ರಿಗೆ.
ಇವೆಲ್ಲ ರಿಲೇ ಆಗೋದಿಲ್ಲ, ಕೊಡಿ, ನಾವು ಕೊಟ್ಟು
Surana, your first ground is time barred. Second one is?
Second ground is these properties were never in the joint family. Chinnappa has sold the property in 1955. 51. And after 30 years, Gopal Reddy purchased 6 acres of land.
ಅದೇ ಪ್ರಾಪರ್ಟಿನೇ.
ಅದೇ ಪ್ರಾಪರ್ಟಿನ 6 ಎಕರೆ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡ್ತೀವಿ. After 30 years. ಆಮೇಲೆ this plaintiff's father, out of 10 acres, 20 gunttas of land, plaintiff's father has sold 3 acre and 16 gunttas of land and 2 sale deeds.
So no property was available for partition.
The sale deeds were registered. They are produced before the court.
Okay.
The trial court don't want to believe it.
Sale didn't believe ಮಾಡ್ಲಿಲ್ವಾ?
On the ground that the vendor is mentioned as Krishnappa, not Krishna Reddy.
ಕೃಷ್ಣ ರೆಡ್ಡಿ ಮತ್ತು ಕೃಷ್ಣಪ್ಪ ಬೇರೆ ಬೇರೆ ಅಂತ
ಇಲ್ಲ.
ಅಲ್ಲ, ಹೋಲ್ಗಿಂಗ್ ಕೋರ್ಟ್ ಹೋಗಿದ್ದು.
ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಪ್ಯಾರಾ 12 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, Krishna Reddy Krishnappa is the vendor, Krishna Reddy is not the vendor. In para 12 of the judgment.
Okay.
But in the evidence, PW admits that my father was also called as Krishnappa.
Was also called as Krishnappa.
Krishnappa.
And ಅಷ್ಟಕ್ಕೆ ನಿಂತರ ಅಥವಾ ಆ ಕೃಷ್ಣಪ್ಪ ಮತ್ತು ಈ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಒಂದೇ ಅನ್ಕೊಂಡೆ ಏನಾರ ಮುಂದೆ ಹೇಳಿದ?
ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Because Krishnappa is described as son of Chikka Chinnanna.
Krishna Reddy is son of
Chikka Chinnanna, that is his father.
father. Nanjundappa's son.
Nanjundappa is grandfather.
Grandfather.
Great grandfather.
He is father of Chinnappa Reddy.
Yes.
That's right.
Chinnappa Reddy's son is Krishna Reddy. Krishnappa. He is also called as Krishnappa. While excluding the sale deed, he mentions it Krishnappa. From thereafter, 3 acres of land have changed hands and constructions have come up.
That court did not believe anta.
Court simply rejected, saying that the vendor is shown as Krishnappa, not Krishna Reddy. That's all. But the sale deeds are there, properties has gone, imputation is affected. And
our father's ಹೆಸರು ಏನು ತೋರ್ಸ್ಯಾರ?
Father 55, Chinnappa sells 10 acre, entire 6 acre of the land Chinnappa in 1955 itself.
ಅಲ್ರಿ, ನಮ್ಮ ಪ್ರಶ್ನೆ ಏನಪ್ಪಾ?
ಚಿನ್ನಯ್ಯ.
ತಂದೆಯ ಹೆಸರನ್ನು ಏನು ತೋರಿಸಿದ್ದಾರೆ?
ಚಿನ್ನಯ್ಯ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಯಾಕೆ ನಿಂತ್ಕೊಂಡಾರ ನಿಮ್ ಕ್ಲೈಂಟ್? ಹಿಂದ್ಗಡೆ ಕಳ್ಸವ್ರು, ಹೋಗಿ ಹಿಂದ್ಗಡೆ.
ಚಿನ್ನಯ್ಯ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ವೈ ಆರ್ ಯು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಹಿಯರ್? Go back.
His father's name is shown as Chinnaya.
Huh?
Chinnaya.
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 Father's name correct ಇದೆಯಾ?
Correct ಇದೆ. ನಾಳೆ ತೋರಿಸ್ತೀನಿ ಅದೆಲ್ಲ. Tomorrow I'll point out.
ಹಂಗಾಗಿ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ ಇದು ಅಲ್ಲಿ ಬರುವಂತದ್ದಲ್ಲ, ಸೆಲ್ಫ್ ಎಕ್ವಿಜಿಷನ್ ಆಗತ್ತೆ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್. ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಆಗಲ್ಲ ಅಂತ.
ಆಯ್ತಲ್ಲ. In the plaint or in evidence, nowhere says that this was purchased out of nucleus.
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದಾಗ ವಯಸ್ಸು ಎಷ್ಟಿತ್ತು?
ವಯಸ್ಸು 34 or 35 years.
Discuss ಆಗಿದೆ.
ಇನ್ಕಮ್ ಏನಿತ್ತು?
ಎಲ್ಲ ಆಗಿದೆ, discuss ಆಗಿದೆ.
ಇದೆ discuss. Yes.
She wants financial assistance.
Huh?
She wants financial assistance from her brothers.
ಅಲ್ಲ ಕೊಡಿ perfect.
For, he doesn't want it either from bar or bench, my lord, from her brothers. So a direction may be issued to the DGIG, that is what she's seeking. I don't mind calling from our office, my lord.
ಅದು ಕರೆಸಿ
ಹಾ.
ನೋಡಿ ಏನ್ ಅನ್ಯಾಯ ಆಗಿದೆ ಅನ್ಕೊಂಡವ್ರು ಏನೋ
Yes, my lord, I'll call.
ಕಾರಣ ಇಲ್ದಂಗ್ ಬರಲ್ಲ. Nobody comes to court without a reason. Just sit and help her.
Yes,
Appears-
I'll instruct
appears to be
DGIG from our office.
ನೋಡಿ ಅವ್ರನ್ನ ತೋರಿಸಿದೇವೆ ಈಗ. ನೋಡ್ಕೊಳ್ಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ನೋಡಿ. Please help her.
I'll call from her.
Serial number 41, madam.
ಹಾ.
41.
ಹಾ?
41, serial number 41 ಅಲ್ಲಿ
ಹಾ.
45512 ಅಲ್ಲಿ ಕೊಟ್ಬಿಡು. R2 to R3 ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಅಲ್ಲೇ ಮೈಕಿ ಬನ್ನಿ.
ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ ಅಂತ ಇದೆ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, R2 and R3 ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಹಾ.
ಅದು ಡಿಲೀಟ್ ಆಗಿ ವೆಂಕಟೇಶ ಸರ್ಬಟ್ಟಿ ಅಂತ ಆಗ್ಬೇಕು ಮೈ ಲಾರ್ಡ್ಶಿಪ್. He is appearing.
ಯಾವ್ದೋ ಒಂದು ವೆಂಕಟೇಶ್ ಅರ್ಬಟ್ಟಿ ಅಂತ ನೋಡ್ರಿ.
Serial number 42.
42.
Pension, my lord, 2013 retired. One date may be given, my lord, may I request.
4 weeks ಆಗಿದೆಯಾ? ಈಗ ಆಗಿದೆ ಅಂತ ಸತೀಶ್ ಅದು. 4 weeks ಆಗಿದೆ, ಸ್ಟೇ ಇದೆ ಅಂತಿರು.
ಆಯ್ತು ಸರ್, ಆಗ್ಬೋದು.
ಕನೆಕ್ಟಿಂಗ್ ಮ್ಯಾಟರ್ ಇದೆ. ಬರೀ 45512 ಮಾತ್ರ R2 R3 ವೆಂಕಟೇಶ ಸರ್ಬಟ್ಟಿ ಅಂತ ಆಗ್ಬೇಕು. ಕನೆಕ್ಟಿಂಗ್ ಮ್ಯಾಟರ್ ಸರ್, ಕನೆಕ್ಟಿಂಗ್ ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ 74, I think ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ ಅಂತ ಇರಬೇಕು. ಬಟ್ ಅದನ್ನು ಮಾತ್ರ 45512 ಮಾತ್ರ ಆಗ್ತದೆ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
The 42nd date. ಹೌದಾ?
Serial number 39. Sir, serial number 39. Sir. 3 weeks. Sir. Oh.
ಅದೇ ಈಗ ಹೋಗ್ಲಿ ಅರ್ಜೆಂಟ್ ಇಲ್ಲ ಅರ್ಬಟ್ ಹೆಸರು ಹಾಕಿ ಆಕ್ಚುಲಿ ನಾನು ಮಿಸ್ಟೇಕ್ ಆಗಿ ನಮ್ಮ ಕೊಲಿಗ್ ಲಾಸ್ಟ್ ನಮ್ಮ ಹೆಸರು ತೋರಿಸಿದ್ದು ಅದು ಅರ್ಬಟ್ ಹೆಸರು ತೋರಿಸ್ಬಿಡಿ ಹೇಳ್ರಲ್ಲ ಆಯ್ತಾ ಯಾಕಂದ್ರೆ ಫೈಲ್ ಇಲ್ಲ ನಾನು ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿದ್ದಾರೆ ಅದಕ್ಕೆ ಓಕೆ ಕೇಳಿದ್ರೆ ಇಲ್ಲ ಅಲ್ಲ ನಾವಿಲ್ಲ ಅಂತ ಅದೇ ವಿಶೇಷ ಬೇರೆ ಸರಿ ಬರಲಾ ಅಲ್ಲಿತ್ತು 7 ಅಲ್ಲಿದ್ದೆ ಹಂಗೆಲ್ಲ